Hello, hello.
Good morning, Court Master Sahab. Am I audible? Good morning, Court Master Sahab. This is Inspector Vijay Paul from Delhi Police. Am I audible, sir?
Yes, sir, you're audible.
Thank you, ma'am. Actually, I am appearing in list 2, serial number 31, item number is 31. So
Yes, sir.
kindly mark my appearance also. I will appear
Yes,
through VC.
yes, sir.
Thank you.
Right. Turkey.
Nigeria.
Oh, Nigeria. All right. Give it ತೊಂದ್ರೆ ಇಲ್ಲ. National integrity ಏನಿದೆ ನೋಡಿ.
ಅಲ್ಲ, because I filed for the application and vacating.
Yes, vacating state will get listed.
Covered by judgment.
Why are you here? Come this side. Neeway don't violate the norms, unwritten norms. Yes.
Madam,
500 crores is
Give it, sir.
for ED, my lords.
Hey, give it.
Staff matter. My request for
Fresh
tomorrow.
matter.
And this
500 crores seized.
500 crores, my lords, been frozen by ED in the gains draft matter, my lords. Hence, I'm requesting for tomorrow.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
Not subsequently after the arrest,
No
they
problem.
would freeze
Give
the
it.
account to the tune of 526 crores.
Tuesday. Fresh matter.
Fresh matter. my lords.
Tuesday.
I request for Monday at least.
No, sir. Monday, I'm not likely to sit, so Tuesday. Yes.
my lord, covered by judgment, my lord.
ಕೊಡಿ ಸರ್ ಎಲ್ಲ.
My lord,
ಎಲ್ಲ ಕೊಡಿ ಸರ್.
No stay, my lord. in this.
No stay.
Stay
ಪರವಾಗಿಲ್ಲ
ಇಲ್ಲ.
ಕೊಡಿ ಸರ್.
My lord,
NDPS matter, my lord, Santosh Hospital, my lord.
ಅದು ಕೊಡಿ. ಸಂತೋಷ್ ಹಾಸ್ಪಿಟಲ್. ನನ್ ಮುಂದೆ 5 ವರ್ಷ ಆಗಿದೆಯಾ?
Bye, sir.
20 ನಾನು 480 ಕೂತಿದ್ದೆ 22.
22 matters.
ಸುಮ್ಮನೆ ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್. I'll release it from part. Let it go before the bench having roster.
I'm sorry, my lord.
ಅದು ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಮೇಡಮ್, will release it from part.
22 matters.
No problem sir. It will go 22 ಇನ್ನೊಬ್ರು ಜಡ್ಜ್ ಇದಾರಲ್ಲ, ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಬಿಡಿ.
I'm sorry, my lord. This is the 5th year.
ಅದು ಪರವಾಗಿಲ್ಲ ಸರ್.
I'm sorry.
No problem. It let it go before the other court. It will dispose it immediately.
ತಂದೆ covered.
ಪರವಾಗಿಲ್ಲ ಸರ್, ಅಲ್ಲೇ ತೋರಿಸ್ಬಿಡಿ.
Sorry, my lord.
ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಮೇಡಮ್.
I'm sorry.
We'll release it from part.
the-
I'm sorry.
Yes.
but
My lord, also in another matter, my lords were directed that the final report will not be filed without my lord's leave. They filed the B report before the magistrate without a notice to the complainant, my lord.
No, ಪರವಾಗಿಲ್ಲ.
Or protest petition ಇವಾಗ ಹಾಕೊಂಡಿದ್ದಾರೆ.
We'll see. Yes.
That may also.
my lord, covered by.
It will come. ಕೊಡಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಕೊಡಿ.
Sir,
How long will you move the memos? ಕೊಡಿ sir, please fast. ಎಲ್ಲ ಕೊಡಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. No problem, give
my
it.
lord, covered by judgment. my lord.
ಎಲ್ಲ ಕೊಡಿ. ಕವರ್ಡ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಟ್ಯೂಸ್ಡೇ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಬರುತ್ತೆ, ಮಿಕ್ಕಿದ ವೆಡ್ನೆಸ್ಡೇ ಪರವಾಗಿಲ್ಲ, ಹೆಂಗಿದ್ರು ಪರವಾಗಿಲ್ಲ.
ಪ್ರಾಕ್ಟಿಸಿಂಗ್ ಅಡ್ವೊಕೇಟ್ ಇವರ
ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಕೊಡಿ.
My lord, covered by judgment.
Tomorrow.
ನೋ ಸರ್, ನೋ ಟುಮಾರೋ ಯಾವ್ದು ಕೇಳಲೇಬೇಡಿ ಸರ್, ಅನ್ಲೆಸ್ ಅರೆಸ್ಟ್ ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಮಾತ್ರ.
ಸರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸರ್, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಮಂಡೇ
ಕೊಡಿ ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು
My lord, pending matter.
ಪೆಂಡಿಂಗ್ ಮಾಡಿ
ಕೊಡಿ ಸರ್, ಎಲ್ಲ ಕೊಡಿ.
Similar case is already.
Maybe sir, give it sir, give all the pending matters. If you want to give the memos. Yeah, now stop. Yes. Stop. ಮೆಮೊ ಕೊಡೋದು ಕೊಟ್ಬಿಡಿ, ಯಾವ್ದು ಇನ್ ಕೇಳಲ್ಲ ನಾನು. Vacating, you're for the complainant. Next week ಹಾಕಿ ಮೇಡಮ್.
I'm seeking for 230 minutes. There is a threat of arrest, my lord.
Why?
Advocate has lodged a complaint, my lord.
Ah.
The plaintiff, he is a defendant in the suit, my lord.
Ah.
There is a verbal conversation in the mobile.
Why are you standing this side? Mister.
There is a verbal conversation, there is a threat of arrest, my lord. There is 230.
Right. Threat of arrest in the court.
My lord.
Hey, wait, ಯಾಕೆ? ಕೊಡಿ, when do you want settlement? Give it. Why are you jumping? Wait, madam. I will take wait. Yes.
7A matter, my lord, your lordship can have it in the second with all the other matters.
Yes, 7, ಕೊಡಿ. 7 is 17th, second ಹಾಕಿ madam.
My lord, it was posted during vacation but didn't reach due.
Can't help madam. Give it, yes.
Kindly fresh matter.
No, give it, yes.
My lord, vacating the interim order, my lord.
Vacating it.
Yesterday I had moved matter.
Am I not listening here? ನಿಮ್ದೆಲ್ಲ ಆಗೋಯ್ತು, ಕೊಟ್ಬಿಡಿ. ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಟ್ಟು ಹೋಗ್ತಾ ಇರಿ. ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, ಬರ್ದ್ ಕೊಡಿ ಯಾವ್ದಕ್ಕೆ.
My lord.
ಎಲ್ಲ ಬರ್ದ್ ಕೊಟ್ಬಿಡಿ ಸರ್. ನಾನು ಮಾಡಲ್ಲ ಅಂತ ಹೇಳದ್ನ, ಬರುತ್ತೆ ಕೊಡಿ. Give it.
230 list.
You want settlement?
Yes.
Madam, 230 settlement ತಗೊಳ್ಳಿ.
230 list.
Yes.
My lords, in this matter, my lords,
ಕೊಡಿ, ಮೆಮೋಸ್ ಕೊಡಿ.
in this matter, a student is roped in for violation of 144. His career is at stake, my lords. He has to fly back this Friday.
Friday?
Please, my lords.
For what?
He studies there as well as he's a faculty also.
230
Please, grateful.
My
sir.
leaking speedy disposal.
ಕೊಡಿ. Spirit disposal Monday Tuesday ಹಾಕಿ ಮಾಡಿ. I am not sitting here.
Please, reporting settlement.
ಕೊಡಿ, ಯಾವಾಗ ಬೇಕು?
Tomorrow, madam. ಕೊಡ್ತೀರಿ.
ಆಯ್ತು ಕೊಡಿ. ಹಾ.
Against parents.
Fresh matter. Give it.
My lord, settle.
No interim order against parents? How come? It had come before me? Then give it, will see.
My lords,
Settlement.
It will come. No interim order cases will come, yes.
Settlement, my lords, 230.
230 settlement.
My
ತಗೊಳ್ಳಿ
lords.
madam.
This is 498A against in-law, my lord, mother-in-law. It's a pending matter. There's no interim order, my lord. It is
Other
posted in
mother-in-law
trial.
has committed some mistake.
No, my lords, it came before some other bench. That day did not reach.
Not mother-in-law friendly bench.
My lord,
Kodi.
I'm appearing in
It is
person.
posted in trial court on 26, my
It will
lord.
come, madam. Yes.
My
give
lord,
it.
case of vacating states, a forgery case.
Ah.
Signature.
Give the memo.
My lords, if a date.
No, madam. Yes. Every day vacating stays are coming. Your turn also will come. Withdrawal 230 Tholi, madam.
My lord, appearing in person, my lord. The allegation on me is that I've assaulted my mother-in-law. And this is a fresh matter. And there's one more case where my mother-in-law has taken a stay from this court in my.
So you want it to be
498.
vacated, is it?
Vacated
I will not
is-
vacate that.
My lord, can this be taken up?
We'll see. Yes, Kodi.
Lords, this matter is posted on trial court on 26 for framing of charges, my lord. Kindly
ಆಯ್ತು
make
ಅದು ನಾಳೆಗಾಗಲ್ಲಮ್ಮ
25th.
25th. No, tomorrow is 25th. Take an adjournment there. It will come 20 Wednesday or Thursday. Yes.
My lords, the
Grateful,
accused in my matter has evaded our summons 6 times, my lords. I
No
appeal
problem.
for
Give
bail.
it. Give it fast. Vacating stay. Give it. Yes. Wait. ನಿಮ್ದೆಲ್ಲ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ. ಆಯ್ತು ಒಂದೇ ಸರಿ ಅಷ್ಟೇ. ಕೊಡಿ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನಿದೆ ಎಲ್ಲ ಕೊಡಿ. Give. ಹಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಸ್ಟೇ ಇದೆಯಾ? ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತೀನಿ? ಓ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಆಯ್ತು ಅದು ಹಾಕಿ. ಅದು ಮದುವೆದು ಯಾವ್ದು ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ಯಾವತ್ತರ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಹಿಯರಿಂಗ್ ಎನಿಥಿಂಗ್. ಗಿವ್ ಆಲ್ ಮೆಮೊಸ್.
With my lord's kind permission.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಎಲ್ಲಕ್ಕೆ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ.
My lords, 498
ಎಲ್ಲ ಕೊಡಿ ಸರ್. ಅಯ್ಯೋ ಯಾವ್ದಾರು ಮೆಮೊ ಕೊಡಿ, ಬೇಡ ಅಂತ ಇದೀನ. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್. ಗಿವ್ ಇಟ್. No problem.
Then the husband approaches US court. Now she has started filing cases in India.
No, let her start, sir. So what? Yes. Kodi.
My lords,
Illegal arrest, Your
give.
Honor.
498 case.
Give all the cases. Fresh matter.
Yes.
Fresh, right?
Fresh case.
Your lordships.
So it came up during the vacation, and the next date is the 1st of July. Charge has been framed. Father-in-law has subacute.
Charge has been framed.
Please.
Go
Which is-
approach
my
this.
lords, father-in-law
I'm
has
not
a
going to interfere.
subacute.
Your lordships,
No,
tomorrow
I'm not going to interfere.
Two
On
months.
whatever ground, I'm not going to interfere there.
So,
Yes.
yes.
Charge frame admele, I'm not going to interfere, madam. It's been exercise in futility.
It's for charge.
It will be an exercise in futility. Yes.
Illegal
Lordships,
arrest.
it's for charge tomorrow.
Tomorrow,
Tomorrow it's for charge, your lordships.
for charge
Kindly
ಅಂದ್ರೆ
take
ಏನು?
up. Trial court matter charge ಇದೆ.
ಏನ್ charge ಗೆ ಅಂದ್ರೆ ಏನು?
Again charge, your lordships.
Plea ತಾನೆ.
ಹೌದು.
ಆಯ್ತು ತೊಂದ್ರೆ
It's
ಇಲ್ಲ
for
ಮಾಡಿ.
a year, your
No
lordships.
problem. Give it. Yes.
Kindly take
ಏನ್ ಚಾರ್ಜ್ ನಾಳೆ ಫ್ರೇಮ್ ಆಗಲ್ಲ ಕೊಡಿ. Give it, sir. No problem, sir. Give it.
Kindly take it up tomorrow.
No,
your lordships.
give it. Yes.
Connected matter.
No date, sir. Please give all the memos.
Connected matter.
Please give all the memos. Monday, Tuesday, I've already posted 300. Beyond that, I can't. Please. Give.
1/7 ke hearing.
No. Yes. Give the memos, please.
Illegal arrest, Your Honor.
Please give the memos.
Illegal arrest,
No
230.
problem. Give it. Yes.
Illa.
You are out on bail now.
No,
You're
I'm not.
Then you're still in custody.
Yes, I'm still in custody.
230
Illegal
ತಗೊಳ್ಳಿ.
arrest, 230.
Yes.
Vacating stay, my lord.
Give.
Previous injuries have been caused to the complaint.
Please give it. Don't finish all the courts and come here to go a memo because I'll be taking memo up to 11 o'clock. Don't do that. Please give. Please give and go. Yes. No submission on memos. Please give. Give the memo and move. Yes. Nothing. Memo ಕೊಡಿ. Memo ಕೊಟ್ಬಿಡಿ. Maybe, sir. Give the memos. No problem. Give it. Give it. No submissions. Give it. Yes. Give the memo.
Lordship,
ಆಯ್ತು ಅರ್ಜೆಂಟ್ ಮಾಡಿ.
Lordship, I may be
All the
permitted.
cases, madam. Yes. No mentions. Please give the memos. Yes.
My lord,
I may be permitted to mention.
No. Yes.
Serial number 133.
You want to withdraw itre matra.
No, 130.
Policy matter, my lords, your lordship.
My lordship, may kindly.
I'll take it at 2:30, sir.
One,
We'll convey that to the learned AG.
at 2:30. my lord.
Sorry?
Take it up at 2:30.
I am going to take it up at 2:30.
Problem.
Yes. No problem. Go call the cases. Yes.
This one fresh matter, still
Give the memos and move. Yes. Who is this? Criminal petition. Serial number 1. Janna Keshava.
Keshava BS.
Yes.
That's the purely civil dispute, my lords.
where the complainant says the property originally belonged to his grandfather.
You are accused number 8.
Yes, my lord.
All a matter of evidence. 1 HCGP 2 emergent notice.
Lords,
No,
may,
sir.
may I also say, my lord?
3 ವರ್ಷದಿಂದ ಸುಮ್ನೆ ಇದ್ದೀರಾ, ಈಗ ಸ್ಟೇ ಬೇಕಾ?
There is another stay already.
ಆಫೀಸ್
operating.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ 2 ವರ್ಷ ಬೇಕು.
There is
ಈಗ
already
ಅರ್ಜೆನ್ಸಿ
an-
ಸ್ಟೇ.
No, my only submission, my lords, is in this honorable court has stayed the proceedings in so far as in another matter, my lords.
Which is another matter.
No, criminal
Which accused?
for,
Which
for
accused?
3 and 4.
Kodi. Tag along with so and so. Same order. List them both on 14 July. Yes. But why do you take 2 years to comply with the office objection?
Lords,
What sort of carelessness is this? Yes.
Bill number 2.
No, there are a series of civil disputes between both the
Pund
parties.
certificate ಅಲ್ಲಿ. Pund certificate.
My lord, I have to get it. Date may be given.
You have to get it. Get it.
because-
Even evidence started.
That frame ಆಗಿದೆಯಾ? ಮೀನಾಕ್ಷಿ ಬಾಲ. ಎಲ್ಲ all contentions ಅಲ್ಲೇ. 2 ವರ್ಷ ಪೆಟಿಷನ್ ಹಿಂಗೆ ಇಟ್ಕೊಂಡ್ರೆ ಅದೇ ಆಗುತ್ತೆ.
No,
Petition
party was
ಯಾವಾಗ
not,
ಆಗಿದೆ?
party was not cooperative.
Party was not cooperating. Let him cooperate with the trial there. Yes. Charge ಯಾವಾಗ frame? After filing the petition, before filing the?
After filing of the petition.
Yes. 1 HCGP 2 emergent notice. Yes, next.
3.
Really pass out the matter.
No pass. 1 HCGP. No, no, this has to be dismissed only straight. See
Notice.
page
Friendly
24.
notice the man.
Huh?
Friendly
Bada,
notice.
bada, notice. Yes. Go to page 24, sir. Horrible allegations. File discharge and come back to the court.
$57 lakhs 12,000. 57 lakhs 12,000.
Page 24, sir, the allegation against you is this.
Yes,
ಒಂದು
ma'am.
ಬ್ಯಾಂಕಲ್ಲಿ ಲೋನ್ ತಗೊಂಡು ಎಷ್ಟು ಕಡೆ ಮಾಡಿದ್ದೀರಾ? The petitioner, ಇಬ್ರಾ ಒಬ್ರಾ?
ಒಬ್ರು ಅಷ್ಟೇ.
The petitioner accused number 1 is before the court calling in question proceedings in CC 10124 of 2023. The petitioner remains as the sole accused pursuant to the investigation and filing of the charge sheet by the by
FIR ಆಗಿರೋದು ಇಬ್ಬರ ಮೇಲೆ,
ಹಾ.
ಇಲ್ಲಿ ನಾವು ಹಾಕಿರೋದು ಒಬ್ಬರಿಗೆ ಅಷ್ಟೇ.
ಇಬ್ರಿದಾರ? So and so. The State Bank of India is the complainant. Registers a PCR in PCR 1838 of 2018 for several offences. The fulcrum of the offence lies in paragraph 8 of the complaint, which reads as follows. The allegation is that the accused, with an intention to play fraud, have created documents fabricating, forging the signatures of various officials, including the sub-registrar, to avail a loan in the complainant bank, i.e. the State Bank of India, of to the tune of 57,12,000. Accused 1 and 2 have indulged in the said act of creating documents and defraud the complainant bank. Therefore, the complaint is registered. The police, after investigation, have filed a charge sheet. The summary, the charge sheet.
Page number 109. 109.
109 ಅಲ್ಲ. The summary of the charge sheet as obtaining in column number 17 reads as follows. Page 1192, 120. ಏನ್ ಬೇಡ. The summary of the charge sheet of the allegations against the petitioner are further glorified by drawing 7 pages, of the acts that are committed by the petitioner. In such circumstances, all the contentions that are advanced by the petitioner to contend that it is a matter which is purely civil in nature is on the face of it unacceptable. Therefore, reserving liberty to the petitioner to avail of such remedy as is available in law, the petition stands disposed. Rejected. Yes, next.
4.
OC Matka,
OC Matka.
Kodi, disposed. Next.
Much obligement.
5.
In the meantime, next.
Appear for the petition in this matter.
Bill number 6.
PB proceed. 5 or 6?
5.
5 I stayed. Next. ರಿವಿಷನ್ ಏನಾಗಿದೆ?
ಡಿವಿಷನ್ ಹಲವಾಗಿದೆ ಸರ್.
ಅದು ಏನು ಮೇಂಟೆನೆನ್ಸ್
ಹೌದು ಸರ್.
ಎಷ್ಟು?
5,000.
ಹಾ?
ಮಂತ್ಲಿ 5,000.
ಮಂತ್ಲಿ 5,000. 5,000.
ಹೌದು ಸರ್.
Emergent notice to the respondent, first respondent husband, there shall be an interim order of stay of the order in revision till the next date of hearing. Next.
7.
For petition. 306 your lordship.
Death note idya?
ಇದೆ.
Death note is
Ah.
Father, the
So-
husband was the second death your lordship. The wife and your lordship. Parents your lordship. It's 2 and 3 your lordship.
Who died?
Husband. Wife is
You are the wife, accused number 1.
Accused number 1, wife, and 2 and 3 are the parents.
Parents will stay. Death note ಅಲ್ಲಿ ಏನಿದೆ?
ಇಲ್ಲ, ಪೇರೆಂಟ್ಸ್ ಹೆಸರು ಇದೆ, ತಂದೆ ತಾಯಿ.
ಹೆಸರಿರುತ್ತೆ, ಕೊಡಿ ಇಲ್ಲಿ ನೋಡಿ.
Except one sentence your lordship, then page number 95 your lordship.
ಇಂದಾಗಿ.
95.
Wife definitely we will not stay.
One sentence.
The petitioners are accused 1, 2 and 3. The wife, mother-in-law and father-in-law of the deceased husband of the accused number 1. A perusal at the summary of the charge sheet would indicate all the allegations of abetment, goading or instigation against the wife accused number 1 for having abetted the suicide of the husband. Insofar as the mother-in-law and father-in-law of the husband, deceased husband is the husband is concerned, except sprinkling few allegations, there are nothing that would indicate any goading or instigation that could become the ingredients of section 107 of the IPC for it to become an offense under section 306, permitting further proceedings against the mother-in-law and the father-in-law. The petitioners 2 and 3 hyphen accused 2 and 3 would run foul of the judgment of the apex court in the case of Yadvinder Yadav, 2025, SSC online SC page 2332. Insofar as the first petitioner accused number 1 is concerned, further proceedings shall continue. Yes.
Please.
8.
Petitioner requesting for a password.
ಇದರಲ್ಲ ಏನ್ ಬಂದೇನ್ ಮಾಡ್ತಾರೆ? ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇದಲ್ಲ.
ಮತ್ತೆ ಎಸ್ 1 HCGP 2 emergent notice. Next.
9.
My lord, the counsel for the petitioner in this case, my lord. My lord, senior is out of town, my lord. Kindly have it.
List after 8 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
10.
Appearing for petitioners, my lord. 2 and 3 are parents, my lord.
2 and 3, husband no stay. Husband is accused number 1, no stay. 2 and 3, yes. 85. Dispensation allow ಮಾಡ್ಬಿಡಿ. ಏನ್ dispensation? ಅನಿಲ್, dispensation ಏನು?
Order sheet, my lords.
ಯಾಕೆ ಹಾಕಿಲ್ವಾ?
I applied for the order sheet. It takes time, my lords.
Why? You should have made something.
No, my lord,
About
4
delay.
weeks time.
ಸರಿ ಆಯ್ತು.
11.
Paying for the petition.
2 to 8, 85, JY. Husband ಗಿಲ್ಲ, 1 no stay.
12.
Yes, sir.
Property dispute, complaint, counter complaint. I have succeeded in a litigation that went on since 1995, ultimately culminating in this court's order in RFA. Supreme Court also confirms that. I go for fencing my own property. They oppose. There is some incident.
But the land senior counsel, Dhananjay Joshi, in the meantime, 1 HCGP 2 emergent notice. Next.
13.
ಕೇಳಿಸಿಲ್ಲ.
13.
The petitioner.
No injuries.
No injury.
No external, simple ಅಲ್ಲ. Go to page 54 ಏನದು?
54, my lord.
54 wound certificate, no external injuries. 118. In the meantime, next.
Grateful.
14.
Petitioner, my lord. My lord, this is second round litigation by
Which is the earlier crime?
earlier crime, my lord, is page 479 quashed by this honorable court, my lord.
In the meantime, next.
15.
85, 2 to 6. Husband is not before the court.
One submission or handover because tomorrow is posted for the.
ಬರುತ್ತೆ, ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ. ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ.
16.
One HCGP to emergent notice. Next.
17,
Appearing for petitioner, my lord. The petition accused number 93, 97, 98, and 110, my lord. Unnecessary sections.
Unnecessary.
Please, my kindly, my lord.
Accused number 93, 97, 99. One HCGP to emergent notice. Next.
Entry model stay, my lord. Kindly, my lordship, do the.
Burley, yes. Let the learned HCGP look into it.
18,
85, 2 and 3.
19,
The petitioner is accused number 3, finding no allegations or not even an iota of allegation in the summary of the charge sheet. The summary of the charge sheet permitting further proceedings against this accused would run foul of plethora of judgments rendered by the apex court on the issue. Therefore, there shall be an interim order of stay.
Granted stay in crime stage, my lord.
ಈ ಕೊಟ್ಟೇ ದಿನಲ್ಲ ಕೊಟ್ಟನಲ್ಲ ಅಷ್ಟೇ. Yes, next.
20,
Petitioner, my lord.
ನೀವು ಡ್ರೈವರಾ?
I'm not a driver. Why the prosecution has been charge sheeted?
Owner.
I don't know, my lord. Has been charge sheeted for no offense.
ಅದೇ ಯು ಆರ್ ನಾಟ್ ದಿ ಡ್ರೈವರ್
I'm not a driver.
ಇನ್ ದ ಮೇನ್ ಟೈಮ್. ನೆಕ್ಸ್ಟ್.
Crash ಮಾಡೋದು sir.
ಹಾ
Crash ಮಾಡೋದು.
ತುಂಬಾ ಸಂತೋಷ. ಸ್ವಲ್ಪ ದಿನ ಆದ್ಮೇಲೆ ಸ್ಕ್ವಾಶ್ ಅಲ್ಲ ಕ್ವಾಶ್. ಹಾ
21,
ಎಸ್.
Dispensation of notice.
ಡಿಸ್ಪೆನ್ಸ್ ಎಲ್ಲಿದೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್?
Note ಬರ್ರಿ. Note ಹಾಕಿ.
ನಮಗ್ ಗೊತ್ತಿಲ್ಲದೆ ಇರಲ್ಲ ನಿಮಗ್ ಗೊತ್ತಲ್ಲ ಹೆಂಗಿದೆ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಇಲ್ಲಪ್ಪ ಇಲ್ಲಿ.
Cost date ಅಲ್ಲಿ ಬರ್ರಿ.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ. ಹಾ ಎಸ್.
Madam, this is yes. Civil suit.
OS number
I have produced.
ಪ್ರೊಡ್ಯೂಸ್ ಹೇಳ್ಬೇಕು ಇಲ್ಲಿ. OS number ಫಾಸ್ಟ್.
25,642.
ಏನು?
25,642 of 25.
So and so on the same set of facts. Yes. Next.
22,
Accused number 4, my lord, the second first wife complaint against me, man.
The petitioners are before the court calling in question the registration of a crime and crime number so and so. There shall be an interim order of stay only insofar as the offences under the Atrocities Act, qua all the accused. Insofar as the other offences are concerned, there shall be an interim order of stay only insofar as accused number 1 and 3. The other offences shall be investigated into qua the accused number 2 and 4. Yes.
23,
OS number. Rakshita madam.
OS number 562 of 26, my lord.
The atrocity ಇದೆಯಲ್ಲ?
Atrocity.
The petitioner, who has instituted that?
Respondent, my lord, the suit is filed by me.
Yes, the petitioners institute suit in so and so, in which the respondent is the defendant. An interim order of injunction, answering the application of the order 39 rule 1 and 2, an injunction is granted. The complainant violates the order of injunction, and therefore proceedings for contempt is initiated. Immediately thereafter, the complaint has sprung from the hands of the complainant, including the offence under the Atrocities Act. In that light, there shall be an interim order of stay of further proceedings, further investigation.
Covered by your lordship's
ಗೊತ್ತಾಯ್ತು ಬರ್ಬೇಕಲ್ಲ ಕವರ್ಡ್ ಆಗಕ್ಕೆ. ಎಸ್ ಫಾರ್ ದಿ ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕ್ವೇ ದಿ petitioners to the next date of hearing. Yes. In the meantime, next.
25,
24 over, sir. Stayed. Next.
25,
Stayed, sir. ಅಲೋ ಮಾಡ್ಬೇಕಾ ಈಗಲೇ?
ಭಾಷೆ ಆಗ್ಬೋದಾಯ್ತು ಅಂತ
ಭಾಷೆ ಆಗ್ಬೋದಿತ್ತ? ಬಹಳ
ಯಾಕಂದ್ರೆ
ಸಂತೋಷ.
this one is it's not at all maintainable.
ಹೌದಾ?
From 1724 onwards the whole.
ಪರವಾಗಿಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಬರ್ಲಿ. Yes, sir.
25,
Page 46, sir. Attempt to murder will not stay. One HCGP to emergent notice. A2 is not.
For a while. Yes.
Like A2 is not
No.
involved in option. A3 and 4 is already granted.
ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ ಕೊಡು. Yes.
26,
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List on 6th.
Swami, stay, Swami. Either recovery, parallel proceeding, civil case,
ಪರವಾಗಿಲ್ಲ
Swami,
ತೊಂದ್ರೆ ಇಲ್ಲ.
commercial.
List on 6th in the fresh matter list. Get him. Yes.
27,
Wound certificate.
Simple. It is same along with item number 12.
Same. Page number, which is that? Serial number?
Item number 12.
Tag with 12, same order. Yes.
Great.
28,
Petitioner, Your Lordship.
One, HCGP accepts notice, secure the investigation papers and place it before the court on the next date. Sixth, fresh matters.
Your Lordship, entire allegation is against.
No,
case number
118, yes.
Simple injuries.
No, no, papers, per. Yes, next.
59,
The petitioner is the sister-in-law of respondent
Correct.
number 1.
DV proceedings. Emergent notice to the respondent. There shall be an interim order of stay qua the petitioner before of all proceedings. There should be an interim order of stay of the proceedings qua the petitioner before the concerned court. Next. Dispensation allowed.
30,
Before the petitioner.
Copyright Act.
Please, minutes.
One HCGP to emergent note. What is this muscle protein powder? Huh?
Please, minutes.
Adardu
Counterfeit,
problem.
but it was supplied by a sales representative of very same complainant.
We'll see, we'll see. Yes. One HCGP to emergent notice. Next.
31,
Not, sir. Order of stay, minutes.
No, sir.
Please.
Yes, 126 to.
31
In the meantime.
appears for
Next.
the petitioners, my lord.
32 A4 in the meantime. 85. JY.
My lord, 31, my lord.
Stayed, sir. Yes.
33,
In the meantime. Next.
34,
497 503.
Custody of the.
Wait, learned HCGP is directed to accept notice for the respondent. Secure instructions and make submissions. Sixth in the fresh matters list.
Custody.
30,
No, not by way of an interim order.
Of,
Let me hear.
At a Upapet police station.
No problem, sir. Let me hear.
Last 2.5 months.
Case ಬಂದಿರೋದು ಇವಾಗ ತಾನೆ? Wait, yes.
Trial court order was rejected.
ಆಯ್ತು sir. ಇವತ್ತು first time it's coming before me. Wait. Yes.
55,
My lords, own certificate, simple in nature, my lords,
Ah.
page number 75, my lords, purely civil in nature, my lords, kindly peruse. My lords, OAS is also has been filed, my lords. My lords, 118 has
Go
been.
to page 29, sir.
Lords. Counter case has also been filed, my lords.
Stay ಆಗಿದೆಯಾ?
My lords,
Stay
they have
ಆಗಿದೆಯಾ?
not approached before, they have not approached, my lord.
One HCGP to emergent notice.
My lords,
Next.
the
No, sir.
proceedings has been, my lords, 118 has been invoked, my lords.
No
My lords,
problem, sir.
OAS has also been filed, my lords.
Case and counter case?
Please, my lords.
ಬರ್ಲಿ.
My lord, in last hearing date also we have filed, my lords. This is the fresh we have challenging the charge sheet, my lords.
ಪರವಾಗಿಲ್ಲ sir.
FIR also was challenged, my lords.
ಕರೆಕ್ಟ್ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ಅಷ್ಟೇ.
Liberty was.
ಸ್ಟೇ ಇತ್ತಾ?
No, my lords.
ಇಲ್ಲ
Liberty
ತಾನೇ?
was.
ಲಿಬರ್ಟಿ ಕೊಟ್ಟ ತಕ್ಷಣ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಅಂತನಾ?
My lords,
ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿರೋದು ಮೆಮೊ ಕೊಟ್ರೆ 2.5 ತಗೊಳಕ್ ಅಷ್ಟೇ.
now documents has been produced, my lords.
No.
Own certificate is stated as simple in nature, my lords.
It's case and counter case. Why is it that only you say the truth? ಅವರು ಇರ್ಬೋದಲ್ಲ.
My lords, they have not challenged any
HCGP to
proceedings.
emergent notice. No, sir. Yes.
My lords, date maybe.
Immediately after service of notice. Yes.
36,
Mother-in-law has lodged a complaint.
No
The
problem.
previous
Come
day
after, go see page 35 to 37. Come after charge.
At 33, page number 33, previously I have also lodged a complaint.
No problem.
There is a counter blast to the
No
early
problem.
registration
No
of
problem
FIR.
at all, sir.
And because of the case and counter case are there.
No problem.
Kindly notice maybe.
No.
Because it's within the family members. May
Let
try
the
to-
investigation go on.
Try to settling the matter after
No.
service of.
Let the investigation go on. ನಿಮ್ದು ಆಗ್ತಾ ಇದೆಯಲ್ಲ. ಒಂದು HCGP to emergent notice. ಒಂದು ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ.
37,
Happy for the petitioner, my
Ah.
lord. The entire transaction pertains to.
Where is Maida?
The accused number 1, respondent number 2 in the matter, my lord. He has not supplied it, my lord. He had taken that one. I had
ಮೈದಾ
introduced-
ಮೈದಾ ಇಂಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ ಅನ್ಬಿಟ್ಟು ಎಲ್ಲ ದುಡ್ಡೆಲ್ಲ ಹೋಗ್ಬಿಟ್ಟು.
ನಾನು ಬರೀ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಸಿದ್ದೆ ಅವ್ರಿಗೆ.
ಯಾಕೆ
ಯಾಕಂದ್ರೆ
ಇಂಥವ್ರನ್ನ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ವಾ ಏನು?
ನಾವು LLP, we connect the buyer and the seller.
1.5 ಕೋಟಿ ಮೈದಾ.
So the orders was placed by the complaint to the accused number 1, my lord, and the entire dispute is as against them. I'm basically more of an agent who has introduced the complaint to that at the price which they both agreed upon. In fact, my only thing was the travel expenses of 19,000 which you have seek for reimbursed, where the end financial.
ಎಲ್ಲಿ ಜೋಧ್ಪುರ ಜೈಪುರ?
Jabalpur, my lord. Jabalpur. But introduce ಮಾಡಿಸ್ಬಿಟ್ಟು ನಾನು ಇದ್ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ. Young individual who is also a cricketer who has got prospects before him. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ entire dispute between complainant and accused number 1 ನಲ್ಲಿ ನಾನು
The petitioner is accused number 2.
accused number 2, my lord.
Cracks a deal between the complainant and.
Cracks a deal.
Hello, ನಿಮಿಷ. Cracks a deal by introduction. Introduces a complainant to accused number 1. The two crack a deal for getting Maida from Jabalpur to Bangalore. 1.5 crores is allegedly transferred to accused number 1, there is neither maida nor money. Therefore, the crime is registered. The petitioner having introduced the petitioner's role of introduction and payment of 19,000 as travel expenses, there is nothing alleged against him. Therefore, nothing against him, while all the allegations are against accused number 1. In that light, there shall be an interim order of stay only against accused number 2. It is made clear pendency of this petition or the interim order granted qua accused number 2 would not mean further proceedings against accused number 1 would not continue. It shall continue.
Deeply obliged, my lord.
38.
Split, who's 38?
The matter may be passed over, my lord.
It's split charge sheet.
My lord, I have no instructions regarding the matter.
Proxy counsel
Yes, my lord.
also.
39.
Prepare for the
Boxo.
application. Yes, my lord.
A5 and A6.
Yes, my lord.
You know what accused number 1 has done, Allah?
Yes, my lord. I know, my lord.
Brutally.
Yes, my lord. But accused number 5 and 6, my lord.
Brutally sexually assaulted the minor.
Yes, my lord. But FIR, my lordship, our name is not there, my lordship. Only in the charge sheet. And one second, my lordship. The trial court has taken the cognizance for the same offences which were taken, which was alleged against the.
You don't worry. Charge frame ಆಗ್ಬೇಕಾದ್ರೆ ಅದ್ ಮಾಡಿದ್ರೆ
Lordship. The only allegation at page number 35, kindly peruse page number 35, my lordship.
Only
The
notice.
charge sheet allegation, they participated in the talks. That is the only allegation against the accused number 5 and 6, my lord. They are mother and son. Son, he accompanied his mother to the place,
Yes,
my lordship.
Vaida madam, look into it. Learned HCGP is directed to accept notice, look into the papers and make submission. 6th in the fresh matters list.
Lordship, they are.
In
Lordship, one small child is there, my lord. 2 months child is there. They're
so
running here and there, my
ಯಾಕೆ
lordship.
bail ತಗೊಂಡಿಲ್ವಾ?
Well, still it is pending, my lordship.
ಮತ್ತೆ ಅದಕ್ಕೆ.
Please,
Yes.
my
No,
lordship.
sir.
No, if there is an allegation, my lordship, I withdraw my petition, my lordship.
ಮಾಡ್ತೀಯ ಮೆಮೊ ಕೊಡಿ.
Allah, there is no allegations,
No
my lordship. That's why, my
That
lordship.
we'll see. Yes. Yes, 6th fresh matters. Next.
Please.
For the petitioner in this case.
Husband 85.
My lords,
One
the matter has
HCG.
been settled between the parties, my lords.
ಎಲ್ಲಿದೆ?
We'll report the settlement in the 2:30 PM, my lord. So it may be
Pass over.
Much over.
41.
Raghavendra, who is in possession?
I am in possession.
In the meantime. Yes, next.
42.
One
ಯಾರಿಗೆ
offense-
ಬೈದ್ರಿ?
My lord, general public ಜೊತೆ
ಜನರಲ್ ಪಬ್ಲಿಕ್
ಅಷ್ಟೇ ಇವರಿಗೆ no force used, my lord. There is no force.
ಹೌದಾ?
Yes. And they.
Why
the
have you
police-
not used force?
I am not, there is no allegation of
good
using
man.
of force, my lord.
Rowdy
And
sheet,
also that, my lord, they were not on duty.
ಎಷ್ಟು ಕ್ರೈಮ್ ಪೆಂಡಿಂಗ್ ಇದೆ?
ಇಲ್ಲ ಇದಿಲ್ಲ ಕ್ರೈಮ್ ಪೆಂಡಿಂಗ್ ಯಾವ್ದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಇವನು ರೌಡಿ ಶೀಟ್ ಅಲ್ಲಿ
With
ಕಂಟಿನ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಈಸ್ ಎ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮೆಂಬರ್, ಮೈ ಲಾರ್ಡ್, ಜಸ್ಟ್ ಟು ಕಂಟಿನ್ಯೂ ಹಿಸ್ ನೇಮ್ ಇನ್ ರೌಡಿ ಶೀಟ್, ನ್ಯೂ ಕೇಸ್ ಫಾಲ್ಸ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್
2023.
for same cause of action. One more case registered, my lord. Two cause of
An
action,
assault
two
has
cases for single. cause of
ಅಸಾಲ್ಟ್
action.
ಯಾರ್ಗ ಅಸಾಲ್ಟ್ ಮೇಡಮ್?
Police.
ಪೊಲೀಸ್ಗ?
Assault ಮಾಡಿಲ್ಲ.
ಪೊಲೀಸ್ಗೆ ಅಸಾಲ್ಟ್?
ಇಲ್ಲ ಅಸಲ್ಟ್ ಯಾರಿಗೂ ಅಸಲ್ಟ್ ಮಾಡಿಲ್ಲ.
ಏನ್ ಅಸಾಲ್ಟ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ, ಬರೀ ಸಾಲ್ಟ್. ಎಸ್.
For single cause of action, my lord, they have registered two cases, my lord. And my lord, allegation, lordship may kindly see the complaint. There is no allegation of using of force, my lord. And they
Tell him why you did not use ಅಂತ ಕೇಳ್ತಾರೆ.
ಮಾಡಿಲ್ಲ, false case. This is totally a false case. Since I'm a.
The petitioner is before the court calling in question. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
Calling in question proceedings in so and so registered for offence punishable under section 132 of the BNS stroke 353 of the earlier regime, the IPC. For an offence for an act to become an offence under section 353 of the IPC, the ingredients of section 351 is necessarily to be present, which would mean the accused must have deterred the public servant from performing his duties by use of criminal force. There is no allegation of the kind in the case at hand. In that light, there shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing.
Much of.
43.
27B of
Learned HCGP is direct.
Consumption.
NDPS, consumption.
Consumption.
The matter is squarely covered by
Monday,
your
but
lordship.
we'll take it on Wednesday.
Please.
The learned HCGP is directed to accept notice of the respondent Wednesday in the fresh matters list. Next.
44.
complainant, please, my lord, tenant. The allegation is that, please, my lord, 60,000 is not being paid by the
Page
petitioner.
40, 41.
My lord, page, my lord, the allegation is that, please, my lord, the only that, please, my lord, made an allegation to an extent of his caste is concerned. And the eyewitness would be, please, my lord, the person who has earlier registered a crime against me.
Atrocity I will stay.
My lord,
Seri
insofar
ಏನಿದೆ?
as
341 ಅಷ್ಟೇ ಅಲ್ವಾ?
in 341, 115 ಇದೆ.
100, yes. In the meantime, next.
Please, my lord, in respect of IPC also.
Meantime, yes.
Please.
In the meantime,
45 ಅಲ್ಲಿ I have sought for.
withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, I sought ಅವರು without making PF melody, they are keeping my motorcycle melody in their custody.
Release of vehicle.
ಅಲ್ಲಲ್ಲ, I have sought for stay of the FIR melody, and at the same time without making
ಯಾಕೆ
subjecting.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Yes, next.
I have filed an application melody seeking release also.
Release of vehicle ಆಮೇಲೆ ಫಸ್ಟ್
Direction,
ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದನ್ನ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ.
please.
ಅಯ್ಯೋ ಫಾರ್ ಡೈರೆಕ್ಷನ್ ಇದೆಯಾ?
Please.
ಯಾವ ವೆಹಿಕಲ್?
Motorcycle melody.
Without number plate.
ವಿತೌಟ್ ನಂಬರ್ ಪ್ಲೇಟ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ your lordship may kindly peruse annexure B melody.
ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
ಫ್ರಂಟ್ ನಂಬರ್ ಪ್ಲೇಟ್ ಡ್ಯಾಮೇಜ್ ಆಗಿರುತ್ತೆ. ನಾನು ಹೊಸದಾಗಿ ಅಪ್ಲೈ ಮಾಡಿರ್ತೀನಿ, ಬ್ಯಾಕ್ ಸೈಡ್ ಇರುತ್ತೆ. ಅದನ್ನ ಸ್ಟಾಪ್ ಮಾಡ್ತಾರೆ, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕರ್ಕೊಂಡು ಹೋಗಿ 318 420 ಅಫೆನ್ಸ್ ಬುಕ್ ಮಾಡ್ತಾರೆ.
ಮತ್ತೆ ನಂಬರ್ ಪ್ಲೇಟ್ ಇಲ್ಲದೆ ಓಡಿಸ್ತಾರೆ, ಅದಕ್ಕೆ ತಾನೆ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ we have shown my lord damaged ನಂಬರ್ ಪ್ಲೇಟ್.
ಆಯ್ತು, ಅಪ್ಲೈ ಮಾಡಿದ್ದಕ್ಕೆ ಇದೆಯಾ?
ಪ್ಲೀಸ್ annexure B my lord.
ಯಾವತ್ತು ಅಪ್ಲೈ ಮಾಡಿ?
35ಕ್ಕೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ.
ನೀವು ಸಿಗಾಕೊಂಡಿದ್ದು ಯಾವತ್ತು?
7ನೇ ತಾರೀಕು.
7ನೇ June 6th.
Please,
for the reason, in the light of the interim order granted and the reasons indicated in the affidavit accompanying the application is IFR direction ಮೇಲೆ affidavit application, the petition, the application deserves to be allowed for the reason that the petitioner has demonstrated that he had applied for a new number plate as number plate had been damaged on 30th May 2026, and the petitioner 25 or 26 26, and the petitioner was caught without a number plate,
ಒಂದು ಮಾತ್ರ
without a number plate on the front of the vehicle, front of the motorcycle on 7/6/2026. In that light, the vehicle that is in the custody of the police shall be released to the petitioner without broking any delay, ordered accordingly. Yes.
46.
In time, next.
47.
For the petitioner. Accused number 3, my lords. The money has been transferred to accused number 2's account by accused number 1. The forgery was committed by accused number 1. I was not in the crime stage. I have not been made as an accused. At the time of remanding, my lords, I have been brought in as an arraigned as accused. Only a stray allegation that I went and deposited the checks.
No problem. 1 HCGP, 2 emergent notice.
My lords, no allegation against me at all. There is not even recovery of money. The recovery of money is from
yes, we'll
A2.
see. But yes,
my lords, there is absolutely no material.
problem,
I don't even know what the case is against me.
No, you deposited the checks, sir.
I have that's the allegation, my lords.
That's
There is
no
no
problem.
material at all.
19.
Correct. No
That is a checks issued taken by A2. The entire complaint, my lords, there is not even a
No
single
problem,
sentence.
sir. You will get to know what is the allegation.
Lords.
Wait. Yes.
My lords, there is not even an iota of
No,
criminality
no,
in this on me.
what ella ide. Yes.
My lords, there is, your lordship may kindly see the remand order, my lords.
No problem, sir. Investigation is still pending, sir.
Please, my lords, but
Investigation is still
at
pending.
least prima facie, they should establish.
Correct, sir.
Prima
You will
facie,
know
there
what
no
is the
delay.
allegation against you. Just wait. Charge sheet barli.
ಇಲ್ಲ, prima facie,
Still
my lords,
FIR.
to even
ಅದೇ
remand me,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ, you will know what you have done.
lords.
No, prima facie 19 ಚೆಕ್ ಯಾಕೆ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ?
Huge
Yeah,
amount
next.
has been involved in this.
Absolutely.
Huge amount has been done by A1 and A2.
No
A1,
problems.
A2 is a public servant.
You're
A1,
no problem, sir. You're a cohort in crime. So
my
just
lords,
wait.
It is a post act. What has been alleged is post act.
Period. I'm not granting. Yes.
Oblige.
Next.
48.
The petitioner, my lords. Just because, my lords, I am the friend of the other accused, my lords, I have been roped into the web of
In the
crime. my lords.
meantime, yes.
My lords, in Rajesh.
Next.
49.
118, 1 HCGP to emergent notice.
recent counter case, my lord. First FIR, it was
ತೊಂದ್ರೆ
not
ಇಲ್ಲ,
by
yes.
2 days delay.
ಪರವಾಗಿಲ್ಲ, yes.
Please.
Page 32.
Page 32.
Notice
my lords.
only, yes. 1 HCGP to emergent notice.
One thing, my lords, in Abdul Salim, my lords, and CT Ravi, my lords, has distinguished, my lords. Wherein, my lords, the words, my lords, are not used.
I think, no, wait.
Great.
Yes.
51.
Lot 376 offense.
Hmm.
Lower court has rejected the discharge application.
Hmm.
There is no valid
What do you
reason.
think the trial court should discharge you on 376, sir?
No, my lord.
Hmm.
We, in an entire charge sheet, an entire complaint, my lord, if plain reading
You're
itself.
accused number
itself-
one.
I'm only one.
Only sole accused, correct, yes, sir.
Sole accused.
Hmm.
My lord, offense happened on the date of Holi.
On the date of?
Holi.
Holi.
It was last year
Oh.
in 2025.
Hmm.
The victim and accused together, they went to a place. And after 14 days of this said offense, the FIR complaint was lodged. The victim by herself, she denied the medical. She voluntarily denied the medical. 164 is statement is not recorded. And Milord, even the forensic details also, she was at the time of offense, she was wearing some other male friend dress, Milord.
Wearing some other male friend dress.
Some other male friend. It happens in a group of a place. One person called Anurag, at his place, they did the party. After that, they went somewhere on the second place to the Milord. This entire of document, entire complaint. Nowhere there is a forcefully intercourse or in nowhere it is mentioned, Milord. And also, Milord, she herself, she joined the party voluntarily. She provided 90 minutes of head massage to the accused
Head
person.
massage?
Yes, my lord. After that, they together they went in one car. This in the complaint she mentions black car, but actually it was a white car. Both were drunk. In the complaint itself, she mentioned that she also had a sip of whiskey and
Sip
beer.
of whiskey.
Yes, my lord.
Very risky.
My lord, there is no prima facie any material to continue this case. My lord, we approached Honorable Sessions Court. Sessions Court has rejected without giving any reason in entire order sheet. My
You're a
lord.
masseur,
Yes, my lord.
head massage kotte.
It's she herself, she writes in the complaint that she's a Mehndi artist.
Mehndi artist.
She's a Mehndi artist. She provided head massage. She
Oh,
voluntarily
she
joined-
gave you head massage.
Yes, my lord. And my lord, there is no evidence, no, in entire charge sheet, there is no document. Voluntarily, she denied the medical. She herself went to with morning 5 a.m. with the accused person to the accused person's house, flat,
So consensual.
consensual, my lord. My lord,
ಡಿಸ್ಚಾರ್ಜ್ ಹೋಗಿ ಅನ್ನೋಕ್ಕೂ ಆಗಲ್ವಲ್ಲ ಆಗೋಗಿದೆ ಅದು. ಎಸ್ ಮೇಡಮ್, ವಾಟ್ ಇಸ್ ದರ್?
my lord, no cooperation from.
ನೋ ಕೋಆಪರೇಷನ್.
No cooperation in the
ನೋ
investigation. also.
ಕೋಆಪರೇಷನ್ ಗೆನೆ ರೇಪ್ ಬಂದಿರೋದು.
The police just made this case and filed the charge sheet. In the charge sheet also, there is no document, even in forensic also, to prove there any charge against the accused person.
Yes. The petitioner, the sole accused in SC 1351 of 2025 is before the court calling in question an order of the concerned court which rejects an application under section 227 of the CRPC seeking his discharge from the area of accused in an offense that has become punishable under section 376 of the IPC for the act of the petitioner. Heard so and so. Facts enumerated are as follows. On a particular day, -25/3/2024, it is the case of the prosecution that on 25/3/2024 at around 11 p.m., the complainant visits the house, friend's place. A complainant visits the place of a common friend where the alleged incident takes place. The alleged incident is that the petitioner, the sole accused now, takes head massage from the complainant for about 90 minutes gives her whiskey, and after sipping whiskey, the petitioner takes the complainant to another apartment and commits the act of sexual assault. The next morning, when the complainant was found in a state where she realized that she had been sexually assaulted, registers the complaint on 8/4/2024, though albeit after certain delay. Delay of about 8 days, huh? Delay of about 8 days after the said incident. The police then, this becomes a crime in crime number 148 of 2022 for the offense under section 376 of the IPC. The police conduct investigation and file a charge sheet. The charge sheet led the petitioner to file an application seeking his discharge from the case on the score that there are several lacunae in the conduct of investigation by the prosecution. The concerned court refuses to discharge the petitioner. Therefore, the petitioner is before this court seeking quashment of the entire proceedings. The learned counsel appearing for the petitioner submits that the complainant is a mehendi artist. She came to apply mehendi and also gave head massage to the petitioner, then sipped whiskey. And after that, it was only consensual acts between the two and not sexual assault, as is obtaining under section 375 of the IPC for it to become an offense under section 376. He would therefore submit that these acts, he would further submit that the complainant has volunteered herself not to get medically tested after the incident, the medical examination after the incident, and 164 statement is also not recorded. 164 statement ilva?
No.
164 statement is not recorded.
No.
Be that as it may, all these contentions of the petitioners are shrouded with seriously disputed questions of fact. It is an offense of rape that is alleged. The charge sheet so filed against the petitioner pursuant to investigation would clearly pin down the petitioner for acts that would become the ingredients of section 375, albeit prima facie. The summary of the charge sheet reads as follows. It is not that the act has not happened. The petitioner also would admit that the act has happened, but would project it being consensual. While it is only a one-off situation where the petitioner has indulged in sexual intercourse with the complainant. Therefore, it cannot be said that they were acts of consensus continuous acts of consensus. It is a matter of evidence for the petitioner to come out clean in a full-blown trial. As the offences in the considered view of this court would require a trial. All the lacunae that the petitioner is wanting to project before this court is should be projected before the concerned court, reserving concerned court finding no merit to entertain the subject petition. The petition stands dismissed. Next.
52.
There is a prohibited order by the deputy commissioner.
ಅಲ್ಲ ಆಯ್ತು, ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಹೆಸರೇನು?
Not complainant, not lady by name.
ಆ ಲೇಡಿ ಗೊತ್ತು, ಏನದು ಹಂಗಂದ್ರೆ? ಪ್ರಿಯಾಂಕಾ, ಓಕೆ. ಶಾಪ್ ಪ್ರಿಯಾಂಕಾ ಅಂದ್ರೆ ಏನರ್ಥ?
ಇಲ್ಲ ಇಲ್ಲಿ
ಶಾಪ್ ಪ್ರಿಯಾಂಕಾ ಯಾಕೆ?
ಅಲ್ಲ FIR ಅಲ್ಲಿ ಆ ರೀತಿ ಇದೆ. FIR ಅಲ್ಲಿ ಫಿರ್ಯಾದರ ಹೆಸರು ಶಾಪ್ ಪ್ರಿಯಾಂಕಾ ಅಂತ. ಮೇ ಬಿ ಶಿ ರನ್ನಿಂಗ್ ಎ ಶಾಪ್, ನಾಟ್ ದೇರ್ಫೋರ್ ಶಿ ಇಸ್ ನೋನ್ ಆಸ್ ಶಾಪ್ ಪ್ರಿಯಾಂಕಾ.
ಎಲ್ಲ ನಡೆಸೋರೆಲ್ಲ ಹೆಸರಾ? Woman should not run the shop also, is it?
She may be so famous, Lord.
Oh, correct. Yes. Why shop Priyanka? In the meantime, yes, next.
53.
Number 123, my lord. Date of statement. 123, my lord.
And so there shall be an interim order of stay only insofar as the offences under the Atrocities Act are concerned. Insofar as the other offences, same would be considered after the appearance of the complainant. 1 HCGP to emergent notice. Next.
54,
Same in the meantime, next.
55,
490, 420, madam.
490, 419.
419 and 420.
Ah.
Earlier crime stage, madam, the Chandrabal court entry
The
ಮಾಡಿದ್ರೆ
petitioner is before the court calling in charge sheet ಆಗಿದೆಯಾ?
charge sheet
Calling in question proceedings in so and so, registered for offence punishable under section 419 and 420 of the IPC, and 465 also. The incident, even according to the complaint, freezes in the year 2020. Complaint is registered in the year 2025, 5 years after the said incident, without a speck of explanation for the said delay. Therefore, the complainant is full of embellishments that have happened between 2020 to 2025. In that light, permitting further proceedings in the case at hand would run foul of the judgment of the apex court in the case of Chanchalapati Das versus State of West Bengal, 2023 SCC online SC page 650. There shall be an interim order. Next.
56,
Lords, petitioner is accused number 2. There was a car coming from behind who is the accused number 1. It's the petitioner from the behind who is the accused number 2. The accused number 2 car hits the deceased and the deceased passes away. Accused number 1 further goes and hits another car. Due to the rash and negligence of accused number 1, I am implicated, my lords.
Can't help, you're caught in the muddle.
My lords may kindly peruse the statement of the
482 is not the jurisdiction to decide who hit whom, who died of whose hit.
Please, my lords, but my lords may kindly peruse. My lords may kindly peruse the statement of CW.
No, sir. ಇಲ್ಲಿ ಸ್ಕೆಚ್ ನೋಡ್ಬಿಟ್ಟು ಯಾರು ಹೊಡೆದ್ರು ಫಸ್ಟ್ ಅಲ್ಲಿ ಬಂತು ಕಾರ್ ಬಂತು. ನೋ ಸರ್. ವೈ ಬಿಡಿ ನೀವು ಅಲ್ಲೇ ಕೂತ್ಕೊಳ್ಳಿ. ಎಸ್.
My lords, due to negligent act of somebody else, my lords, I am at a standstill. He comes from behind and hits me. There is no criminal culpability attached to me, my lords, because no ingredients of 281 or 106 clause 1 is made out against me.
That is 304A, rash and negligent act of accused number 1.
Accused number 1 though, there is no act of me. There is absolutely no act of me. Because of his acts, I am implicated in this. My lords may kindly peruse the statement of CW-15 in page number.
And trial commence ಆಗಿದೆಯಾ?
ಇಲ್ಲ, my lord.
ಇಲ್ಲ ಅಲ್ಲ.
No. But
Heard the learned
as-
counsel appearing for the petitioner. The petitioner is drawn as accused number 2. The accused number 1, comes, hits the car of accused number 2. The impact of that hits the person who sustained injuries. Not stopping at that, the accused number 1 again goes and hits the deceased, goes and hits the person who then dies. The acts of 304A has fallen on both these accused 1 and 2. So far as accused number 1 is concerned, the acts are directly attributable of rash and negligent driving. The petitioner is said to have been caught between the accused number 1 and the person who died, as the documents would clearly indicate that he was not the one who was driving in rash and negligent manner. In that light, there shall be an interim order of stay, qua the petitioner, till the next date of hearing.
So one more humble submission. She's a law student. She's trying to enroll and having the criminal.
Here, petitioner.
Petitioner.
Hmm.
She's trying to enroll. So she's cleared. She's a grade A student.
How would that come in the way?
My lords may kindly permit her to enroll.
ಈಗ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಲ್ಲ, take advantage of it. Yes.
Obliged.
57,
On HCGP to emergent notice.
78. Offense in 78. Case and counter blast complaint against me, Malish.
70?
78, Malish. Offense in 78.
AP Act.
BNS,
Yeah,
Malish.
BNS.
354D, Malish. Talking. Allegation that Malish, number of cases against me on complaint.
Yes.
Initially, Malish, NCR Malish, after filed the complaint, Malish. Counter blast complaint was stay before the court, Malish. Kindly to criminal petition, Malish. 290 but
ಅದರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
Stay ಇದೆ. My complaint, Malish.
ಇದರಲ್ಲಿ ಕೊಡಲ್ಲ. Yes.
Counter blast, Malish.
354D.
Malish. No allegation, my lord.
No, sir.
Number of cases, my lord.
Parvala, we'll see. Tag the petition along with so and so, one HCJP, two emergent notice.
290, my lord. Criminal petition, 290.
Right,
Please.
yes, next. No interim order in this. 58 in the meantime.
59,
Speedy trial matra kodak sadhya.
Counter blast, my lords, ಅದರಲ್ಲಿ acquittal
2013 acquittal.
For the other accused, my lords, respondent to acquittal ಆಗಿದೆ sir. In that case, my lords.
We'll direct the court to conclude the trial within 3 months. You will also get acquitted. ಈ trial ಶುರು ಆಗಿದೆ ತಾನೆ?
Evidence.
Charge ಆಗಿದೆ.
The petitioner is before the court seeking the following prayer. The prayer is, the contention of the learned counsel for the petitioner is that the counter case that is registered, that on a complaint registered by the petitioner against the complainant has ended in acquittal, and the petitioner's case is being tried. While that would not be the reason to quash the proceedings at this juncture, more so in the light of the fact that the trial is at its fag end. Trial in CC 605/2013 is at its fag end. Therefore, I deem it appropriate to direct the concerned court to conclude the trial within an outer limit of 3 months from the date of receipt of the copy of the order. While so doing, it shall bear in mind that the counter case on the same allegations has ended in acquittal. Ordered accordingly.
60,
Petitioner. Malaysia. Offense under section 354, 323, part of 5 for same complaint, Malaysia is complaint against me. Same set of facts, Malaysia.
ಯಾವುದು sir?
Last 57.
ಗೊತ್ತು.
Yes, Malaysia.
ಅದೇ ಆನಂದ NH.
Please, Malaysia.
Accused.
Accused, Malaysia. Same set of fact, Malaysia. Allegation that Malaysia is the second complaint, Malaysia.
Next.
First.
ನೋಡಿಲ್ವಾ?
File.
ನೋಡಿ. In the meantime, next. The subject complaint, 60 ಬರ್ಕೊಳ್ಳಿ. The subject complaint is second in line, verbatim similar to what is challenged in serial number 57.
57.
Serial number 57. ಅದ್ರಲ್ಲಿ crime number ಅನ್ನು ನೋಡು. Same sound. In that light, there shall be an interim order of stay of further proceedings square the petitioner to the next date of hearing.
61, Malaysia.
61 ಅಲ್ಲ? 60 ಏನು?
60, same. 61 same.
ಏನ್ ಸೇಮ್ ಮೂರನೇದಾ?
ಮೂರನೇದು ಸೇಮ್ set of
No,
fact.
no, no,
Counter
no.
case is my case is a stay, Malaysia. 29.
No. 61. Look into it, madam.
Please.
Yes, ಯಾಕೆ ಫೈಲ್ ಎಲ್ಲಿದೆ? Yes, list the matter on 30th fresh matters list. Next.
290, Malaysia. Is same connected,
We'll see,
Malaysia.
we'll
Same
see,
case
yes.
and counter. ನಮ್ ಕೇಸ್ ಸ್ಟೇ ಆಗಿದೆ.
ಆಯ್ತು, ಪರವಾಗಿಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ.
Along with that.
52,
ತೊಂದ್ರೆ ಇಲ್ಲ, ಅವತ್ ಬರ್ಲಿ. 2-3, husband no stay, 2-3-85.
Your lordships, just one submission, my lords. There was already a settlement agreement 1 month before the complainant, my lords. And the complainant itself, in her second paragraph, she mentions.
Settle ಆಯ್ತಾ?
Settle agogide, and there's a final settlement agreement,
Where
my
is
lords.
that?
Page 90, my lords. Page 90, the complainant herself, in second paragraph, the written complaint, my lords. If I may be permitted to read.
Where is this settlement?
The settlement is in annexure D, and annexure D, page 106 and 113. There's a joint affidavit as well, my lords.
Page.
Page number 106, my lords.
106.
Yes, my lords. Running page 105.
Yes, mutual divorce.
Yes, my lords.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
Idರಲ್ಲಿ November ನಲ್ಲಿ there's a mutual divorce that they enter into.
Where is the
joint affidavit is in page 113, my lords.
one ನಿಮಿಷ, joint affidavit ಅಲ್ಲಿ ಇದು ಇದೆಯಾ?
Yes, my lords. Paragraph 5, my lords, 4 and 5. Joint affidavit. Page 113, 114, my
ಈ
lords.
crime ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಸರ್?
My lords, the crime was registered 1 month after all this was done. my
After
lords.
this, is it?
After this is done, and there's an admission that they were living separately since November of 2023, my lords.
That's all right.
That's also in joint affidavit. Now, on 23rd January.
Look, 1 minute.
Yes, my lord.
What's the crime now?
Crime number 27 of 2026.
Wait.
Sorry, my lords.
2 and 3 matra, yes.
Much obliged.
No stay for husband, yes.
For petitioner.
No stay for A1, husband, A2 only stay. Yes, next.
Obliged.
64.
What's review? In madam idu? Yes, government.
Review of entire order in writ petition 41934/2007.
ಯಾವ್ದು ಕೊಡಿ?
Service matter.
Service matter. How ಕಾಲದ madam?
17.
They have mentioned annexure in writ petition number.
ಯಾವ್ದು that Mojini operator sir?
Yes, your lordship. First time hearing.
Notice. Take Leonard AG na?
AGA.
AG accepts notice for the respondent. Yes, next.
Much obliged.
Avare iradu state bere yarilla. Yes.
65.
The meantime, next.
Great.
66.
Paying for the petitioner.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service by the 1st of July, list on 6th of July in the fresh matters list. Next.
Stay may be granted. Your
That
Honor.
day, yes.
Despite resettlement, they have initiated the 138 proceedings against us. Your Honor.
But 379, 406, 420 yaar madid? Who has registered that crime?
The-
Get, yes, next. ಅವ್ರು ಬೇಡ ಸ್ಟೇಟ್ ಮಾತ್ರ ಸಾಕು ಅವರೇ ಯಾರು ಬೇಡವೇ ಬೇಡ ಓನ್ಲಿ ನೋಟಿಸ್ ನೀಡ್ ನಾಟ್ ಬಿ ಇಶ್ಯೂಡ್ ಟು ದಿ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಮಾಡ್ಬಿಡಿ
67.
Waiting for the petitioner.
in the meantime. Next.
68.
The petitioner. The petitioner is accused number 3. My
Where is
lord.
the agreement?
Agreement is at page number 32, my lords. The
You are
petitioner
not the
was-
signatory to the agreement,
We are not the.
nor the signatory to the check.
Yes, my lords. We are not, my lords.
The issue arises out of an agreement entered into between the husband of the petitioner and the complainant. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the petitioner is neither the signatory to the agreement nor the signatory to the check. For the acts of the husband, the wife is now roped in for offences under section 138 of the Negotiable Instruments Act. In that light, there shall be an interim order of stay of further proceedings, square the petitioner to the next date of hearing.
Great.
69.
Petitioner in this case, my lord. But petitioner is an employer, the managing director of a company wherein this particular respondent number 2 was working for some time.
Even
Since
her
the
documents also not given.
that the documents have been handed over
Even
to the
then,
police station. my lord.
horrible offences.
Lord, that is alleged against other women employees, but against this person, only for that, after they took the documents, my lord, she has not even come back to the work, not even placed the resignation.
No problems.
But that is, my lord, may kindly see the complaint that is being lodged, my lord. After the letter was issued from the chartered accountant to identify the discrepancies, she stops coming to work. And then she was requested to report to the work and file the resignation letter and complete the exit process. The complaint comes to be lodged, my lord. And in the police station, my lord, the
One
documents were taken
HCGP
back.
to emergent notice.
The documents were taken back and there is no such.
We'll see, yes.
70.
Petitioner in this case, my lord.
Your husband and wife, huh?
No, my lord, they are in a living relationship.
Hmm.
At that time, she only transferred the money through RTGS.
Why did you break the FD?
No, my lord, the kindly.
The
see
allegation.
No, kindly see the summary of the FIR, my lord, for a moment. In that, my lord, she is stating that, my lord, I may be permitted to read, my lord.
Anyway, in the meantime, yes.
Grateful.
71.
17A. 17A.
Yes.
Learned AGA ಬರಕ್ಕೆ ಹೇಳಿ ಅಥವಾ SPP ಗೆ ಹೇಳಿ. The learned HCGP is directed to accept notice for the respondent. The learned SPP shall secure instructions and submit 6th fresh matters.
Interim order.
No,
22.
in the meantime.
73.
State, sir, yes. Sachin,
73.
Case of defamation. Lords, NCR is issued. Lords, he goes before the magistrate 156(3). FIR is registered. Lords, all arising out of same transaction. Lords, saying that I have defamed him. Lords, now my lords decision
it's
is
353.
353. Lords, arising out of the same this thing. He says, my lords, that I have sent the photo of the complainant and said that Asami ಇದು ಮಾಡ್ತಾ ಇದ್ದಾನೆ.
But it's an amalgam of two. FIR ಹೆಂಗ್ ಮಾಡಿದ್ರೆ ಇದನ್ನ?
FIR is done. My lords, 156(3) referring from the magistrate. If it is, my lords, before the private complaint, my lords, then I
It's
have.
all right, correct. Defamation, you can't go there.
Yes. Let
Settle
him be
principle.
given liberty, my lords. My lords,
But without hearing henge.
Please, please. But my lords, I've also
Emergent
quoted,
notice
my
to the respondent, 1 HCGP to emergent notice, there shall be an interim order of stay of all proceedings, all investigation in crime number
41 of 26.
41 of 2020.
2026.
ಸ್ವಲ್ಪ prayer ಗೆ ಬನ್ನಿ, interim prayer ಗೆ.
Lords, 41 of 2026.
Interim prayer ಗೆ ಬನ್ನಿ ಸರ್.
Lords, 22.
ಏನ್ ಹೇಳಿದ್ದೀರಾ ಸರ್?
20.
2023.
Lords, I'll amend it.
Yes. Meantime.
May permit it, my lords.
ಈಗಲೇ ಬರೀರಿ 26 ಅಂತ. ಸುಮ್ನೆ ಒಂದು ಹಾಕ್ತಿರೋದೇ ಅಷ್ಟೇ. ಸ್ಟೇ ಯಾಕೆ ಮೇಡಮ್ 73. ಎಂಟ್ರಿ ಮಾಡು. ಇನ್ ದ ಮೇನ್ ಟೈಮ್ ಹೇಳಿದ ಅದೇ ಮಧುಸೂದನ್ ನಡೀಗ ತಾನೆ.
75.
ಎಸ್ ವಿನಾಯಕ್.
Petitioner is a reporter. Trivial incident of
Trivial?
how the Saturday evening Tahsildar caste was stopped and she filed a wrongful restraint complaint against me. Charge sheet has been filed. Kindly see page 50, last paragraph.
ಯಾವ್ದಾರ ನೀವು?
Accused number 1.
ಅಲ್ಲ ಯಾವ
Pratidhwani media.
ಯಾವ ಮೀಡಿಯಾ?
Pratidhwani. Pratidhwani.
ಪ್ರತಿಧ್ವನಿ.
Echo.
ಓ ಅದಕ್ಕೆ ಕ್ರೈಮ್ ಎಕೋ ಆಗ್ತಿರಲ್ಲ.
My lord, kindly see page 50, last paragraph. ನಾನು ಹೊರಗಡೆಯಿಂದ ಗ್ಲಾಸ್ ಇಳಿಸ್ದೆ ಅಂತ ಹೇಳಿ ಅವ್ರು ಗ್ಲಾಸ್ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡಿದ್ರು, ಮೈಕ್ ಹಿಡ್ಕೊಂಡು just 2 minutes I walk. Last 8:30 evening Saturday in the toll plaza. I cannot even stop for 5
ಅದು
minutes.
ಯಾಕೆ ಅಂದ್ರೆ you wanted to unearth why where the vehicle was being taken at 8:30 on a holiday. In the meantime, yes. Beyond official hours. ಅದೆಲ್ಲ ಕೇಳಬಾರ್ದು ನೀವು ಆಫೀಸರ್ಸ್ಗೆ. ಕೇಳಿದ್ರೆ ಇದೇ ಆಗೋದು. ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ.
My lords, one submission, my lord, my apologies, my lord. Serial number 68, my lord, there is no dispute between husband and wife, my lords. Dictation ಕೊಡ್ಬೇಕಾದ್ರೆ
ಅವ್ರ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and 2 ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಅಲ್ವಾ?
ಇಲ್ಲ my lords.
ಯಾಕೆ?
ಕಂಪನಿ ಮತ್ತೆ ಕಂಪನಿ ಡೈರೆಕ್ಟರ್ಸ್.
Madam, is not this lady wife of accused number 1?
No, my lords. Accused number 1 is a company, my lords.
ಅಲ್ಲ 1 ಅಲ್ಲ. Who is this then? Wait. Joyce.
Accused number 3 is a petitioner, my lord. She was
One
formerly
moment. Who is Robert Christopher? That's your husband.
daughter, my lords.
Robert is daughter?
No, my lords, the Joyce petitioner number 3 is a daughter of the accused number 2, my lords.
That is daughter of Robert, is it? Daughter ಅಂತ ಹಾಕಿ madam instead of wife. Yes.
Great.
Number 2, seal number 1 being spoken to.
Madam, ಇದೇನ್ ಮಾಡಿದೆ 72? 72 ಇನ್ಸ್ಟೇ ಇಲ್ಲ. ಯಾರು ಹೇಳಿದ್ರು? 72 ಯಾರಿದ್ರು? ಯಾರು ಬಂದಿದ್ದೀರಾ?
ಬಂದಿಲ್ಲ.
72 fake currency, no chance of stay. 72 nobody represented ಅಲ್ಲ?
No.
Yes. ಜವೈ 72 ಆಮೇಲೆ ಸ್ಟೇ ಕೊಟ್ಬಿಟ್ರೆ. 73 yes.
Actually 72 stay ಅಂತ.
72 ಸ್ಟೇ ಮಾಡಿಲ್ಲ. ಮಾಡಿದ್ನ? ಹೇಳ್ಬಿಟ್ಟ?
Same.
No. ಯಾರು ಬರ್ಲೇ ಇಲ್ಲ.
ಬರ್ಲಿಲ್ಲ.
Yes. 72 is fake currency caught by group CBD children. Kolaralli. Yes.
List number 2 being spoken to.
72, no representation, list on 6th in the fresh matters. Madam, list.
Being spoken to seal number.
List, madam. List. ಇದೊಂದೇ ತಪ್ಪು.
Serial number 72.
ಹಾ ಬನ್ನಿ.
I'm sorry.
Yes. ಹಾ.
My lordship, offense under section 179 and 180 of VNS, my lordship. Fake note.
Fake currency, 500.
Yes.
Totally ಎಷ್ಟು 2,00,000?
2,38,000 ಅಂತ. In the complaint itself, it states that Children's Bank of India ಅಂತ.
Correct.
So anybody can get it from any.
No,
My lordship.
no problem. Yes, SPP ಅವರೇ, ಇದು ಅದು fake currency. Learned HCGP is directed to accept notice. The learned SPP is directed to appear in the matter. List the matter on 15th in the fresh matters list.
List 2, being spoken, serial number 1.
ಇದು ಮನೆಯಲ್ಲೇ ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟೆ. ದೇವರಿಗೆ ಏನು ಹೇಳ್ಬೇಕು ಹೇಳ್ಬಿಟ್ಟು.
Fresh matter, serial number 2.
Let's kindly pass over, senior counsel.
This is the matter, my lords, the one incident, 2 FIRs, my lords. This Alliance University, my lords, last date, senior counsel Shyam Sundar sir appeared. And if the incident is covered in the 2 FIRs, my lords, one incident, 2 FIRs, when I'm placing the synopsis.
Let one continue.
So second one, my lords, as against me, my lords, in second FIR, there is no allegation at all. In the second FIR, my lords, they narrate that, my lords, the charge sheet, my name is incorporated in the charge sheet, my lords. In that charge sheet, they have narrated section 307 of IPC, my lords. None of the witnesses.
Pass over.
Yes.
Number 3.
HL. Yes.
The council on record, son is
No,
undergoing
no, ma'am.
surgery.
Surgery?
Today, Lordship. Yes. He's
What
in
happened?
Malike Hospital. He has a surgery in the mouth, your lordship. So kindly grant any date that's convenient to the court.
So we'll take it next Wednesday. The same stage, next Wednesday.
Sir, I'm hearing for R3, respondent 3, we have issued NOC requesting my name be deleted.
Registry to delete the name of Dilip Kumar, is it?
Yes, yes.
Dilip Kumar as appearing for the third respondent. List. The learned counsel for the petitioner submits that the arguing counsel is undergoing surgery. Therefore, list this matter next Wednesday in the same stage. It is made clear no further adjournment will be granted in the
Number 4.
Okay, for petition. Your lordship may have it next week sometime. my lord.
Intermod ಇದೆಯಲ್ಲ?
Intermod ಇದೆ, my lord. Our matter pertains to PCP entity, my
ಗೊತ್ತು.
lords.
Yes. You are manufacturer.
I am the manufacturer. And also there are. The only issue I, in fact, have spoken to secretary.
Huh?
I've spoken to the health secretary. There are some, this thing, my lord, we need to streamline. Your lordship have it next week, my lord. Also,
I
it's
think
covered
stay
by the
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
judgment, ನಿಮ್ದೇ judgment.
Intermod ಇದೆಯಲ್ಲ?
ಆಯ್ತು. Please.
The learned, at the request of the learned SPP, list the matter, same Wednesday, next Wednesday in the same stage. Interim order subsisting will continue, ಅದರಲ್ಲೂ interim order continue ಆಗುತ್ತೆ. Interim order subsisting will continue till the next date of hearing. Yes.
Hearing for the petitioner, your lordship. Split up charge.
Split up.
There is 2 petitions, your lordship.
ಕೊಡಿ.
Out of same crime number. Kindly see the page number 130.
ಈಗ ಒಂದೊಂದಾಗಿ ಹೇಳಿ. First petition.
First petition, your lordship.
You are accused number 8, ah?
Yes, your lordship.
Who are acquitted?
Accused number 8 and accused
Acquittal
number
ಯಾರು sir?
all accused, all
All.
co-accused person except accused number 3.
Page.
Page 150, 125.
Reason.
Lordship, kindly see the page number 157, your lordship. 157. Para 26.
ಕಾರಣಗಳು ಇಲ್ಲಿದೆ ಬಿಡಿ. ಕನ್ನಡದಲ್ಲಿ ಬರ್ಕೊಂತಾರಲ್ಲ. 147. Three not seven na?
Yes, Your Lordship.
What is it, bhai? Just. Will dictate, wait. Next matter thought. One ನಿಮಿಷ ತಾಳಿ. ಬರ್ಲಿ, ಚೇಂಜ್. ಎರಡು dictate ಮಾಡ್ತೀನಿ. Yes.
Parties are ready for a settlement.
What's the offense?
69 and 89.
69. Why, who is the accused yaru?
Accused is the
There's an interim order?
There's an interim order. This is a matter where spa allegations. Spa allegations have been. Lordships could remember.
Steam. They're settling the matter? No.
Can I talk, sir?
You're the complainant.
Yes, sir.
You're settling the matter.
I have some concerns to talk.
Then, no settlement. Who said settlement?
We were informed that she has even signed a joint memo. But suddenly
You've signed the joint memo?
I was not, on 12th, they informed me for the hearing, I came, but while talking, I'm not.
Who is this on the VC?
I'm not sure.
Yes.
I'm not fine for it, but they have told me that like even Rotary while signing, I have informed them I'm not ready to sign, but they have informed me I can come and talk in front of you.
Lordships may have the matter on merits.
We'll hear the matter.
Please.
Unless both of you are getting married. All right. We'll see, we'll hear it on merits.
Please.
You engage a counsel or you appear, whatever it is.
Oh.
I'm not closing it by settlement now. Yes?
I have one small concern, sir. After the 12th, so we both are staying in the same area, just a 500-meter distance. So last 6 months after the complaint, several times he and his family, while going my sports practice or my office, I have crossed a number of times. I felt that
We'll
it was
see,
a coincidence.
you engage a counsel.
But last week, Tuesday, it happened where I was standing, there 4 people, night 10 o'clock.
It's all right, you engage a counsel. Counsel is there.
No, sir, I am appearing for myself.
Who are you?
Excuse me.
Yeah, right.
You appear for her.
No, I have not signed any wakalats to anyone.
Madam Manjula said, right?
You know who, what's your name?
Priya, right? You're Priya.
ಬೇರೆ ಯಾರ್ದು ವಕಾಲತ್ ತಂದಿದ್ದೀರಾ?
No, Lord, sir.
I have not signed any wakalat.
You have not yet signed. You're Priya, right?
Please.
Lordships may have it on merits, next week.
No, this will hear on merits,
Please.
whoever it is. Yes.
Next week.
List the matter on 15th July.
Please, Manoj.
Yes.
Interim order, please.
Interim order will continue, but no settlement in this.
No, please.
We'll hear it on merits. Yes.
Sir, my kind.
That day, on 15th.
Not to disturb outside.
On 15th, yes, whatever it is. Ask him to encourage restraint, otherwise I'll vacate the interim order. If it troubles the lady, I'm going to vacate the interim order. Yes. Let him beware.
Charge sheet is already filed here. 7.
Charge sheet format.
Lords, I have not assaulted the police officer. Page 17 nodidre Swami.
Who has assaulted?
A1 to A3 have done. That is the allegation. My lords, I have been roped in only because I am the owner of the car. I was not even there and when it was done. Page 17 nodi Swami. My lords, page 17, fourth line, my lords. ಅದೇ ಸಮಯದಲ್ಲಿ ಶೀಘ್ರಪಡೆಯಲ್ಲಿ ಹೆಚ್ಚು 60 ನೇರವಾಗಿ ಕಾರನ್ನು ತಡೆದು ನಿಲ್ಲಿಸಿ ಅವರ ಹೆಸರುಗಳು ವಿಳಾಸ ವಿಚಾರಿಸಿದಾಗ ಸುದರ್ಶನ್ ಕರ್ತವ್ಯ ಶೆಟ್ಟಿ ಮತ್ತು ಅರುಣ್ ಶೆಟ್ಟಿ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ದೆನ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಅಲ್ಲದೆ ಶ್ರೀಕಾಂತ್, ಶಶಿಕಾಂತ್ ಹೆಬ್ರಿ, ತೇಜಸ್ ಬೈಂದೂರಿನ ಪ್ರಜ್ವಲ್ ಇವರುಗಳ ಸಂಘಟನೆಯಲ್ಲಿ ಸೇರಿ ಹಣ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಕ್ರಿಕೆಟ್ ಬೆಟ್ಟಿಂಗ್ ಹಣ ಹೂಡಿಕೆ ಮಾಡುವಂತೆ ತಿಳಿಸಿ
mean time accused 6 and 7 others have done. The petitioners are accused 6 and 7. The allegation of stopping the police from performing the duties or usage of criminal force are against accused number 1 to 5. While against these petitioners, it is only conspiracy to make money and not the ingredients of offense under section 132 of the BNS.
1 to 3.
1 to 3, all right. So and so. In that light, there shall be 1 to 3, the accused number 1 to 5, 1 to 3. In that light, there shall be an interim order of stay where these petitioners of further proceedings before the concerned court. It is made clear the proceedings against the others would continue. No, 5.
Bill number 5.
The petitioners, the criminal petition 15719. The petitioner is accused number 8. Is before the court calling in question the proceedings in CC 865 of 2023 and its continuance on a split charge that is drawn against the petitioner. The petitioner, along with other accused, get embroiled in a crime in crime number 46 of 2020 for offences punishable under so and so. Synopsis first. The police conduct investigation and file a charge sheet, and the matter is tried before the concerned court as in CC 612 of 2021. The concerned court on the persons available for trial tries and acquits them of all the offences on the ground that the prosecution has miserably failed in driving home the guilt beyond all reasonable doubt. The petitioner at the relevant point in time was not available for trial. Therefore, a split charge is drawn against him in SC
58 of
SC 58 of 2023
connected matters
and connected cases, notwithstanding the fact that accused number 1, 3, 5, 6 and 7 are acquitted of the same offences. A perusal at the reasons rendered for acquittal are as follows, page 148 to 154. The reasons, if the reasons so rendered to acquit the other accused is noticed, it cannot stand different to the accused number 8 in the present petition. If all other accused have been acquitted on the said reasons, if the petitioner is tried even would not end up in conviction. In that light, for an eventuality of an acquittal, permitting further trial would be wastage of precious judicial time. Therefore, I deem it appropriate to exercise my jurisdiction under section 48 of the CRPC, 520 of the BNSS, and obliterate the proceedings against the petitioner. Connected,
connected matters 2875
Allappa, the ಯಾವ accused?
Accused number 3 2
Same petitioner.
Same petitioner.
Same order, common order ಮಾಡ್ಬಿಡಿ. ಅದರಲ್ಲಿ SC ಒಂದು change ಮಾಡಿ. Yes, next.
SC also same.
SC also same.
Same connected matters.
Connected SC.
Accused number 2.
Yes.
Great, Your Lordship.
Number 9.
Shobhaj.
For respondent number 2 in 9.1, charge sheet filed ಆಗಿದೆ.
Entry ಮಾಡಿದೆ. Shall not precipitate ಅಷ್ಟೇನಾ? Charge sheet ಆಯ್ತಾ?
Charge sheet ಆಗಿದೆ.
Yes, comment. Charge sheet ಆಗಿದೆಯಾ? ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡುತ್ತೆ FIR. ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಡಿ. Yes, charge sheet format. ಎರಡೂನಾ?
ಇಲ್ಲ, ಒಂದರಲ್ಲಿ 9.1 ಅಲ್ಲಿ ಅಷ್ಟೇ charge sheet.
9.1 ಅಲ್ಲಿ?
ಅದು ಬೇರೆ
9.1 ಅಲ್ಲಿ ಆಗಿದೆಯಾ?
9 ಅಲ್ಲಿ ಆಗಿದೆ.
9.1 charge sheet format. 9 ಅಲ್ಲಿ?
9 ಅಲ್ಲಿ not allegation against this.
ಅಲ್ಲ, connect. What is the connection?
ಅಲ್ಲ, ಅದು ಸೇಮ್ ಅಕ್ಯೂಸ್ಡ್ ಇದ್ದಾರೆ.
Same crime ಆ?
ಅಲ್ಲ, ಅಕ್ಯೂಸ್ಡ್ ಸೇಮ್ ಇದ್ದಾರೆ.
ಅಲ್ಲ, crime ಬೇರೆನಾ?
ಕ್ರೈಮ್ ಬೇರೆ ಇದೆ.
ಅದಂಗೆ?
Arranging out of the same issue, my lord. Partition property issue, my lord, for that reason.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಲ್ಲ?
ಇದೆ.
Yes, 9.1 charge sheet format. ಇದರಲ್ಲಿ entry modus subsisting will continue to the next date of hearing.
Grateful.
Yes. You are appearing in 9, is it?
9.1.
All right, yes, next.
10.
Yes, sir.
Can I bring to your lordship kind notice the reason for not the request made?
One submission. Today only we came to know about this petition.
Where is Sunil Kumar? Yes.
I filed memo for retirement.
ಹೌದಾ? Yes, sir.
And next week.
ಅಲ್ಲ, ಟ್ರಯಲ್ ನಡಿಬೇಕಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has directed conclusion.
It is going on.
Trial ನಡೀತಾ ಇದೆ.
Trial ನಡೀತಾ ಇದೆ.
ಸರಿ, ಮತ್ತೇನು?
Trial is in progress.
ನೀವು ಯಾರಿಗೆ ರಂಗನಾಥ್?
But for the respondent number 4, 6, 7, 8, 9 and 13 and 15.
ಅಲ್ಲ, issue is simple. 154.
Right, my lord, that whether a prosecution can permitted to put questions in the.
ಅದಕ್ಕೆ that is Tamil Maran, just check that judgment.
That doesn't apply, my lord. That is not.
ಸರಿ.
That Mani Maran's case, it's not, it is regarding hostile principalities.
Correct.
But
Without
here, my lord,
without declaring a witness hostile, can you put leading question or clarificatory questions which are leading in nature? That's all.
The nature of evidence, my lord, which is given by PW1. She is the mother of disease.
ಅದು ತೊಂದ್ರೆ ಇಲ್ಲ. We are only on a legal issue. Will not enter
Has
into all
not
that.
exhibited any hostility to the prosecution.
No, we'll
Like,
see.
That, my
senior
lord,
is
the
ready.
facts has to be examined.
Already then can't I'll see if you want.
1 week ಯಾಕೆ
My
ಬೇಕು?
lord, that please, your lordship.
1 week ಯಾಕೆ ಬೇಕು?
We have
Tuesday?
to collect all the depositions.
Monday, Tuesday, Wednesday, not trial is going on. Your lordship take it up on Thursday.
ಆಯ್ತು, Thursday. Next Thursday.
Yes.
1 week ಆಯ್ತಲ್ಲ.
ಇಲ್ಲಿ.
List next Thursday in the fresh matters list. They heard the learned counsel P. Prasanna Kumar for the state, special public prosecutor P. Prasanna Kumar for the state, and learned senior counsel Hasmat Pasha appearing for R2, 11 and 12. R2, 11 and 12. Registered to delete the name of Sunil Kumar as appearing for his R2, 11 and 12 and print the name of
On record counsel is.
the advocate on record yaru?
Lord, senior is yet to file a memo of appearance through his colleague.
Counsel ಅವರು.
Counsel yaru? ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಲಾ?
Kariyappa.
Oh, Kariyappa, so and so. And Rangnath Reddy for the others. List on Thursday in the fresh matters list.
Please, grateful.
But simple issue, we should finish it that day itself.
Yes, yes.
But Maran is for the incurium of another judgment. Which I would bring.
ಅದು ನಾನ್ ಬರೆಯಕ್ಕಾಗತ್ತಾ?
But it is, my lord.
ಅಷ್ಟೇ.
It's not a larger bench. My lord. Both are of division bench judgment.
You.
No, my lord. Kindly, it may be considered. If this is countenanced, my lord, no admission is safe, my lord. My humble submission is this, my lord. If this is countenanced, then no admission, my lord, elicited during the course of cross-examination would be safe.
That's a different thing. We'll answer on its merit.
Please.
But if you say I have to write something as per in curiam,
There is another authority, my lord.
ಆಯ್ತು.
ಕುಡಿ ರೆಡಿ ಇದ್ರೆ ಹೇಳಬಿಡಿ ಅಂತ ಅಷ್ಟೇ ನಾನು ಕೇಳಿದ್ದೆ.
ಅದು ಯಾವುದೇ ಮುಂಚೆನೆ ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರು ನೋಡ್ಕೊಂಡ್ ಬಂದಿರ್ತಾರೆ. He'll make it per curiam. Don't worry. Yes.
Grateful.
And spitry bail.
Cancellation of bail.
The lordship has directed them to cooperate.
Oh, cancellation of bail either.
The lordship has directed them to cooperate with the investigation.
Ah.
They issued notices to him.
Your Lordship may see the responses which he gives the.
Kodi.
We are appearing before the IO every day.
No problem.
The last 3 days.
No problem.
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಕೈಯಲ್ಲಿ ಬರೆದಿರೋದು ಮೊಬೈಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂದ್ರೆ ಒಬ್ರು ಕಳೆದೋಯ್ತು ಅಂತ ಇನ್ನೊಬ್ರು ಮಗು ಹೊಡೆದಾಕಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದೇ ಕಡೆ ಎರಡು ಕಡೆ ಒಂದ್ಸರಿ ಮಗು ಹೊಡೆದಾಕಿದೆ ಇನ್ನೊಂದ್ ಕಡೆ ಕಳೆದೋಗಿದೆ.
Oh, children have damaged the phone. You ಕೊಡ್ತೀರಾ ಇಲ್ವಾ phone na? If you're not cooperating with the investigation,
We are cooperating.
this is the cooperation.
No, we are cooperating.
This is the cooperation. I'll record this and remove the protection that I've granted. Yes.
ಅಲ್ಲ ನಮ್ಮ ಹತ್ರ ಏನೋ ಕೊಡ್ತಾ
ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಐಒಗೆ ಫೋನ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು. ಇರೋ ಫೋನ್ ಕೊಡ್ತೀವಿ. ನಮ್ಮ ಹತ್ರ ನಂಬರ್ ಇದೆ, ನಂಬರ್ ಕೊಡ್ತೀವಿ. They can retrieve my alert from the.
No, mobile device they needed because the conversations are supposed to have happened there and many other incriminating material has to be recovered from them.
The petitioners are before the court.
We will produce my alert. I will ask them to.
ಯಾವಾಗ? Tomorrow?
By next week.
No, why? You're daily appearing before the IO. Produce it. Or I'll vacate the protection that I've granted. Let you be taken into custody. Custodial interrogation ಮಾಡ್ಲಿ ಬಿಡಿ.
29th.
ಏನು?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ.
ಯಾಕೆ? ಅದೇ ಮುಹೂರ್ತ ಚೆನ್ನಾಗಿದೆ.
ನೆಕ್ಸ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದ ಆ ಡೇಟ್ಗೆ.
ನೋಟಿಸ್ 29th ಇದೆಯಾ ನೆಕ್ಸ್ಟ್?
29th ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ. ನಿನ್ನೆ ಅಪೇರ್ ಆಗಿದ್ರು.
But let them produce because this start writing these kind of letters. There's no hint. It shows Melody is not going to cooperate with investigation.
This court on 9/6/2026 had passed the following order. The petitioners were directed to appear before the investigating officer and cooperate with the investigation. The learned SPP would now submit that the petitioners, though appear, would not cooperate for investigation, as the mobile phone that is sought for the purpose of investigation is replied to by a letter contending that the children have broken it. The learned counsel for the petition would now submit that the mobile phone would be produced before the investigating officer on the 29th, the date on which he has been directed to appear. Only on this score, the interim protection stands extended. It is made clear if there is any non-cooperation from the hands of these petitioners, the protection would stand automatically vacated. Yes, next. List on 1st July.
Please.
Sitchu, golden retriever and Sitchu.
Please.
Yes, sir.
My lords, two submissions, my lords. The first submission is that on the basis of certain videos that have come into our possession, we have the videos also. There's cruelty on the animals. On that basis, we've filed the FIR. Subsequently, in terms of the animal case rules, the respondent number 2 has relinquished the dogs in our favor. This is something that is recognized under law. So therefore, the dogs are currently in our custody. Both of these issues have not been considered by the magistrate while passing the impugned order. I already pointed out in the previous date, my lords, CUPA's judgment.
Now the dogs are directed to be handed over to.
Please, my lords.
All the dogs.
All dogs.
You had 9.
9 dogs. Case and counter case. Last date, my lords, I had filed the NCR which was registered by the police. 7th of February.
What complaint did you register?
The neighbor, my lords, had taken her dog outside the house and ಅಲ್ಲಿ ಹೊಲ್ಸ್ ಮಾಡಿತ್ತು ಅಂತ ಮಾಡಕ್ ಹೋಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ಪೊಲೀಸ್ ಡೈರೆಕ್ಷನ್ ಕೇಳಿದ್ವಿ.
9 ಒಂದೇ ಸರಿ ಕರ್ಕೊಂಡು ಹೋದ್ರಲ್ಲ?
ಇಲ್ಲ ನೇಬರ್ ಅವ್ರದ್ದು they have pet dogs and they were.
Oh, the neighbor is the complainant here, is it?
They have complained to PETA.
That's correct. Please. They are the complainants.
Please.
How many dogs did the neighbor have?
Those things are not there.
9.
ಇಲ್ಲ ಅವ್ರದ್ದು ಎಷ್ಟಿದೆ ಅದು ಗೊತ್ತಿಲ್ಲ. ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಫಸ್ಟ್ ನಾವೇ 7th February.
ಅದಾದ್ಮೇಲೆ ಕೌಂಟರ್ ಕಂಪ್ಲೇಂಟ್ ಅವರು 14th ಕೊಟ್ಟು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿದ್ರು. ದೇರ್ ಆಫ್ಟರ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೈ 9 dogs were taken into custody, PF ಮಾಡಿದ್ರು.
Our dogs ಕರ್ಕೊಳ್ಳಿಲ್ವಾ?
ಅವ್ರು ತಗೊಳ್ಳಿ.
Because you are ill-treating the dogs.
That's the allegation that they have made.
My lords, I am not concerned between the
Of course, you are
interstate
only
dispute.
concerned with dogs.
That is all.
Respect to relinquishment, my lords, page number 75 may kindly be taken. Affidavit ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. Signature of the complaint.
Where is the relinquishment?
Please,
Page 75.
Page 75, my lords. Annexure K.
Without my signature, the same has been notarized.
Animal relinquishment letter.
Letter ಅಲ್ಲಿ coercion.
One ನಿಮಿಷ. Yes. Affidavit. What's your name?
Ramesh. Ramesh.
ನಿಮ್ಮ ಹೆಸರಾ client?
Client.
Correct.
Respond number
Yes.
2, Ramesh.
Where is Ramesh's signature here?
My lords, on page 76, second page, his signature is there.
Signature ಇದೆಯಾ?
77 ಅಲ್ಲಿ.
77
ಅಲ್ಲಿ.
Animal relinquishment letter. ಇಲ್ಲ ಇದೆಯಲ್ಲ?
It is under coercion which was taken. I was threatened that if I don't sign this letter, then I will have to face dire consequences.
Oh.
At the end of the day, they have already made frivolous allegation, my lord, saying that I have sexually exploited the dogs, ABCD ಅಂತ ಹೇಳಿ.
Sexually exploited the dogs? What do you mean?
Harassment ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Sexually exploited the dogs. Dogs?
Harassment ಮಾಡಿದ್ದಾರೆ. Complaint.
ಆಮೇಲೆ?
That is the allegation which they have placed. And my lords, relinquishment letter ಮಾಡಿದ್ದಾರೆ. The deed is the affidavit is executed at page 75-76. It does not bear my signature. After obtaining the letter, they went to a notary and they have got it notarized. They have enclosed the letter along with it, and they have stated that I have relinquished my rights over the animals. That's what they have done.
In their application that they have filed, they acknowledge the relinquishment. There is not a whisper of any coercion, forgery, or anything of that sort.
Where is the complaint?
My lords, Annexure D, page 47. Second paragraph.
How old are you?
Lords, I am 43 months.
Those are only the screenshots. The videos also we have.
On the iPad?
Yes, please.
Could you? Who has shot those videos?
My lords, the neighbor.
Against whom I had filed complaint in first week of February.
Lordship, you have to play this.
Seriously? You're beating the dogs.
Since I have not seen.
Notice, take. Let him also see. Yes.
The stick breaks. He picks up the broken stick. He starts beating them again.
ಅಲ್ಲಿ ಬೇರೆ ಏನೋ ನೋಡ್ಬೇಡಿ, ಅದ್ ಮಾತ್ರ ನೋಡಿ. It is his iPad.
Kick the dog. Yes.
Right. And what is the sexual exploitation allegation?
ಅವ್ರು ಮಾಡಿರೋದು.
Is that the complaint? ಇಲ್ಲ ಇದೆಯಲ್ಲ, correct.
Please, alleged sexual assault.
Assaulting, apologies.
Are you a dog breeder?
No.
Then why do you need 9 dogs?
Same thing was
Then
asked.
CCTV ತರ ನಾಯಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲ ಕಡೆ?
I had my lords, few dogs at my home and few dogs were at the friend's home. ಎಲ್ಲ 9 dogs not ಇರ್ಲಿಲ್ಲ. When my lord the incident happened, I had only custody of 4 to 5 dogs. My lords.
I'll dictate at 2:30.
Please,
Now it's in your custody, ಅಲ್ಲ?
ಇಲ್ಲ.
My lords, we've given it to foster homes, my lords.
Adoption already 7 ನಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 2 ಕ್ಯೂಪಾಸ್.
Adoption to whom?
My lords, to families, my lords.
To families. How do you know that they will take care of the dogs?
When
Are you monitoring them?
we go through a process, my lords. There's a background check that is done and constant monitoring. Monitoring also takes place.
The IO says
What do you do? ಅಲ್ಲ ಏನ್ ಕೆಲಸ ಇಲ್ವಾ?
ಏನು ಇಲ್ಲ.
ಅದಕ್ಕೆ 9 ನಾಯಿ. ಅದ್ ಸರಿ, ನಾಯಿ ಓಕೆ. ವೈ ಡು ವಿ ಆರ್ ಬೀಟಿಂಗ್ ದ ಡಾಗ್ಸ್, ಕರೆಕ್ಟ್? Yes, we'll pass order at 2:30.
Please, my lords.
Serial number 13. The husband and wife, the issue, my lord. The mother-in-law is the complaint. In page number 32 is made an observation earlier, my lord. The kidnap case registered by the wife of mother-in-law of the victim.
ಯಾರನ್ನ ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ರಿ ಸರ್?
Wife.
ವೈಫ್ ನ ಕಿಡ್ನಾಪ್ ಮಾಡಿದೀರಾ?
ಇದು ಅಲಿಗೇಷನ್. ಬಂದು ಕರ್ಕೊಂಡು ಹೋಗಿರೋದಕ್ಕೆ ಕಿಡ್ನಾಪ್ ಕೇಸ್ ಹಾಕಿರೋ.
They're living together now.
Yes, my lord.
ಮದುವೆ ಆಗಿಲ್ವಾ?
ಮದುವೆ ಆಗಿದೆ ಸರ್.
ಮತ್ತೇನ್ ಕಿಡ್ನಾಪ್?
ಲವ್ ಮ್ಯಾರೇಜ್ ಆಗಿದೆ. ಬಂದು ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ಅವಾಗ ಕಿಡ್ನಾಪ್ ಕೇಸ್ ಹಾಕ್ಬಿಟ್ಟು ಕಳಿಸಿದ್ದಾರೆ. ಅತ್ತೆ ಮನೆಗೆ ಬಂದು ಹೋಗಿರೋದಕ್ಕೆ 447 ಹಾಕಿದ್ದಾರೆ. ಟ್ರೆಸ್ಪಾಸ್.
The petitioners, the first petitioner, accused number 1, and the daughter of the complainant are in love. They get married. The marriage is opposed by the family of the second respondent complainant, and the daughter is taken away by the complainant. The husband, the accused number 1, is said to have entered the house of the complainant and takes his wife and are now living in his house. In the light of the husband coming into the house of the complainant and taking his wife, the crime has sprung for offences under criminal trespass and abduction. In the light of the aforesaid facts, there shall be an interim order of stay of further proceedings. Query the petitioner to the next date of hearing.
R2 is not served.
Huh?
R2 is not served.
Fresh matter.
Fresh matter.
First time ಬರ್ತಾ ಇರೋದು.
Notice has.
One HCGP, 2 emergent.
Date may be, they are set, may be set.
Yes.
Obvious.
ಏನಾಯ್ತು?
So, my
Day
lords,
for yesterday's matter.
yes, my lords, the court suggested, is there a possibility
Settlement,
of this?
yes.
So what we would request is whether it could be sent to a mediator, my lords, and because they're at loggerheads, whether we are in a position.
I proposed in the morning and last night that the client says both the councils can talk, not the.
No, don't bring in a third party
mediation,
here.
they are not.
Don't bring in a third party. If you want me to answer on merits, I will answer.
Oh, no, that's different,
Not a
my lords.
problem
Now
at
the
all.
point is whether there is
It's
a
only
possibility of a settlement.
if you can, I will.
Lords, I have offered, we both can, he can talk to them.
Yes,
because our client
absolute.
says, instead of a third party.
No, we will not send it to mediation.
Time bound
All
manner
right, my
within a
lords,
week.
we will see, we will look
Yes,
into.
I'll take it on, we'll give you 10 days time.
Yes, sir.
List the matter was heard and reserved. At that point in time, this court felt that since the warring founder directors could sit across and draw a settlement if possible. Therefore, the parties to the list submit if 10 days time is granted, possibilities of settlement would be explored and placed before the court on the next date. List the matter on 9th July.
Please.
Yes.
Lords, I only request, in the meanwhile, since we are open to settlement, let them also not precipitate the NCLT matter. Because
How
your
will
lordships
all-
have stayed.
In the light of the settlement, talks of settlement being projected, no other proceeding need be precipitated either by the petitioner or by the respondent.
Both the parties.
Yes.
Then it's fine.
10 days ಅಷ್ಟೇ, ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ.
Yes, my lords.
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್
ಹೌದು,
ಬರ್ರಿ.
ಹೌದು.
My lord, I'm submitting withdrawal memo for both 15 and 15.1. my lord.
Thank you, sir.
Much obliged.
16.
My lords, this is a case of criminal trespass and house trespass, my lords. I am the owner and in possession of the property,
In the
my lords.
meantime, next.
I'm grateful.
I request for a password. Password. I request for
Pass over, ಯಾಕೆ? Come on.
17.
Yes, sir.
Senior is engaged in another court, my lord. May I
No
request for
problem,
pass
tell
over,
me,
my
sir.
lord.
Notice is not, ತಗೊಂಡಿದ್ದೀರಾ notice?
They are connected.
Interim protection ಕೊಟ್ಟಿದ್ದೀನಿ
Your
ಅಷ್ಟೇ.
lordship may recall, no, this is the matter. They made a submission saying the PPS filed a complaint. It is
Ah,
not the
correct,
PP.
yes. 31, 32.
31, my lord, for violation of
yes.
31,
Anything
my lord.
else, sir?
No, my lord, senior is engaged in another court, my lord. Kindly pass over.
This should be over today, sir.
Please, my lord.
This should be over. 31, 32 is permissible, he has told. There is nothing else in this.
No, my lord, there are merits, my lord. Kindly pass.
Oh, yes. Again, it is between the mother and the son.
Yes, sir.
You are the son, na?
I am the son, daughter-in-law, and a third party. Against 3 persons, my lord, DV Act case has been registered. And my lord, they agreed with the same order, my lord, prefer a revision petition, though my lord, revision
No,
is
that's
not
all right.
maintainable.
Why are you in dispute with your mother?
My lord, I am not in dispute, my lord,
Then what,
because of the, at the instance of my sister, my lord, all these are.
No,
cropping
no,
up.
nothing. Yes.
Your lordship may kindly pass over, my lord.
If you are at loggerheads with the mother,
No,
we
my
will
lord.
not permit you.
Last time also, learned friend took the time saying that Passover, saying that.
At sharp 2:30, I'm taking it. If you don't submit, I'm going to dismiss it straight away. Yes. Madam, then ಮಾಡಿ 2:30 sharp ತಗೋಬೇಕು. ಯಾವ ಮ್ಯಾಟರ್ ಇದ್ರೂ ಪರಲ್ಲ. Yes.
Obliged.
18. Counsel for the respondent. We have filed wakalat this morning at the
138,
counter.
138, my lord. It's the same matter that your lordships had passed an order in the default sentence. It's the
Correct,
same
yes.
petition.
Your lordship, this matter is still, the trial is going on. It's been 5 years. It's at the stage of cross-examination of the complainant witness. They've cross-examined 5 times already in 2023. Because the counsels have changed, they've recalled the witness multiple times. They have, it was to be listed for arguments, and now the trial judge has.
You filed your wakalat now?
In the morning at the.
All right, you will file your objections.
We will file, we have not received a copy of the IA.
We've already served, my lords. We've already
Copy of
served.
the IA?
IA.
What IA?
Just no.
IA for stay.
Stay.
IA for stay is not served on us.
ಆಯ್ತು ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಪೂರ್ತಿ.
Great.
Heard the learned counsel, Srimati Kirti Reddy, and the learned counsel so and so undertakes to enter appearance for
Respondent.
the sole respondent. So the respondent registry to print the name of so and so. Petitioner to serve set of papers upon the counsel for the respondent, if not already served.
Please.
List the matter 2 weeks.
2 weeks.
The learned counsel for the respondent seeks 2 weeks time to file statement of objections. List the matter on 16th July. The fresh matters list. Interim order subsisting would continue till the next date of hearing.
Obliged.
Sorry for interrupting. My matter was dismissed, my lord. The matter is settled between the parties. my
Which
lord.
one, sir?
Serial number 7, my lord. List 2, serial number 7, my lord. Day before yesterday.
Charge sheet file ಆಗಿದೆ ಅಂದ್ರೆ ಅಷ್ಟೇ.
Matter is settled, my lord, time stage.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಹೌದು. 4 o'clock today, my lord.
ಆಯ್ತು 4 o'clock. ತೊಂದ್ರೆ ಇಲ್ಲ. ಹಿಂಗ್ ಡಿಸ್ಮಿಸ್ ಆಗೋ ಬದಲು ಹಂಗ್ ಡಿಸ್ಮಿಸ್ ಆಗಿ. Yes.
19.
I appear for the petitions, my lord. It's a classic case of misuse of powers.
Classic case of?
Misuse of powers, my lord. Unwarranted interference by the police authorities in a civil dispute. The only allegation in the complaint at page number 24, my lord, is that I have sublet the property. I'm in a possession of the property while registered these.
The main time. Yes.
Grateful. My lord, may I request for hand delivery on the phone?
Why?
My lord, because I'm running a retail shop there, my lord. In the guise of this FIR, they are coming on a daily basis. Grateful, my lord.
20.
At page 34, my lord.
Respondent number 2.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
Notice has been out.
Last time notice ಆಗಿದೆ.
The learned ಅಲ್ಲಿ ವಕಾಲತ್ ರಿಜಿಸ್ಟ್ರಿ ಹಾಕಿ.
May I make one request? It seems to be that petitioner has some psychological issue. Your lordship allow us to investigate, because what transpired, my lord, during the course, even the petitioner also was tried and beaten, and the case has been registered for that as well. Now both cases have been investigated by the same officer. So your lordship allow us to investigate, and your lordship can protect him.
And don't take any coercive steps against him. Cooperate with the investigation.
My lord, may I request only this? My lord, some other hospital for the treatment, the reason being, please, my lord, I have been instructed to say that this particular respondent number 2 is visiting the hospital, threatening the mother as to what made circumstances. Please, my lord, if your lordship would peruse
No,
page 34.
all those things won't happen. It will be a plain investigation. If he wants to interfere, then I will direct the police to take action against him.
And also the, please, my lord, the inmates who are taking the treatment also of particular.
Nobody will be disturbed, sir. Only investigation will take place. I will record everything.
Please.
All right?
Since he is in, my lord, psychological.
Don't worry, yes.
No, I'm making that submission.
Totally 3 incidents. my
No
lord.
problem, sir. ಅಲ್ಲಿ ಹೋಗಿ ನೀವು ತೊಂದರೆ ಕೊಟ್ರೆ ನಿಮ್ಮನ್ನು I'll ask you to be taken into custody.
3 ಪ್ಲಾನ್ ಮಾಡ್ಕೊಂಡು ಇವ್ರು ಮಾಡಿದಾರೆ madam.
ಪರವಾಗಿಲ್ಲ.
But
144 has to be imposed.
We'll see.
Give this person alive, 144 has to be imposed.
Wait. The learned SPP submits that there are cases registered against the complainant and against the petitioner. Therefore, against the petitioner, and it appears that mental instability pervades through these cases. Therefore, submits that.
Your Lordship, don't record that, my lord. But we will look after.
Sorry, Bada. The learned SPP would further submit, in the light of both these cases and the investigating officer being common, if investigation would be permitted, it would be arriving at the truth of the matter, as there are allegations and contra allegations by the petitioner and against the petitioner. In the light of the said submission, I deem it appropriate to permit investigation into the matter, both in the crime registered against the petitioner or the crime registered against the complainant. Therefore, in the garb of investigation, the police shall not harass or take coercive steps against these petitioners. The report of investigation be placed before the court on the next date. 4 weeks sakala. List the matter on 30th July. For 30th July in the fresh matters list, the report of investigation be placed before the court by the next date.
Copies may be there.
Copy kodi sir. The petitioner is at liberty to move the matter in the event the police would deviate what is observed at the hands of this court, i.e. harassment or taking coercive steps.
My lord, since he is in medical treatment, my lord, if he requires any, my lord, further treatment, please, my lord, liberty
That
to.
they will do it, sir. They will not come in the investigating officer shall not come in the way of the necessity of any medical treatment for the petitioner. Yes.
Even in single day, my lord, we are not visited the hospital. It is
Right.
normally submitted. before
We'll
the
see,
court.
sir. So what? Yes.
21. Evidence is already commenced, your lordship.
No, it's in framing of charges. It's on the stage of framing of charges.
If charges are framed,
Lordships, in this matter, my lords, a probate order was secured against me. I came before your lordships and order of stay was granted at page number 84. Your lordships had heard this matter when a civil dispute was arisen, had stayed that matter. Thereafter, my lords, that order was passed on 18th August 25. On September month, my lords, a crime has been registered saying that they interfered with our position and then.
Charge frame agide, madam.
Agide, your
Charge
lordship.
sheet is filed.
As per the e-courts, evidence has also commenced, your lordship. I'll furnish the details.
Yes, sir.
That is on the crime which I filed.
Get the order sheets.
Please.
The petitioner to produce the entire order sheet till yesterday, data. List on
Page 70.
List on 30th in the fresh matters
Okay, my
list.
lords, framing of charges.
30th fresh matters list, yes.
Please, my lords. Tomorrow it is there, my lords.
30th fresh matters list, don't worry.
Tomorrow.
Produce the order sheet completely. Even if they frame charges, if they are framing tomorrow, I'll consider it. Don't worry.
No, it's on page 70, lordships.
You don't worry, just get the complete order sheet.
Please.
Yes.
Bless.
22.
Lord, complainant is my wife, my lord. This is the fourth complaint, my lord, filed by her.
Only wife?
Only wife, my lord.
Fourth complaint.
Fourth complaint, my lord. My lord, the first complaint is at page number 41, my lord.
ಏನ್ ಅಷ್ಟೊಂದು ಮಾಡ್ತಾ ಇದೀರಿ ಮತ್ತೆ ನೀವೀಗ? ನಾಲ್ಕು ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು.
41 ಅಲ್ಲಿ ಪೇಜ್ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಮೈ ಲಾರ್ಡ್, ವಿಚ್ ಇಸ್ ರಿಸಲ್ಟೆಡ್ ಇನ್ NCR. ಅದನ್ನ ಸ್ಪ್ಲಿಟ್ ಮಾಡಿ 3 ಸಪರೇಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ತಾರೆ ಮೈ ಲಾರ್ಡ್. ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಸ್ಟೇಡ್ ಮೈ ಲಾರ್ಡ್. 498
ಪೇಜ್ ಸ್ಟೇ ಆಗಿರೋದು
58 ಮೈ ಲಾರ್ಡ್.
Tag along with 58. List them both same order. List them both on.
ಅದರಲ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಆ ಇಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತ ಇದಾಗ್ಬಿಟ್ಟಿದೆ. ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಮೈ ಲಾರ್ಡ್.
ಆಯ್ತು, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಮಾಡಿ ಲಿಸ್ಟ್ ಬೋತ್ ಆನ್ 23rd July. Next one HCGP to emergent notice. Next.
Lord, the petitioner is a 20-year-old boy, my lord.
20-year-old
boy who has been alleged, who has been taken into custody only on the allegation made in the dying declaration, my lord.
This is what, yes.
My lord,
What the SPP or ask him to come.
Petitioner is a brother-in-law of the deceased, my lord.
Who is killed?
My
Who dies?
My lord, the brother-in-law of the petitioner, who is Mr. Naveen.
So what?
My lord, before my lord going into the allegation, my lord may kindly come to page 6, my lord. It's the true fact of the case. What has happened?
Wait,
my
you
Please.
copy ಇದೆಯಲ್ಲ ಎಸ್ ಪಿ ಪಿ ಅವ್ರಿಗೆ ತಗೊಳ್ಳಿ. I'll take it 2:30. Yes. Ask him to come at 2:30 ಪರವಾಗಿಲ್ಲ. Next.
24.
Lords, I am appearing for the petitioner for release of vehicle, my lords. For release of vehicle.
ಯಾವ ವೆಹಿಕಲ್ ಸರ್?
Maruti Swift Desire, my lords.
ಏನ್ ತಗೊಂಡ್ ಎಕ್ಸೈಸ್ ಆಕ್ಟಾ?
ಅಲ್ಲ, my lords, ಇದು ಆನೆ ದಂತ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು. ದಂತ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ ಕಂಪ್ಲೇಂಟ್. I have not made as an accused, my lords.
ಇರ್ಲಿ ಬಿಡಿ.
Forest Act under ಅಲ್ಲಿ ಇದು ಮಾಡಿ.
The CGP is directed to answer notice for the respondent. ಆಗಿದೆ ಅಲ್ಲ?
Yes, my lords.
Yes. List on 6th and the fresh matters list. Look into it, madam. ನೀವು ಮತ್ತೆ ಅದೇ ಕೆಲಸ ಮಾಡ್ತೀರಾ ಇರಿ. Yes.
Much.
25.
My lords,
Notice ಆಗಿದೆಯಲ್ಲ?
charge sheet has been filed in this case. I may be permitted to withdraw this petition and file.
Yes, charge sheet format.
26.
Petitioner is the de facto complainant. Impugned order is at page number 27, my lord. My lord, this is amount has been frozen. The total fraud, my lord, is about 3 crores 68 lakhs. Everything is being transferred through online, my lord, from my account to the accused account, my lord.
Now we have sought
I've sought for release, my lord.
release of that amount. Yes, madam.
Substantial documents have been found in the charge sheet where they have frozen, my lord.
I'll take notice.
ನೋಟಿಸ್
already
ಆಗೋಗಿದೆ
taken.
ಮೇಡಮ್.
File.
ನೋಡಿಲ್ವಾ?
File.
ಅವ್ರು ಸ್ವಲ್ಪ ಗೇರಪ್ ಆಗಿದ್ದಾರೆ, ನೀವೇ ಗೇರಪ್ ಆಗ್ಬೇಕು.
File misplace ಆಗಿದೆ.
ಮಿಸ್ಪ್ಲೇಸ್. ತೇಜಸ್ ನೀವು ಇದ್ದೀರಾ?
One matter.
One matter.
The difficulty is, my lord, the amount which has been frozen, Mumbai alli, Pune alli, Kolkata alli, several places.
You should look into it.
Kindly pass over it.
Pass over, yes.
Be taken at 2:30 kindly.
I pass over. Yes.
27.
That's 223. Provi's compliance is not done, my lords, it has to go back.
Prosecution complaint you have filed.
My lords, on merit also, my lords.
On merit and ಅಲ್ಲೇ ಹೋಗ್ಲಿ, ಆಮೇಲೆ ಬನ್ನಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Parvinder will follow and close it.
Please.
ಇಲ್ಲಿ ಕೊಡಿ. The petitioner is before the court, calling in question the entire proceedings in special case 52 of 2025. The petitioner is sole accused,
Sole accused.
sole accused gets embroiled in a crime on interception by the officers of the Directorate of Revenue Intelligence at Mangaluru Airport, seizing ಎಷ್ಟು ಗ್ರಾಮ್?
5995.51 grams.
5,995 grams of gold valued at 1,34,44,457. Proceedings were taken up against the petitioner and ಅದ್ ನಡೀತಾ ಇದೆಯಾ?
ಅದು ಇನ್ನೂ pending ಇದೆ. That is
And
also.
those proceedings are pending consideration at the hands of the concerned court. The enforcement directorate then registers an enforcement case information report -ECIR for under the provision for violation of under the provisions of the PMLA. Summons were issued to the petitioner, then the enforcement directorate have filed their quote unquote prosecution complaint before the concerned court. On the prosecution complaint, it transpires that the concerned court takes cognizance of the offense and issues summons to these petitioners. The issue is prior to the taking of cognizance whether the accused are heard in the matter. They are admittedly not heard. there was certain obfuscation with regard to whether for the proceedings under the PMLA, the procedure stipulated in section 223 of the BNSS should be followed or otherwise, which would be hearing the accused prior to the order of taking of cognizance. The apex court in Parvinder has steered clear the controversy by observing that even for the offences under the PMLA, the special court prior to taking of cognizance must follow the procedure as stipulated under the BNSS. In that light, leaving open all the other contentions on the merit of the matter, I deem it appropriate to obliterate the order of taking of cognizance and remit the matter back to the hands of the concerned court to follow the observations made by the apex court that are quoted here and above. In that light, the petition is allowed in part, the so and so the concerned court shall now pass necessary orders in accordance with law within 8 weeks from the date of it being taken up. All the petitioner is reserved liberty to knock at the doors of the appropriate fora in the aftermath of the order.
Yes, right.
Yes.
The affidavit was filed on the last date, my lords, indicating the value of the property.
Yes, sir. I
have some instructions to make. This judgment what my friend showed, that was the 2020.
Apex court.
2023 judgment. Thereafter, my lords, we had gone in one of the Windsor matters before the Supreme Court.
Which matter?
We had gone before the Supreme Court. There, my lords, what has happened is, my lords, of course, in that matter, my lords, once the PC is filed and it is at HPC level, this matter, lords, once the proceeds of crime is determined and my lords, a cognizance is taken, my lords, the Supreme Court held that cannot be touched or that cannot, the money cannot be utilized from such properties.
Which judgment, sir?
Not the argument was, my lords, before the single judge here, lords, the argument made was that the adjudication authority, the matter was pending before the adjudication authority. And before the single court, my lord, they sent it, the court held that all the issues should go before the adjudication authority, subject to the fact of the salaries to be released. Now, salary was released. On that, we went to writ appeal before the division bench. Division bench also held that no salary has to be paid. In spite of we making
Justice Shyam Prasad.
Please. After that, my lords, the division bench held that no salary, let the salaries be paid. In spite of we making an argument that everything is a proceeds of crime, it cannot be touched. And thereafter, my lords, we filed an appeal before the Supreme Court. Supreme Court, my lords, in this matter held that even salaries cannot be given. So therefore, my lords, once the PC is determined with respect to those properties.
Supreme Court in this held, once the court was remitting the matter back to the authorities, it did not have jurisdiction to order or observe anything apart from its remittance. Incidentally, it was salary to be paid. Salary no kodak baralla anta.
That in fact, their petition was that if my lords were to see the para number.
Defreezement of the account for the purpose of payment of salary was what was directed. Correct.
Please, my lords, please admit on that part. But our submission was with regard to this once the POC is determined, my lords. Now, my lords, what they're asking is, my lords. Sorry. Now, what they're asking is, my lords, that they'll give the FD equivalent of the property. My lords, my submission is, my lords, once the POC is determined and the matter is at the stage of HBC and the matter is being considered as final arguments before the adjudication authority. Now, my lords, here they come and say that we'll give an FD. My only submission, my lords, is in view of this, my lords, that perhaps at this point of time, they to seek that we'll give an FD may not be inappropriate, particularly of the fact that, my lords, everything is that property is derived from the proceeds of crime. That's my lords, my only submission is let them go before the adjudication authority and seek this remedy, my lords. My only submission, because you'll open Pandora's box, my lords, everyone will come and say, I'll give FD. My lords, we don't even.
That's what the Supreme Court has permitted.
That was in 2023, lordship. That was in 2023. The judgment, whatever was pronounced, was 2023, my lords. My submission, my lords, is that, my lords, once the property is derived from the proceeds of crime, my lords, we can't use it, we can't touch it. That's what the.
No, but equivalent FD kotra aitalla. Proceeds of crime is protected.
My lords, once my only submission is, once the proceeds of crime is derived and also we have determined that this property is bought from the very proceeds of crime, my lords, then my lords, it has to be decided only by the adjudication authority.
Property
Merits of the matter.
brought in 2008, the alleged incident is of 2009-10.
No, if that is on the merits, my lord, then they have to
That
go
is on
before
merits,
adjudication
absolutely.
authority.
We are before the adjudicating
My
authority.
submission, my lords, kindly.
We'll see. Tomorrow I'll look into this. Adu kodi. Yes.
My lords, maybe on Monday, Monday or
Tuesday. Monday, not sitting,
If my
Tuesday.
lords may consider kindly this part. And particularly, my lords, the matter is pending before the adjudication authority.
Objections, copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
At the final stage, lordship.
ಆಯ್ತು ಸರಿ. We'll see.
And this is at the
Tuesday,
stage of
yes.
arguments.
Same stage.
Same.
Please, oblige.
29.
Transportation of wooden logs, acacia.
ಅದೇ from ಎಲ್ಲಿಂದ ಬಂತು ಅಂತ ಕೇಳಿ.
4 years in the charge sheet ಇಲ್ಲ. Crime register ಮಾಡಿ. I am the owner of the vehicle. No progress in the trial. My lords, that is one thing. In the FIR, there is no allegation as such. I have I have cut and removed from the forest land. There is no allegation in the FIR.
Your lordship, it may
From
be
past
taken up
4
on
years.
Tuesday, lordship. It may be taken up on Tuesday, lordship. There is an order passed dated 27/3/26 regarding.
ತೊಂದರೆ ಇಲ್ಲ. List the matter on Wednesday in the fresh matters list. Further proceedings shall remain state till the next date. Yes. In the fresh matters list. Yes. Next.
30.
But ಅವತ್ ಮತ್ತೆ ಟೈಮ್ ಕೇಳಬೇಡಿ, ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ನೀವು ಕೇಳಲ್ಲ, ಹೇಳ್ದೆ.
Seek to assist on behalf of the petitioner, my lord. CEO of the company.
ಗೊತ್ತಾಯ್ತು.
Acquisition.
KDB, KSFC.
I'll be guilty of, my lords, troubling your lordships with the facts for the 5th time if I take your lordships to the facts.
ತೊಂದರೆ ಇಲ್ಲ, ಹೇಳಿ.
No, I don't want to trouble.
I'm not convinced in the first instance itself. ಇಲ್ದರೆ ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ದೆ ಅವತ್ತು.
That this is similar, my lords. In fact, one occasion where this honorable court has had, my lords, an occasion to adjudicate similar facts. Your lordships, my lords, have been inclined to pass an interim order, my lords, staying the operation of the order itself. Now, 2016 was the date of purchase. At which point of time, my lords?
Now you tell me, madam, it is purchased prior to everything springing. 2017 is your complaint. 2016 is the purchase.
The loan.
Predicate offense ಏನಾಗಿದೆ?
I have been dropped, my lords. I have got a brief.
Oh, dropped, correct.
My lords, the list of dates, only 4 dates are important.
ತೊಗೊಳ್ಳಿ madam.
My lords, in February 2016, the first loan was taken, my lords.
First,
The loan was taken.
drag the mic to your side.
This
madam.
loan was taken in 2016, my lords. There are two components. One was directly paid to the KIDB and one given it to the company. And my lords, in 2016, my lords, 25/2/2016, loan was disbursed.
Loan was dispersed
On
to the
20
company
Yes, my lord.
by the KSFC. He was its CEO.
He was a CEO.
All right.
Please, my lords. Then, my lords, he purchased a property on 21/5/2016. This property was purchased,
For what is the amount? 78 lakhs.
78 lakhs.
No, my lords, 15 lakhs. Kindly, my lords, I have produced the sale deed also.
All right, 15 lakhs.
15 lakhs. Then, my lords, that money was refunded back by KIDB on 8/3/2017.
Correct.
Then, my lords,
Money goes to the account of the
company,
company.
my lords, two times. One is to the company in the beginning 2016 for building and construction work.
Correct.
And part of it gone to KIDB for acquisition of the land.
So it did not happen, KIDB refunds it.
Refunds it, my lords, in 2017, my lords. Then, my lords, the wife receives salary. And
Who receives?
The wife receives salary from this company, wife of petitioner number 1. my lords. She receives salary from the company to the tune of 37.41 lakhs without any employment. Her statement is on record, and this money is not accounted for. Thereafter, he also received 10 lakhs. Then, my lords, in December 2018, they purchased a property to show.
No, you are attaching proceeds of crime to the loan availed from the KSFC, which was returned later.
Yes,
That is the proceeds of crime. But it goes to the company.
my lords, the company in turn used this money
to pay salary to
Oh,
people.
that money is used.
Please,
All
my
right.
lords, to people who are not employed.
All right.
And to this gentleman, to 10 lakhs rupees for no reason, my lords.
Hmm.
The statement is there, the wife's statement is there where she admits that she was not working. And she also says that income tax, she has filed Form 16 based on the advice of the company.
But for 6 years, what were you doing?
My lords, we took up the matter after the, we initiated proceedings, my lords.
Predicate offense ಯಾವಾಗ close ಆಗಿದ್ದು?
2021 itself.
My lords, charge sheet was filed. In the charge sheet, may kindly see at page.
Charge sheet is dropped from a
He's
case.
dropped, my
And
lords,
then?
because they could not find anything against him. So
Then how
far
are you
as-
finding
so
something
far,
now?
My lords, we have done our investigation, my lords. In my
Done
investigation.
the predicate offense.
No, my lords, in the ECIR what we filed, pursuant to which we have initiated the investigation, my lords.
When did you initiate investigation, madam? 2026.
Please, my lords.
Correct.
Please, my lords. During the investigation, my lords, we have found some incriminating documents and money trail to show that these are nothing
Madam,
but
2021, he is dropped. No charge sheet is filed against him.
against him, my lords.
All
I'll go
right.
down.
5 years later, you spring into action saying there is money trail.
My lord, there are certain things that has happened in between, my lords.
What
The
happened?
bank has gone to the OA was filed before the DRT.
Yeah.
DRT proceedings were.
For what?
For recovery of money
Of
from this.
recovery of what money?
This money which is supposed to be paid to the bank, which has been misused.
Which money?
Money which they have received from the KIDB, my lords.
No, KIDB, madam, returns the money
Please, my lord.
to the company.
Please, my
No
lord.
acquisition takes place.
No acquisition. They dropped.
The amount is in the coffers of the company.
Please, my lords.
That was a loan taken from KSFC for the purpose of acquisition in KIDB.
Please, my lords.
The company does not pay it back to KSFC.
Please, my lords.
Does
No,
not pay?
no.
Yes,
And
sir.
the-
I'll state the facts, my lord.
Why, no, why the, it was not paid back to the KSFC?
My lords, more than 80% of the amount is already paid. What
Already
remains-
Allah, when you got back the amount from KIDB,
My lords,
the loan that you had taken
my lords.
was not put into use. So you had to give it back.
My lords, there were two aspects, my lord. Though it does not concern with the facts, my lord, that I'm troubling your lordships with in this petition, my lord. Since, my lords, for the sake of completeness, I'll just state in 2 sentences. KSFC would give me loan for plant and machinery and operational expense. It is not that only for the purpose of acquisition of the land the loan was given.
All right.
Now, there was some delay on the part of the KSFC to disperse the loan, for which, my lord, the company would say, I will pay the loan in advance because let not, my lord, the allotment letter had a stipulated timeline. Certain amounts were paid. So for the amounts that were already paid, KSFC would say, all right, you have already paid the money which KSFC had to give to KIDB. I'm now giving it to the company. This is not related to me at all. Not a single rupee of the loan amount I have received. Now, my lords, the
What is
amount,
that 37 lakhs your wife receives?
37.
my lords, 37 lakhs is when she was there, my lords, as an employee of the company, which happened several years after the property was, my lords, purchased by me in 2016. Now, my lords, I asked my
Salary received when?
salary received for 2 years.
When?
During 2018, my lords, 2017 to 2018, 18 to 19. My lords, she has declared income tax or Form 16. My lords, these are all part of investigation. My lords, the limited question, my lords, I am assisting your lordships is, can now, my lords, the ED virtually step into the shoes of a loan recovery agent? Now, my lords, under section 2U, there are 3 aspects, my lords. One is for a recovery of the proceeds of crime. The 2018 amendment, which was by way of an insertion to the amendment, to the definition of proceeds of crime, said, if the proceeds of crime are not being able to be traced within the territories of the country, then value equivalent to the proceeds of crime.
That's your taking it too far. Yes.
Now, my lords, the ED does not even in their affidavit that they have filed before your lordships say as to how, my lords, they have involved in this entire transaction. Their only singular allegation against me is I was the CEO.
Difficult, madam. Not because what he is saying, because of the clear dates.
My lords, may kindly, if I take my lords to page 16.
He's not, no, according to Pavana Dibur, I told you, there should be 120B.
Yes.
Otherwise you can't.
My lords, 120B is something, my lords, is.
There's not even an offense of 120B in the predicate offense.
My lords, I have done my independent inquiry into this matter.
Straight away covered by Pavana Dibur. Not in your favor. That's the whole problem.
My lords, if I may,
No, ಈ ತರ ಆದ್ರೆ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ಸ್ ಕೇಸು ಹಂಗೆ ಇರೋದು.
my
8
lords,
years ಆದ್ಮೇಲೆ you see the house, oh, this must be proceeds of crime and start.
my lords, we did not do that, my lords. We have done entire analysis of her bank account, how this money was utilized, which is received from the uh, from the KIDV.
No,
how it is used.
as on the day
Yes, my lords.
that you, now we should consider once the accused, those three circumstances where the apex could discharge, acquittal and quashment.
Yes.
So this is the third one, fourth one.
Yes. My lords, in that,
Fourth one in the sense, if he is dropped from the array of accused in the predicate offense, what would be the effect?
please, my lords, for that, my lords, I may be permitted to rely upon one judgment of the Delhi High Court Division Bench judgment.
Toli madam.
Arun Suri.
My lords, the judgment started page 23, my lords. My lords, the relevant,
Idralli
Para 10.
you are also dropped from the array of accused.
is my lord, 61, my lords, para 71.
Para?
Para 61, my lords.
Para 61.
Please, my lord, 71 page number, my lords. Additionally, the learned single judge has erroneously reached to the conclusion, since the first FIR and the consequential charge sheet were quashed by this court and there is no criminal activity, consequently there can be no proceed of crime, thereby failing to attract the offense of money laundering under PMLA. The learned single judge further observed that the money laundering is a standalone offense only in a sense that it has to be tried separately and not that it can survive independently even if the charges in respect of the predicate offense has been quashed or if the accused has been discharged by the competent court with the finding that no offense is made out. Additionally, it has to be seen to by learned single judge that the proceeds of crime stated to be generated by provisional by PIL was already a part of first charge sheet and therefore directorate's power to initiate proceeding is only limited to 4/9/2023. The aforesaid view taken by the learned single judge is flawed on three premises. Firstly, as elaborated in the preceding paragraph, the directorate power to initiate proceeding is not constrained to the four corners of CBI's report or limited to the
No,
findings
there
of the
the matter was challenged before the apex court.
First judgment that my learned friend has submitted, my lord, may I request your lordship to kindly turn to that. That is the subsequent judgment, my lord, the Delhi High Court itself. Para 10 supports my proposition that unless and until it is a case of the ED that the proceeds of crime cannot be traced, value equivalent cannot be resorted to. Kindly have para 10, my lord, of this page number. Arun Suri, the same judgment that my learned friend is relying upon. The lords gets para 10.
My lords, 2018, one more property was bought, which we could not attach because of there is a bank loan on that. Therefore, my lords, we had no choice but to take value equivalent, my lords. That I have narrated in my provisional attachment order, my lord. May kindly peruse the page A60.
Well, post on Tuesday, Wednesday, dictating orders. Next date, yavattal?
28, my lords.
The further proceedings shall remain stayed till the next date of hearing. Yes.
I'm sorry.
31.
Here's the petitioner.
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. Further, in the light of the matter being heard and posted for dictating orders, further proceedings shall remain stayed till the next date.
31.
My lords, appearing to the petitioner, my lords. This is the matter seeking stay of suspension of the LOC, my lords. Issued by
you want to
the
travel
Delhi.
anta?
No, an officer from the Delhi police has logged in.
Ah,
My lords, the
travel permission.
Allah, their
ಹೋಗ್ ಬರ್ತಾರೆ ವಾಪಸ್.
he is not cooperating.
My lords, in
The
similar
grievance of the Delhi police is that despite several notices, he is not responding and is not
Even then,
cooperating.
coordinate bench, Apex court right to travel.
He may be heard. The officer is present. Maybe.
How will I hear the officer?
My lords, may I pass on the joint affidavit filed before this court, my lords,
By
where
whom?
by the complainant and the petitioner, where the subject crime was settled between the parties, my lords.
That's all right. That's a larger issue. We'll decide. We are not on that. No, if you want to travel, you have filed your affidavit of itinerary or something?
Yes, fine.
ಎಲ್ಲಿದೆ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
Annexure F, page 166. Annexure F, my lords.
Page
166, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ?
Itinerary details.
affidavit ಅಲ್ಲಿ.
Lords, we have furnished
File your
itinerary.
affidavit.
I'll file it.
Kamath sir, affidavit file ಮಾಡ್ಲಿ ನಾಳೆ. We'll take it tomorrow. The right to travel cannot be curtailed.
But there is a status report filed by the Delhi police.
We'll see. Yes. But how
Sir,
can
is
I
my-
hear the officer?
Sir, may I submit?
He should give you instructions, not.
Right.
Please serve ಆಗಿ. R3R. Oh, yes. It's served on you, is it? Yes, officer.
Sir, sir, इसमें we have served a notice under section 35.3 BNSS to these three petitioners. Three notices have already been served, but despite that, they have not joined the investigations till date.
Lords, once the matter is
They are
settled,
continuously
entire amount of
seeking
PD
time, sir.
process
They
You
are
should
saying.
go and tell that and come.
My lords, we have produced all the documents, my lords. He is in receipt of the settlement agreement, everything, including the joint affidavit.
We'll see. You file your affidavit of your travel itinerary, going, returning, and if you don't return, we'll direct your passport to be impounded. Straight. That's generally what I do in travel things. Yes. Tomorrow we'll do it. We'll allow it tomorrow. Only the travel. Yes. Nale, same in the fresh matters list.
32.
32, my lord, seeking speedy disposal of the criminal revision petition.
ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್
230.
ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಬರಲ್ವಾ? ಅಲ್ಲ ಕೇಸಲ್ಲಿ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಬರಲ್ವಾ ಅಂತ.
We have merits, my lord, in the other case as well. This petition, my lord, the petitioners are the victims. My lord, on behalf of the victims, my lord, the respondent lodged the complaint. My lord, the victims, my lord, approached the magistrate seeking, my lord, release of the property, that is, my lord, the gold ornaments. The honorable magistrate, my lord, released the gold ornaments in favor of the victims. My lord, this order, my lord, was challenged by the second respondent.
Revision ಅಲ್ಲಿ.
Revision. My lord, revision, my lord, was stayed in 2024. Till now, my lord.
The petitioners are before the court seeking the following prayer. The petitioners are said to be the victims who approached the learned magistrate seeking release of the gold ornaments, and the learned magistrate allows the said application, allows the application filed under 451 and 457 of the CRPC, against which the respondent approaches the revisional court. The revisional court stays the said order in criminal revision petition 35 of 2024. The learned counsel submits that since for the last 2 years, there is no progress in the case, i.e. before the revisional court. Therefore, submits that the revisional court be directed to consider the case expeditiously as possible, and as the victims are suffering, notwithstanding the fact that there is an order in their favor and passed under 451 and 457 by the learned magistrate. In that light, the prayer being innocuous, I deem it appropriate to direct the concerned court to dispose the criminal revision petition 35 of 2024 with an outer limit of 8 weeks from the date of receipt of the copy of this order in accordance with law. Ordered accordingly.
33.
This matter was said to be connected with another matter listed, my lords. If it may be
ಯಾವುದು?
15970. We had given the number also. It's a 311 application, your lordship. The matter is already set for judgment itself.
No, correct. Yes. Yes, madam.
Monday it is listed for the judgment, your lordship. My 311 application is rejected.
This is the third application they have made, your lordship.
Your lordship, in the cross examinations, they admit regarding the authorization of the authorization letter, your lordship. Thereafter, they filed section 91 application for producing authorization.
Who files?
Company, your lordship, that is the complainant. And thereafter, we file an application in 311, Your Lordship. That is rejected for further examination
After the authorization. is
after
read.
the authorization letter, Your Lordship.
When was the dates ಹೇಳಿ? Our application date. Fast.
Your Lordship.
You can't turn the pages here, madam.
My
We'll vacate
apologies.
the interim order. Interim order ಇದೆಯಾ?
No, no, that's
Ah,
gone.
then ಬಿಡಿ. List the matter on Monday.
Your Lordship, Monday it is posted for
Again,
judgment, Your
you
Lordship.
can't turn the pages here. Yes, next.
Oblige.
Hearing on IA 34.
Okay, for the petitioner, my lord, 70 years mother-in-law.
Your Lordship.
ಆಮೇಲೆ
498 case has been listed.
78 mother-in-law.
Only 7 days they stayed in the Tumkur. After that, 14 years they are staying in Bangalore, my lord.
ಓ ಎಲ್ಲ 7 ಏನಾ?
Under 8 days ಇದೆ, ನಾನು 7 ಅಂತ ಹೇಳಿ.
ಓ
Complaint ಅಲ್ಲಿ 8 days ಅಂತ
70
ಕೊಟ್ಟಿದ್ದಾರೆ.
years, 7 days.
And my lord, accused number 2 is the friend, my lord. 498 will not attract to him.
ಆಮೇಲೆ
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಅಷ್ಟೇನಾ?
Just an harassment to me.
ಹಾ.
Whatever the A1 has done, there is nothing to do about him. I am just innocent, my lord. A2 and A3.
Just innocent.
Completely innocent.
Fine. Yes.
Humbly request this honorable court to quash, my lord.
Vacating stay ಇದೆಯಲ್ಲ?
Vacating stay.
ಹೇಳಿ ಸರ್.
498A and 307, my lords. My lords, we have information that the accused number 1 has passed away this morning.
This morning?
This morning.
He is suffering from cancer.
He's passed away.
Last ಅದೇ ಇದು ಮೊದ್ಲೇ ಕ್ವಾಶ್ ಆಗಿದ್ದು, ಸ್ವಲ್ಪ ನೆಮ್ಮದಿಯಾಗಾದ್ರೂ ಹೋಗ್ತಾ ಇದ್ರು.
ಅಯ್ಯೋ.
ಅಂದ್ರೆ 70 ವರ್ಷ ನನಗೆ ಮಗ 7 ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ 8 ದಿನ
ಇಲ್ಲ, ಅವರೇ
ತುಮಕೂರಿನಲ್ಲಿ.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಅಲ್ಲ ತಾನೆ?
A1 ಬಟ್ ಐ ಆಮ್
A1 ಗೆ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ, A2 A3 ಮಾತ್ರ.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲ, ಅದೇನೋ ನೆಮ್ಮದಿಯಾಗಿ ಹೋಗ್ತಾ ಇದ್ರು.
ಮದುವೆಯಾಗಿ 7 ದಿನ ಮಾತ್ರ ತುಮಕೂರಿನಲ್ಲಿ ಇದ್ರು. ನಾನು 70 ವರ್ಷ ಏನು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. 14 ವರ್ಷ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾರೆ. ಐ ಆಮ್ ನಾಟ್ ರಿಲೇಟಿಂಗ್.
ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಲ್ಲ ಸರ್.
Stay has been given, but I request this honorable court to quash, and also it's a 2023 old matter, my lord.
ಗೊತ್ತು ಸರ್, ಈಗ ಮಾಡುವ ಯಾಕೆ?
Yes.
ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ನ.
And your judgment is also there. 498 will not attract to the stranger.
Stranger.
Yes.
Oh,
In my petition number 1504 of 2023.
Paramara stranger.
Stranger.
Lady.
Even given judgment on 6th January 2026, reportable judgment.
Yes, sir.
And ample of judgments you have cited.
Yes, sir. A1 ಓದು, A1 ಅಬೇಟ್ ಆಯ್ತು, ಇದು ಕ್ಲೋಸ್ ಮಾಡೋಣ.
2 and 3, my lords, there are materials show there's 164 statements and 161 statements.
ಆಮೇಲೆ
next week, kindly, my
Why,
lords.
sir? Nothing doing. Yes. It's listed for
My
vacating
lords,
stay.
let them go and urge this before the trial court and file a discharge application. There are ample materials, my lords.
Take me to that material, sir.
Please, my lords.
Yes. ಇದ್ರೆ ನಾನೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಈಗ. ಇದು ಸ್ಟ್ರೇಂಜರ್ ಯಾವುದು?
Accused number 3, my lord. Petition number 2. If you see page number, my lord.
1 minute, sir.
In the complaint, only 2 allegations they have made, my lord. Petitioner number 3.
ಇವ್ರು ಯಾರು? Accused number 3 is a stranger ಅಂತ ಹೆಂಗೆ?
A friend, my lord. He is the friend. The allegation against him is that if you see the complaint.
One moment.
Complaint paragraph number 3, my lord. Complaint is in page number 20, paragraph number 3. ನನ್ನ ಭಾವನ ಸ್ನೇಹಿತನಾದ ಮಂಜುನಾಥನು ಇಲ್ಲ ಸಲ್ಲದ ವಿಚಾರಗಳನ್ನು ನನ್ನ ಭಾವನಿಗೆ ಹೇಳಿ ತನ್ನ ತಂಗಿಗೆ ವಿಚ್ಛೇದನೆ ನೀಡುವಂತೆ. Yes, my lord. And against mother-in-law, if you see page para 1 of the complaint says.
Complaint bidi sir, come to page 30.
Yes, my lord. My lord, the entire
I,
allegation,
accused number 3, fine.
even 2 also, my lord, because I was not staying there.
You're not staying together.
Yes, in the I was
ಇದೇನೋ
staying in
ಹೇಳಿದ್ರಲ್ಲ A1 ನೆಮ್ಮದಿಯಾಗಿ ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ, ಚಾನ್ಸೇ ಇಲ್ಲ.
cancer 4th stage.
ಅಲ್ಲ ಅದು ಹೋದ ಸರಿ,
Cancer 4th stage.
ಬಟ್ ನೆಮ್ಮದಿಯಾಗಿ ಹೋಗ್ತಾ ಹಾರಿಬಲ್ ಅಲಿಗೇಷನ್ಸ್ ಅಗೇನ್ಸ್ಟ್. ಎಸ್.
But A2, I was staying in Tumkur.
With respect to A2 and A3, my lords. A3, there is some instigation, my lords.
Instigation will not amount to 498. Please. What is this? Page 30, instigation is there, last 4 lines ಅಷ್ಟೇ.
Please.
ಪ್ರಚೋದನೆ ಮೇರೆಗೆ A1 behaved like that ಅಂತ. But A2, yes.
My lord, but I was no way
Mother-in-law,
connected.
yes.
Mother-in-law, I was staying in Tumkur. They are residing in Bangalore.
ಎಲ್ಲಿ?
In Bangalore, my son A1 and my respondent number 2, they were both residing in Bangalore. I am staying in Tumkur. Only for 8 days they stayed with me. 14 ವರ್ಷ ಬೆಂಗಳೂರಿನಲ್ಲೇ ಇದ್ದಾರೆ. ನಾನು
ಆರಾಮಾಗಿ ವೇಟ್. ದಯವಿಟ್ಟು ಆರೋಪಿ A1 ಜೊತೆ ಸೇರಿಕೊಂಡು ಅಂತ ಇದೆ. You still want against the mother-in-law?
ಮಗನೂ ಕಳ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಈಗ ನನ್ನ ಮೇಲೆ
wait.
Let it proceed, my lords. Let them urge all these facts before the trial court, my lords. Let them file a discharge application.
3, of course, will quash. No doubt about it.
I'll leave it to you, lords.
3 quash ಮಾಡೋಣ, 2 discharge ಹಾಕೊಳ್ಳಿ.
2 also, because the thing is 8 ದಿನ ನಾನು ಇದ್ದಿದ್ದು, ಇವ್ರಿಗೂ ನನಗೂ ಯಾವ ಸಂಬಂಧ ಇಲ್ಲ. ನನ್ನ ಮಗ ಮತ್ತೆ ಸೊಸೆ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಿದ್ದು. ಈಗ ನನ್ನ ಮಗನೇ ಸತ್ತೋಗಿದ್ದಾನೆ. ತಿರ್ಗಾ ನಾನೀಗ ಕೇಸ್ ಹೋಗಿದ್ರೆ ನಾನು ಸತ್ತೋಗ್ತೀನಿ ಅಷ್ಟೇ. ನ್ಯಾಯ ಬೇಕು ಸ್ವಾಮಿ.
ವೇಟ್ ಸರ್, ಅಬೆಟ್ಮೆಂಟ್ ಇಲ್ಲಿಗೆ ಹೇಳ್ತಾ
ಇಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ಕಷ್ಟನ ಹೇಳ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ ದೇವ್ರ ಮುಂದೆ.
But what do you gain? I'm asking.
My lords, there is.
What do you gain by trying the mother-in-law now?
My lords, there is a child about 14 years, my lords, as of today, and there are some expenditures that has to be taken care of.
ಆಯ್ತು ಸರಿ, settle it then.
If they're ready, we can have it.
ಈಗ ನನ್ನ ಮಗ ತೀರೋಗಿದ್ದಾನೆ, ಏನೇನ್ ಆಸ್ತಿ ಇದೆ ಹೆಂಡತಿ ಮಗನ್ಗೆ ಹೋಗೋದು.
ಆಯ್ತು, ಅದು ಏನಾರು ಇರ್ಲಿ, you sit and settle the issue.
Yes, my
I'll grant you 15 days time.
Please,
now that the son is no more,
please,
husband is no more who has tortured you. Now I think better settle this course in the interest of the child.
Please.
They list the matter on 17th July in the fresh matters list. The husband against whom the allegations galore on a perusal at the summary of the charge sheet is said to have died today.
Today.
Is said to have died today owing to terminal illness. The others who remain in the fray is the accused number 2 and 3. Accused number 2 is the mother-in-law, and accused number 3 is the friend of the husband who ostensibly cannot be proceeded against for an offence under section 498A. Therefore, the proceedings against the accused number 3 must be obliterated. Who would remain is the mother-in-law, accused number 2. Since the husband is no more, and the couple had a child of 14 years, in the fitness of things, it is better that the parties to the list sit across and arrive at a settlement between them, which would result in closure of these proceedings or any other proceedings that are pending. The matter on 17th July in the fresh matters list. Settlement, if any, arrived at by the said date, be placed before the court, failing which the matter would be considered on its merit insofar as accused number 2 is concerned.
Much obliged, my lord.
My apologies, Your Lordship. Serial number 33, at least for tomorrow, Your Lordship, because Monday is the judgment. I have the dates.
Illi you can't flip through pages.
My apologies.
ಆಯ್ತು, tomorrow ಹಾಕಿ. ಅದು ಯಾವತ್ತು ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್, ಯಾವತ್ತು 30th ಹೇಳಿದ್ನ, 29th ಅದನ್ನ ನಾಳೆ ಹಾಕಿ. 24.
Grateful, Your Lordship.
35.
My Lordship, I'm appearing for the petitioners in this case, my Lordship. For the money recovery, my Lordship, she has filed this case, my Lordship.
ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್, 2024. ಫಿರ್ದೋಸ್ ಬಾನು.
Yes.
2325.
Yes. The petitioner Vacating stay ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಇಲ್ಲ sir, ಯಾರು ಹಾಕಿಲ್ಲ.
ಯಾರು ಇಲ್ವಾ? Dispensation. Dispensation allow ಮಾಡಿ. For the reasons indicated in the affidavit accompanying the application, dispensation allowed. The petitioner is accused.
1 to 4.
Admission ಗೆ ಬಂದಿರತ್ತಾನೆ ಮೇಡಮ್? ಇಲ್ಲ fresh matter ಇದು.
No, my lordship, it is.
Interlocutory. Yes, post, the interim order stands extended to the next date of hearing.
No, not fresh matter, my lordship, it is.
List the matter for admission on next Wednesday. Yes. Next.
Lordship, Wednesday, some inconvenience. my
ತೊಂದ್ರೆ
lordship.
ಇಲ್ಲ, yes.
Friday, my lordship.
Thursday ಕೊಡ್ಲ.
Friday, my lordship.
Next Friday ಬೇಡ, Thursday or other next week.
Other next week, my lordship. Some
ಆಯ್ತು, list the matter on 10th July, 9th July.
Please, my lordship, please.
Next.
Your lordship, it may be taken up next week, your lordship. State has filed for vacating stay. The CH-14 was already ready, your lordship.
No problem.
Let's have one submission.
Produce the entire material.
Let's may kindly pass over, my lord. The senior is on his
Oh,
way.
seriously, wait. The learned HCGP seeks a week's time. The application, interlocutory application seeking vacation of the interim order is filed by the state. Therefore, list this matter on 8th July as the last chance, and in the same stage. Interim order subsisting will continue till the next date of hearing.
There's a shorter date if possible.
15th July. Yes.
Please, ma'am.
Society.
Not dispute as to not the interim custody of compensation.
Huh?
Dispute as to not the interim custody of compensation.
Interim custody of?
Compensation.
Compensation.
Yes.
Yes, sir.
But the accused number 1, my lord, had formed Graha Nirmana Samiti, not for forming not sites to not sightless persons to its members. Sightless persons to its members. But he formed the layout not till the year not 2015-16. He also formed not about 300 sites. Of them, not 170 sites not were allotted to its members.
ಅದು ಮಂಡ್ಯದ ಇದು?
Mandya. But in the meantime, but the National Highway Authority not acquired not certain part of the land, and ultimately not acquisition proceedings were contested, and compensation of rupees 11 lakhs and odd not was awarded. 11 crores. I'm sorry.
11 ಲಕ್ಷಕ್ಕೆ ಯಾಕೆ ಅವ್ರು ಹೊಡೆದಾಡ್ತಾರೆ?
I'm sorry. 11 crores not was awarded. But when Lord the respondent number 2, who was nowhere in the picture not from the year 2006 to 2018, he was elected not for the first time not in the year 2019.
What is the date of acquisition, date of deposit of compensation?
Yes, not, I'm not, I'm producing the
ಕೊಡಿ,
synopsis.
list of dates ಕೊಡಿ.
I have the documents. List of dates and
I have the
synopsis.
ಕೊಡಿ ಎಲ್ಲ ಕೊಡಿ. ನೀವು ಕೊಡಿ.
But item number 6, 23/9/2016, not the amount of compensation not was awarded. But subsequently it was deposited not in the 2020. But he filed not on coming to know that not in August 2020, but the amount is deposited. But the respondent number 2 not suddenly became leader and he filed complaint. On the basis of which not the present complaint came to be registered not on 20/10/2020, not after the depositing the money. Not in the course of investigation, not certain amount not was seized, and not the amount in the account of not the account number 1 not was freezed. Not so not the petitioner as well as not the respondent number 2 had filed an application. Ultimately, not the learned magistrate was pleased to reject. Not the said order not was also came to be confirmed not before the regional court. Not here, not my first submission to lordship is not. This is an amount of compensation. It is not the proceeds of not the crime, but the proceeds of because my lord, what I'm trying to submit is I had formed the layout, not it was acquired, not part of the land was already allotted to not different members, but that amount was not deposited not in the account of not Graha Nirmana Samiti formed by account number 1. But suddenly not this respondent number 2 not filed a complaint and sought for not the release of the money. He has no concern absolutely whatsoever. From the year 2004 to 2016, he was not in picture. First time not
Compensation ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು?
accused number 1.
Who is accused number 1?
Account number one, my lord, is Graha Nirmana Samiti.
That is society.
Yes, my lord.
Who are you?
But I'm the chairman. I was the chairman.
Who took that compensation?
But it is the Graha Nirmana Samiti. But amount was deposited by the land acquisition officer. But in the
So
name
it is still with the
bank, in the bank, not in the custody.
still
of-
there.
Yes.
Oh, no, man.
Now what's the complaint about then? If it is still there, what's the complaint about?
But they say,
Khali ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಅದೇ problem.
no, that is their allegation. But in fact, not, it is not so. Not, it is freezed by not the investigating agency. Amount is not intact, not in the bank account.
Yes, sir.
Please, my lord, 5 persons filed an application seeking release of this amount.
Compensation.
Compensation amount. Out of which R2 is also one. And in my
So
favor.
new obra.
Please, my lord.
Oh, sorry.
And my application came to be
Rejected.
no, allowed. Only my application came to be allowed, both before the trial court and in the revision court. Now, my lord, the contention of the petitioner is that, my lord, the Gruhana Nirmana Samiti itself is an independent association without having any nexus with the Karnataka Sarkar Navkar Sangha. That is the first submission. Second submission, my lord, that that Gruhana Nirmana Samiti was developed by the T.H. Ramakrishna, accused number 1, who is no more right now. It was developed out of his own pocket. The money was spent out of his own pocket. That is the second submission. The third contention is that they are questioning the very propriety of the respond number 2, which is now settled by the ROCS. Now that T.H. Ramakrishna filed many petitions before the Register of Corporate Society. For that, may I persuade your lordship to, where is my copy? To page 26, my lord. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರ ಸಂಘ ಮಂಡ್ಯ ಜಿಲ್ಲಾ ಶಾಖೆ ಅಡಿಯಲ್ಲಿ ಸ್ಥಾಪಿತವಾದ ಗೃಹ ನಿರ್ಮಾಣ ಸಮಿತಿಯ ಪ್ರಭಾರವನ್ನು ವಹಿಸಿಕೊಡಲು ನಿರ್ದೇಶನ ನೀಡಲು ಕೋರಿರುವ ಕುರಿತು. This order has reached finality. Nowhere it has been appealed or questioned.
No. What the prayer is for release of amount.
That release for amount.
Release
Now,
of how much amount?
Release of 1 crore 25 lakhs.
1 crore.
Yes, my lord. There were like 7 PFs. Out of which PF number 10 with regard to 38 lakhs is now been questioned.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
Call for relevant records, allow the criminal 83.
Now, how he got that money into his account is important, my lord.
Seeking interim release of 38 lakhs, seized so and so. ಅಷ್ಟೇನಾ?
Yes, my lord. Now, my lord.
ಮತ್ತೆ 11 ಕೋಟಿ ಅಂತ ಇದ್ದಾರೆ?
My lord, 11 crores were released. Released in the name of president.
ಎಲ್ಲ ಆಯ್ತು. ಈಗ 11 ಕೋಟಿ ಕಾಂಪೆನ್ಸೇಷನ್ ನೀವು ಪೂರ್ತಿ ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ. ಈ 38 ಲಕ್ಷ ಯಾಕೆ?
We claim not 11 crores.
ನಿಮ್ ಪ್ರೇಯರ್ ಇಲ್ಲಿ 38 ಲಕ್ಷ ಇದೆ ಅಷ್ಟೇ.
It is not with regard to not there are 3 petitions not before your lordships. So far as 37.2 is concerned,
ಅದರಲ್ಲಿ ಎಷ್ಟು?
It abates. Not he has died.
Accused number 1 ಆಯ್ತು.
Yes.
Connected matters, both matters abates.
37 and 37.1 not they survives for consideration. But so far as not this 37 is concerned, it is only not with regard to not 38 lakhs.
38 lakhs.
Not so far the other petition, that is the criminal petition 10077 of 24, not it is with regard to the entire money.
Entire money ಯಾವುದು?
Of not the compensation and deposit in the account of not Graha Nirmana Samiti.
Samiti, who is who are now the officers in charge of that Samiti?
No, he the one Chetan not is the president.
No. By
He is the
virtue
president. No, I have produced not the
Samiti ಇರಲಿ ಬಿಡಿ ಅದು.
No, it is private body. No, he cannot have not any say in the matter.
Let me clarify that one. By virtue of superannuation or by death or by resignation, the very membership ceases.
No, ಅದು ಬಿಟ್ಟೆ. Samiti is still there.
Correct, my lord.
The account of the Samiti is still there.
Yes, my lord.
Let the amount be in that account.
The amount, what Ramakrishna, the accused number 1 did is, he created a new account. When already an account in the name of the Samiti was in existence.
We will direct that the Samiti, money will be kept in the account of the Samiti only.
My lord, now I have to release that amount for.
ನೀವ್ ಯಾರು?
But he has absolutely. First of all,
ನೀವ್ ಯಾರು?
My lord, I am the respondent, but I am the.
ಆಯ್ತು, but in the Samiti, who are you?
In the Samiti, my lord, by virtue of the. I am the president. I am the president.
When were you elected?
Elected as and when elected, any person who get elected as a president is the president by de facto. He is the president of all the Upasamitis.
When did you get? When you became the president?
2022.
Of this Samiti, is it?
Yes, my lord.
No, no, not
of not
Samiti.
this Samiti.
Then
District committee.
Karnataka Sarkar Navaka Sangha Mandya Shake. By virtue of that post, I become the president of all the other Samitis.
Oh,
That is the categorical finding by the Register of Cooperative Society.
Where is
Please,
that?
my lord. May,
Now, Lord, he is
may
not the
Royal
president
Lordship
also.
27, my lord.
ಈ ಸಮಿತಿಗೆ ಏನ್ ಬರ್ಬೇಕು ಅದು ಹೋಗ್ಲಿ.
ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
I am.
Then why are you blocking that amount? Compensation a samiti property belong to that samiti.
Please, my lord.
Yes.
Compensation should go to the samiti.
Please, my lord.
Yes.
And then who are you to stop it?
My lord, I happen to be the president by virtue of that presidency.
That's all right. Compensation ಯಾರ್ಗ್ ಹೋಗ್ಬೇಕು ಬರ ಹೋಗ್ಲಿ. How are you controlling compensation?
Well, compensation has to come to me. I am the president of the Samiti.
You are not the president of this samiti.
That's him.
Ex officio president.
Yes, my lord. Ex
Being
officio.
president of the district, you are ex officio president. You are not the elected president of this. That we will have to decide how did he become the president.
Please, my lord. At page.
ಮಧ್ಯಾಹ್ನ 2:30 ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Please.
2:30 2 ಮ್ಯಾಟರ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ತಗೊಂತೀನಿ.
And now he is not even the president of that.
Now who is the president?
He is not the president, my lord. Now one.
One ನಿಮಿಷ. You still hold the post of president?
No, my lord. One
Then
Nagesh
forget
is-
it. Then you don't have to worry about anything.
My lord, my son.
Your ex officio has become ex now. So don't.
Exactly, but that is the crux.
If your ex officio president post has become ex,
But still, my lord.
but no still, sir.
My lord.
ಯಾರಿಗೆ compensation ಹೋಗ್ಬೇಕು? You can't control compensation of somebody else. Period.
My lord,
Yes.
compensation amount is not.
Don't worry, sir. ಏನು ex officio president ಆದ್ರಿಂದ you wanted to control it. You are no longer president. Somebody else is the president.
But is president.
Leave it.
We are
Leave
right.
it.
Yes, that may be taken care
Then
of, my
you
lord.
have lost your cause.
My lord, by
You have lost your cause. Finish.
but there are.
Because you are not the president, no longer the president.
Yes, my lord. Correct. But my lord, as so
Sir,
far as.
compensation ಯಾರಿಗೆ ಬರ್ಬೇಕು ಅವ್ರಿಗೆ ಹೋಗ್ಲಿ ಬಿಡಿ. What is your
My lord,
problem? What's your problem, sir?
ಅವರು ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು
Then
ಅವರಿಗೆ
ನಿಮಗ್ ಬರ್ಬೇಕಾಗಿರೋದು ಬಂದಿಲ್ವಾ?
My lord,
Exactly.
ಯಾರಿಗೆ
Exactly, my lord. He tried to put it-
ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು ಹೋಗ್ಲಿ ಬಟ್ ದಿ ಕಂಟೆನ್ಷನ್
ಈಗ ನೀವಂತೂ ಹೋಗಿದ್ದೀರಾ ಪೋಸ್ಟ್ ಇಂದ, ನೀವು ಮರ್ತ್ ಬಿಡಿ.
Correct.
ಪರವಾಗಿಲ್ಲ. We'll pass orders in the
My lord.
2:30 will pass orders.
Please.
One matter ತಾವು clear ಮಾಡ್ತಾ ಇದ್ರಿ. Lawyers matter against the doctor for having filed a.
Correct. ಏನಾಯ್ತು?
ಬರ್ತಾನೆ ಇಲ್ಲ.
ಕೊಡಿ. ಕೊಡಿ. ಅದನ್ನ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ ಯಾವತ್ತು ಟೈಮ್ ನೋಡ್ಕೊಂಡು ಹಾಕಿ.
Serial number 66, my lord. The colleague had appeared in the morning. The connected matters have been stayed, my lord. It was not brought before the court. Serial number 66.
ಫಸ್ಟ್ ಲಿಸ್ಟ್
Yes. First list. Connected matters have been stayed by the Sound Road Court.
ಸ್ಟೇ ಮಾಡಿದ್ನಲ್ಲ ಅದ್ರ 138 ಅಲ್ವಾ?
ಹೌದು 130.
ಆಯ್ತು ಕೊಡಿ ಅದು. ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ. ಅದು ಯಾರು ಮಾಡಿದಾರೆ ನೋಡಿ.
ಮಾಡಿದ್ರು ಸರ್. ಮಾಡಿದ್ರು.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದ್ರೆ ಇದು.
Lordship, serial number 60. Second list 47 minutes. Respondent 2 minutes. Some inconvenience.
ಟೈಮ್ ಪೇಜ್ ವೈಸ್ ಕರೆಕ್ಟ್ಬಿಡಿ.
Page wise adjournment list, page 7, 38. Page 8.
Serial number 38, my lords. 1 week time may be granted due to some inconvenience.
Vacating stay ಇದೆ, no time. Yes.
Page 8, 39 to 45. Page 9, 46 to 49.
47 minutes for respondent number
Vacating
2.
stay, no time. Yes. Next. Who has filed vacating stay? You have filed? Then I'll dismiss that application.
Let's
Is
any
it
date
okay?
in the next week, my
No.
lords. There's some complaint registered.
No
my lords,
problem.
against
Wait.
the-
Yes.
There's some
Mention when it
inconvenience.
is called. Yes.
Please.
Page 10, 50.
Madam, 15 list on 23rd July. Interim order subsisting would continue to the next date of hearing. Yes, next.
Page 15, 51. Page 16, 52 to 50.
Orders better.
Page
Admission book.
19, 67 to 69.
66.
Orders better. Wait. Yes.
Page 20, 70 to 74. Page 21, 75 to 80.
In. ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ ಸರ್. ಅದು ನೆಕ್ಸ್ಟ್ at the request of the counsel for the petitioner 23rd July. Yes. Next. 2 weeks ಮಾಡಿ ಮೇಡಮ್. ಅದು 23rd ಬೇಡ 2 weeks ಮಾಡಿ. Yes.
Page 23, 81 to 86. Page 24, 87 to 91. Page 25, 92 to 95.
My lord, 95, my lord, kindly. My lord, 95, my lord, kindly.
Yes, sir.
95 may be urgent by.
What do you want?
It may be urgent, my lord, interim audits may be extended. There are three
Yes.
petitions.
List after 2 weeks. IO. Next.
Please.
Page 26, 96 to 98. Page 27, 99 to 107. Page 28, 108 to 114. Page 29, 115 to 118.
Yes.
My lords, 117 is prior.
ಹಾ ಇರ್ಲಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
All of them are rope.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಕೊಡಿ, ಈಗಲೇ ಕೊಡ್ಬೇಡಿ, ಬರುತ್ತೆ ಬಿಡಿ.
Lords, apologies, my lords, one mention. Your lordship had directed this matter to be listed today.
Which one?
Lords, the matter, lords, I'm mentioning. The reason is this, lords, she's a lone lady. Lords, on account of compassionate appointment, your lordship had fixed a date today. When I mentioned the last week when the matter was listed. All the cases have been quashed, this has been stayed. Not sir, compassionate appointment is pending only on the ground that there is pendency.
ಆಯ್ತು, ಅದು ಯಾವ್ದು ಕೊಡಿ ಮೇಡಮ್, ತಗೊಳ್ಳಿ.
Lordship may have it tomorrow.
ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್, ಏನಾದ್ರು ಕೇಸ್ ಇದ್ರೆ ಮುಗಿಸ್ಕೊಂಡು ಲೆಟರ್ ಗೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಟ್ ಲೀಸ್ಟ್. ಊಟ ಮಾಡ್ಲಿಲ್ವಾ? ಆನ್ ಮಾಡಿ.
Matter pertaining to illegal detention, my lords, wherein the petitioner was arrested yesterday. In the morning, my lords, the respondent police have registered an FIR stating that he was found with a Hindi in his car along with a ganja. So yesterday he was arrested, my lords, from the homes. Entirely it has been recorded in the CCTV. But they are alleging that he was found somewhere in near Bangalore-Mysore highway in a car, and
somewhere
in Bangalore-Mysore highway, my lords.
SPP ಅವರೇ,
the arrest procedures.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವರು.
Yes, tomorrow, please.
Tomorrow we'll take it. RE policy.
Fortunately, Ruben sir is also there.
Fortunately, why is always there? What do you mean? Yes.
No Passover.
ಏನಿಲ್ಲ, no Passover. ಮುಗಿಸ್ಕೊಂಡ ರೂಬನ್. Anyway, I think you need only 5-10 minutes. Because Basaprabhu sir is finished. ಅಷ್ಟು ಕೊಡಿ ಸಾಕು. ಮೇಡಮ್, ಇದಾದ್ಮೇಲೆ take that Balakrishna sir's 2:30 ಹೇಳಿದ್ನಲ್ಲ, ಅದು still number 17. Then dog and that is all. Yeah. In this seriatim. Yes. ಕೊಡಿ, ಇಲ್ಲೇ ಕೊಡಿ. Memo? Sign the letter. Yes. Highlight. ಅಯ್ಯೋ. Yes, please. Let's just Kodi. On.
That's the 3 volumes. I'll just, but it's all the. I'll just point out, Millets, what is the relevant extract.
You want me to finish writing this in 2027?
No, Millets, it's not that. The RE policy copy I've just placed it. They have already.
The lighter ways. Yes.
Please. Millets, may kindly see for a moment, Millets, page number 4, Millets, in volume 1. Millets, there we provide. I'll just.
Oh, this is like convenience compilation.
Convenience compilation.
Thank you. Yes.
Page number 4, Millets. Clause 1.2D is under challenge because it provided for retrospective operation.
Yes.
First Amendment removes that, makes it prospective.
Yes.
Challenge, Millets, does not lie.
Yeah, correct. So insofar as the retrospectivity is concerned,
we have.
Challenge does not remain.
One project has been.
That may not be correct, because what has been made prospective is only one project, not my lord universally. So anyway, I'll answer.
I'll point out where how I made it prospective. Let's may kindly see 1.2D for a moment. The policy supersedes all earlier solar and RE policy issued. This policy will be applicable to all RE projects sanctioned prior to the commencement of the policy, and those RE projects in the process of development if a project developer with government order issued prior to the commencement of this policy applies for timeline extension or transfer, the applicable timelines, time extension fees and transfer fees shall be as per provisions 7.1 and 7.2 of this policy. This is what is under challenge. I'll point out, Millets, what is amendment, but kindly see, Millets, 1.3 is the legislative framework of the policy. It provides, Millets, under what provisions of the Electricity Act. And then, Millets, the C is National Electricity Policy clause, that is section 3.31 is referred to. That is where, Millets, the National Electricity Policy provides that the state government, it is open to the state government to make a renewable energy policy. Please, Millets. Now kindly see 3.2, Millets, page 8. Page 8. Millets, objectives, the vision and objectives, Millets, we have given it there. And 3.21 nalli, to facilitate, kindly note, Millets, to facilitate development of 10 gigawatts of additional RE projects with or without energy storage systems in the state, including the 1 GW of rooftop solar PV projects, to attract investment in the RE sector and development. Now, my lords, as I pointed out, this was an optional policy. I will also point out, my lords, what projects have come up outside the policy also, because I have given in that convenience compilation. Now, my lords, may kindly take 5.1, page 13.
Yes.
Let's 5.1A provides for how energy sales have to be done. That is, the RE project developer shall sell the energy to ESCOM, procurers, intermediaries, or any other consumer under open access, both within Karnataka and outside the state, under this policy to promote interstate transmission system and intrastate transmission and interstate transmission system category projects. Then B provides for land. B1 may kindly be seen. It shall be the responsibility of the RE project developer to acquire, lease the land required for the project development. So it is their responsibility. Now, my lords, I will explain why the requirement, my lords, with regard to the cap on the for per megawatt, my lords, of a particular project. Let's page 15 may kindly be taken. Page 15. Page 15, bottom of the page, E, project allotment. The state shall facilitate the project allotment through application process, and Karnataka Renewable Energy Development Limited shall be the nodal agency for processing such applications. The allocation of solar parks, solar projects, parks, and energy storage projects shall be approved by the Energy Department, Government of Karnataka, on recommendation of KRADL. Let's page 27. Page 27. Plus allotment of projects. It specifically provides, page 27, allotment of projects. What is the procedure for application and allotment of projects? Because under this policy, what we are doing is we are monitoring the projects from the stage of application to the end of its life, and also facilitating that the project, my lords, will come up in a particular timelines. I will also point out, my lords, what if you go outside the policy or within the policy, what are all the NOCs that you are required to take? How much time it might take? If you come under the policy, what is the? It is a Tatkal scheme.
Of course, if you come under the policy, everything will be done in a single window.
Single window. Now 6.2, my lords, is under challenge. 6.2, page 29. 6.2 only we have provided for the limits within criteria for utilization of land to set up. That is 29, page 29, 6.2. I'll point out, my lords, this has been amended. Now, except for one petition, the amendment is not challenging the rest of the petitions. So, insofar as this, once we have amended this and increased it in terms of some objections that were received by them, that solves their issue. And most of them have already put up their project with that particular, in that particular, acreage that we have permitted. Now, 7.2 at page 31, also under challenge. 7.2, minutes. That is with regard to the fees. Fees has not been amended. Now, my lords, 8 may kindly be seen. What is the facilitation that we provide? 34.
Yes.
8.1, nodal agency. Karnataka, 8.2, page 34.
Yes, yes. Yes, sir.
8.1, nodal agency. Karnataka Renewable Energy Development Limited is the state nodal agency for implementation of this policy. However, the smart grid projects as specified in the Karnataka Electricity Regulatory Commission smart grid regulation shall be implemented by the transmission licensee or the distribution licensee. 8.2, state level allotment committee. A state level allotment committee will be constituted for approval of the RE projects, wind, solar, so and so, under this policy, and to fast track, kindly note this, minutes, fast track its implementation. The SLAC shall comprise of the following members. Then below the table, minutes, the SLAC shall meet once in every 3 months or on need to basis. CREDL will examine and submit project proposals with recommendations to GOK for placing before SLAC for discussion. Kindly note this, minutes. After issuance of government order allotting the project, the developer may approach the concerned departments for obtaining clearance approvals. The developer may also request CREDL to issue facilitation letters for obtaining clearance approvals from the concerned departments. The concerned department shall convey the approval, clearance, observation, or comments, if any, within a stipulated time period of 45 days from the date of the application. CREDL as a nodal agency shall carry out the following functions: verification and recommendation of proposals to GOK, act as a facilitator to obtain all statutory clearances by issuing facilitation letters, resolution of policy level issues for accelerating deployment of various RE technologies, and monitoring the progress of the project implementation. Plus, the fee that we are charging is only for this purpose. The facilitation part is done through a specialized company, that we have incorporated, which is a state company, CREDL, and the energy department. So it is for this purpose, a very nominal, I am using the word a very nominal rate.
2 lakhs.
2 lakhs per megawatt is what we are saying. Earlier it was 1 lakh. 14 years, it was not extended. which I've already, I don't want to repeat that submission, my lords.
Yes.
Now, please see the amendment, first amendment at page 36. First, at page 36, the retrospectivity is removed, clause 1.1. Notes clause as existing and right column only, clause as amended. I'll just read that. Notes. This policy supersedes all earlier solar and RE policies. For those RE projects, applications received with stipulated fees for government order on or before the commencement of the RE policy, that is 6/5/2002, the provisions of the RE policy 2009-14 and solar policy 14-21 shall be applicable with respect to fees and charges along with timelines. For those RE project applications received after 6/5/2022 for allotment, time extension, so and so, RE policy 2020-27 shall apply. So it is prospective. The retrospective has been removed. If in any particular case, my lords, where a project developer has an issue with a particular project, because that's an individual grievance, my lords. He can come to this court, my lords, and if there is any issue with regard to the implementation issues, that is another aspect. That is an individual grievance, my lords. He has to work it out. And you see page 39 for a moment. Page 39, my lords. This is the increase in the
fee.
No, not the fee, my lords, the acreage.
Acreage, yes.
We had, my lords, earlier, if my lords may see, solar PV technology, 3.5 acres per megawatt. Now we have made it 4 acres per megawatt. Then below that, wind was earlier 4 acres. Now, my lords, we have extended it from 5 acres to 10 acres. Like if it is for 2.5 megawatt, it is 5 acres. Now, if it is above 4 megawatts, then you can go up to 10 acres. So that is also provided for. Now, my lords, page number 40 is an amendment to the land revenue rules. Page 40 at 42 may kindly be seen. What is the facilitation, my lords, with regard to even corresponding amendments made to the land revenue rules also. Page 42.
Yes.
Rule 106E may kindly be seen. Lords, it provides for procedure for auto conversion under section 95 for establishing new industries up to 2 acres and renewable energy projects in the state. 106EB says setting up renewable energy projects as prescribed in
So
Karnataka.
those are the benefits under the policy.
So if you go outside the policy,
You don't get that benefit.
Please, let's page 43. I'll just go fast. Page 43. Plus, these are all the NOCs that are required.
Under the policy, they
Not under the policy.
no, these are required. If you come under the policy, all these will
Fast track. It will be fast track.
Ade.
Please.
Tatkal scheme ಇದೆ.
Tatkal. 44 is the projects that were established outside the policy. Maybe I'm expecting in a rejoinder submission that they might say, let them point out in which projects were established outside the policy. It is one thing to say that
doesn't mean that there should be some project.
Please, but still
Outside the policy, this is what is there. Inside the policy, this is what is there. You want to stand out or stand in. That's
Please,
all.
44 is still some of the projects, which were established outside the policy.
All right.
They don't have a government order. Now 45, document number 6 and 7 is one sample government order approving a project under this scheme, which provides
Which is outside the policy or
within
the policy.
I'm pointing out why. Page 45, my lords may take at page 52. Bottom of the page, my lords. Sarkari Adesha Sankhya so and so. This is the project at page 52. This is where under this government order, this project is allotted to them. If my lords may see from 53 onwards, can you see the WTG coordinates? This is a wind project. In a wind project, my lords, based on how many coordinates they're seeking for approval. Now, my lords may see, so these are all the technical aspects we go into for the purpose of facilitation of the projects. We have overlapping issues. Multiple developers come with same WTG coordinates. Some might have a surface right, some might have a lease rights, and there have been conflicting WTG issues which we have sorted out. All these is what is facilitated, my lords, by CREDL and the Energy Department. Then, my lords, 62 is one solar project government order, a sample government order, my lords, which is within the policy. Now 67 to 80
is the outside the policy.
No, within the policy. From the time we implemented the policy, 67 my lords to 69 are the projects that were allotted before the first amendment, and 70 to 80 are the projects that were allotted after the first amendment. I pointed out, my lords, if we add it up, it was coming to 21,248 megawatts and 6,722 WTGs. So so many WTG, so many developers, including most of the petitioners herein, have taken the projects with that acreage. And my lords, I'm sorry, there is one clause I forgot to mention. If my lords may see, I'm sorry, my lords, I'm taking my lords back to 39 for a moment. 39, just one clause, page 39. Page 39.
Yes.
Right side, last column. Any additional land requirement beyond the maximum area shall be evaluated by the government of Karnataka on case-to-case basis, depending upon the topography of the location. So this is what the policy also provides for relaxation insofar as the land requirement, if there is an issue with the topography of the land. All these projects of which I've given, this list is given from page 67 to 80. These are all projects, my lords, which have come within the policy. The policy is in force from 22 onwards.
22.
We are at the fag end at this stage, my lords. I don't think it is something which warrants the interference of this honorable court. Is my respectful submission. If their entire problem is the fees are onerous, please go outside the policy.
Yeah. Yes.
Now, it's page 81. One judgment. This is with regard to fees. I'm not reading it. I'll just mention the paragraphs. Para 13 to 26.
ನಿಮ್ ನೋಟಲ್ಲಿ ಹೇಳಿಲ್ವಾ?
Index ಅಲ್ಲಿ, but I can put it in the written submission.
Written submission ಹಾಕಿಲ್ವಾ ಇನ್ನು?
Not in this.
ಹಾಕ್ಬಿಡಿ.
Rejoined ಆದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ. It is almost ready. In case they make
ಎರಡು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರಿಸ್ಬಿಟ್ಟು.
Another paragraph ಸೇರಿಸ್ಬಿಟ್ಟು. No, there are two judgments.
No, you must be aware, Nandkumar and Vikram sir, their rejoinder is lengthier than the.
Because I think Vikram had reserved his right of reply, right of reply.
But I'll keep it brief.
No.
ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹೋಗಿತ್ತು. That's why he's given me so much material that I write it only in Jan 2027.
So the last two, my lords, are two judgments. I'll point out the paragraphs. One is with regard to the fee and the quid pro quo. And my lords, here in this case, there is enough. The facilitation that we are providing is amounting to the fees that we are charging is only 0.04%. That is 40 paisa for every 100 rupees. So it might, with all due respect, it is not an onerous levy. It is not a very onerous levy.
Exorbitant or onerous.
Please, it's not exorbitant. Just one document in volume 2. Just one document. Volume 2 alone. That is that national tariff policy, page number 3. That 5.2 provides in page number 3. Where it provides, my lords, that the state government can notify this policy. Then, my lords, I have in volume 2, we have provided, my lords, copies in the index itself. I have given the relevant page numbers of Andhra Pradesh, my lords, RE policy, Bihar policy, Gujarat policy, and Rajasthan policy. Similar policies are there in RE energy rich states. And, my lords, fees in our state, my lords, is very reasonable. With that's what I wanted to say. It is very reasonable.
Because very kade more than 10 lakhs, is it?
Please, up to 30 lakhs, my lords, in some states.
Same per megawatt.
Per megawatt.
It can't be that much.
No, per megawatt it can't be. It's total.
Illi per megawatt 2 lakhs.
That is the submission.
Per megawatt, it can't be 30 lakhs anyway.
Per megawatt 30 lakh.
It's 30 lakhs per project.
Illi per megawatt 2 lakhs.
Limited. We also.
My learned friends documents.
No, I'll put
it.
Yes. We have also given the page numbers, 11 page numbers.
Yes,
I'll put what is the relevance in my written submissions. Then the last volume 3 is only the list of authorities. In the relevant paras, we have already extracted also, and the judgment copies are also provided for. Please.
Yes, sir. ಮತ್ತಿನ್ನೇನಿದೆ?
I will take about 5 minutes to
No.
this.
ಆಯ್ತು ಎಲ್ಲ ಹೇಳಿದ್ದೀರಾ.
Can a submission be made that it is optional? And let me tell you, lots of it cannot be. It is not. Or if one says it is optional, straight away that is arbitrary. And my lord, the fact is, today you say that it is optional. If you don't want, don't come in. I cannot have a project without a geo. I cannot have land conversion without a geo. Their portal requires it. Their documents may not show it. I don't need to say more than that. And Assam,
without a geo, they cannot geo.
No, they can. They can. No, let's note this. The submission is literally. It is what they are saying is they want all the benefits of the policy, They want the benefits of the, if you see, the technical clauses have been challenged, fees and timeline, fees and land requirement. Rest of the policy is very fine for them. They want they want to come under the policy.
They want.
But it's
No,
like
that is
saying,
why you held Ange. Without the GO, they cannot do anything. They're asking that they would GO.
They can do.
it is
Gene
this,
do, GO or
my
Gene
learned
do.
friend's submission is this.
There is
He
no
is
need
the
for a
state.
GO.
He says, policies, if you want to file a suit, pay court fees. Optional. You don't want to pay court fees, go outside and sort it out. There is fisticuffs. That is the submission.
No, that's not what we are saying.
No, don't worry.
What else can it be?
One submission, I mean 133.4. The argument of incentives is a smoke screen because there is no incentive. It is like a builder saying you will take water connection as per at the applicable laws. That is what it is written. They are saying I will approve. I don't need your approval. As the learned senior has already argued, under Electricity Act, my lords, I am entitled to do everything. And I also, my lords, last time argued the difference between the earlier policy and this policy. My lords, permit me to file to
All
that.
of whoever wants to file anything, please file in the next 1 week.
Yes, please. Yes, please.
Just one small thing, Your Lordship.
Early, within the next 1 week, please file.
Not being presumptive by any means, but in the event this writ petition, these writ petitions were to be allowed, the Lordship also in the, I'm not being presumptive, but the Lordship may keep in mind the fact that the interim orders required us to pay 100% of the 30% of the processing fee and 100% of the application fee.
There's no such
So the question of
interim order.
But it said that the clause of the policy will not apply to the
the
petition. It was
arrangement
suspended.
of Act, your Lordships had stated. Your Lordships may recollect. Now, I'm glad the state brought
But
it.
if I'm dismissing it, it would
Of
run
course.
from the
Then
beginning.
it has to run, exactly.
My learned friend gave such a lot of information. If we see that one of them has a condition saying it's a new clause. So my learned friend may not be right in saying that everything has gone on without.
No, inspection, they will.
No, I stand corrected. In fact, this honorable court did not direct us to pay this. Despite this honorable court granting an absolute stay, the state would hold us to ransom saying you pay 100%.
There is no interim order for payment. That's the complaint that was made, saying despite the interim order, they're asking us to pay.
Reading on this optional and clause C
Sir.
of the definition.
There will be no pleading. That is optional to make an argument. That's the option, sir.
Just
ನಿಮ್ಗಾದ್ರೂ ಅಷ್ಟೇ ಅವ್ರಿಗೆ that's the option.
Just Your Lordship, one aspect I would like to highlight on the legislative competence, irrespective of whether it is optional or not optional, that is an aspect that will have to be gone into. It can't be wished away only.
Then you're on occupied field.
Occupied field, and as well, Your Lordship, my colleague is there. He'll hand over the rejoinder submission.
All right.
We have in paragraph 3 set out specific conflict between the central law and this policy. So that makes it amply clear. Second, Your Lordship, on the land limits, it will also have to be examined from the standpoint of 300A, because there can't be any derogation without the authority of law. The policy ultimately is an executive instruction. It doesn't bear the authority of law. And third, Your Lordship, insofar as the mandatory nature of the policy is concerned, 1.2 of the policy itself may be referred, makes it very clear that it is mandatory. Second, I have also, with my rejoinder at page 9 and 10, placed the pages of the portal, which shows that the GEO has to be uploaded, and without that, there can't be any processing of applications. Even though 95 of the KLRA makes it clear that there is an exemption, but that exemption is negated by virtue of the portal.
Yes. In the pleadings, technical data has been given in the pleadings. In the written submissions, we'll refer to the paragraph.
All of you file.
I just wanted to highlight one submission that has not been addressed.
How many highlights?
Only I am not part of the association, Malad. That's why I just wanted to make one.
So your highlight is different.
Slightly different, Malad, only because it operates as an entry barrier. I'm equivalent to a startup in Karnataka, localized.
Is it matter listed? It's here. All right. Yes.
It's listed, Malad. Both those matters are listed today. With your
All right.
lordship's
Yes.
The argument on the fees being an entry barrier.
No, really, you made submissions in that different.
Look, I'm part of the same batch, not part of association.
It has been tagged today.
Tagged, Malad.
Then wait. No. The learned AG wants to make separate submissions in that.
But I have to look at it.
Because he's not even seen it.
It's a common, it's identical. Challenge is identical.
Because you just now said you have a different highlight.
If it is the
No,
same.
the only highlight is, my lords, that I am a small player.
Delink it. If this order covers, it covers.
Ashte,
If
that's
it does
all.
not cover, then we'll argue that.
Dealing that particular matter, post it after 2 weeks on date.
Yes, there are
The
two
remaining
matters.
matters are
One, they have
reserved.
filed a reply. In point 7, they have filed a reply. Point 8 was just put. Point 8 may be delinked if your lordships deem fit, but the submission is identical.
Ruben sir,
That,
dealing ಮಾಡ್ಬೇಕಾದ್ರೆ
Delink okay. 33.8.
Yes.
but just may I just complete the submission, my lord?
No,
The
no.
incumbent
It is delinked. So you'll have to complete the submissions after he gets a copy of it.
I mean, I'm appearing in two matters. I'm appearing in two matters today, my lord.
That's
Point
what those
7,
two matters. You serve the copy upon the learned.
Sorry, my lord, there's a confusion. In point 8, pleadings are completed. They have filed their counter. In point 7, class corp. Point 8 is just come today for first time.
Whichever the pleadings are complete, I have taken them. We will order on that. If point 8 gets covered to all other things, it closes. Yes.
And just one last thing, Your Lordship, I will just mention that because it was stated that the amendment has not been challenged, we had moved in the main lead matter, association matter, we had moved an amendment application to challenge the amendment.
No, that if it is challenged in one, that's enough.
Very good.
My lords, I appear in item 133.6. I appear for the petitioner for Hexa Climate. My lords, our challenge in this petition, in this writ petition, is limited to clause 7.2b, wherein which it requires the petitioner to submit a bank guarantee, which is
We'll consider that limited edition also. Yes.
My lords, our written submissions will meet their.
Yes, please do, sir. Yes.
Obliged.
Yes. ಆಮೇಲೆ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗಿರ್ತೀರ, please give a proper name. Then don't come to the chamber. I had appeared. My name is there. Somebody else has not appeared. That name is there. Please don't do that. Whatever you give now, that will be final. Whatever, whoever it is, even on the state side.
State we are giving.
Whatever. Now 70.
My lords have granted liberty to file written submissions in item.
Yes, in all the cases. But in the next 1 week.
Yes, my lord.
Yes.
That's
Interim order in the meantime can continue, Your Lordship, till the decision is rendered.
Obviously continue, sir.
Obliged.
Who's that? That's one submission. 110, that PP kit matter arguments were completed. Today, my lords had said my lords will dictate.
We'll see.
Our
Facts
written
are
submissions were filed. My lords, we have filed it already in the counter, but we have served it on the other side, the state's written submission.
No, let's see. ಇವತ್ತಾಗ್ಲಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಮಾಡ್ತೀವಿ. Yes. ಹತ್ತೋಳಿ ಮೇಡಮ್. ನಾವೇ PP ಕಿಟ್ ಹಾಕ್ತಂಗಿದೆ.
110.
Names correct ಆಗಿ ಕೊಡಿ ಸ್ಟೇಟ್.
Please.
ಯಾರ್ಯಾರು ಅದರಲ್ಲಿ RE policy.
Please, in that grateful.
Yes. Now second is a password matter.
For the petitioner in this matter. 17.1 may be taken up first. 17.1.
What is under challenge in this?
Mother has initiated proceedings under Section 12 of the TV Act. In the TV proceeding, partial relief was granted in favor of the respondent. It is in page number 104. Restraining the respondent from drawing the capital gains from demat account. That is order. By the London action, it falls under section 23 of the DVA. Challenging that the revision petition came to be filed by the respondent, which is in page number 30. Revision petition. In the revision petition, the learned session judge has passed a series of orders.
Serious orders, sir. Series of orders.
The page number 15 is one such order, my lord. In this petition, another application under section 438 of BNS section 20 the Protection Act is also filed. Here in the case, 3 orders have been filed. One is, and as of now, whoever holding the common business property shall not alienate his own shares and shall maintain the value of such holding, matching equal to the number, volume, and value equal to the speeds of the revision petitioner. Then next order, page number 17, my lord, is para 10. You have the obligation to perform the marriage of daughter of revision petitioner. It is obligation of respondent of one to stand perhaps with a more broader shoulder and deeper in his involvement to perform the marriage of his sister. Therefore, the respondent one shall, by all means, extend all possible assistance in performing both the social and religious obligations befitting to the status of the revision petitioner and respondent one by properly maintaining accounts. Such involvement is unhindered financial support with proper moral behavior. Similarly, with the personal involvement, the revision petitioner being a widow is expected to enjoy the support of the respondent one, but for certain reasons, the differences must have developed. As the proper support, both from protection of the holy, shall be extended to the revision petitioner for performing the marriage and related ceremonies. Next order. Further, the respondent one, along with the chartered accountant, involved with the regular audit, shall disclose proper account to the revision petitioner in the presence of either a common trusted friend or in the presence of responsible elderly person of their community or elderly respected person of the business community of Udupi, as would be desired by the revision petitioner. Then 12. Further, the respondent number one is restrained from paying any amount more than 1 lakh towards charity. This series orders have been passed by the learned session judge. Then, my lord, page number 21. Page number 26, my lord. Page number 26. Third paragraph. As for non-compliance of the order dated 9/4/2026, which amounts to breach of said order, respondent number 1 and 2 are to be analyzed or to be prosecuted as provided under section 31 and 32 of the Act. Hence, the official registered a separate case for non-compliance of the order dated 9/4/2026. And pursuant to this order, 9/4/2026, the special case number 44/2026 has been filed through public prosecutor.
That is strictly permissible. Anything else you want to say?
No, your lordship, the revision petition itself is not maintainable.
We'll see.
Now,
Yes.
your lordship, I'm relying upon your lordship judgment on this point, my lord.
Oh.
It is fairly applicable to the facts and circumstances present case.
Now, who is this Swamiji involved in the family?
Who is the acquaintance of petitioner?
How is he interfering in this family affairs?
So, in the case of the respondent is there, certain amount has been transferred by the petitioner one to the account of the petitioner three.
Why?
He is the acquaintance of.
Why have you transferred the amount of the family to the Swamiji? Who is he? A rank stranger and outsider. Why have you dragged him into the family? Oh, Amala?
Now, there is a this alternative remedies there under section 29 of the DV Act.
Oh.
The petitioner, the respondent appeal. There's a specific.
No problem. I will convert this. Yeah, I will convert this order into an order in appeal. No problem. Tell me.
Order passed by the London magistrate under section 23.
No problems. No problem.
That same is covered by the judgment of this court.
No worries.
And now this is the presiding officer, the district session judge. Does not possess any summon of powers.
Oh, yes, sir. I have, sir. No
Your
problem.
lordship,
Yes.
how can the London session judge has directed the office to register the special case?
I will convert it, sir. Don't worry. Both of you, both petitioner 1 and 2 and this Swamiji seri mother kata kodta idira. What, sir? Yes. What false allegation? Early. Anything else? Anything? What else, sir? So no, don't worry, sir.
Vested with the magistrate under section 12 of the DV Act.
Don't worry, sir.
So you
Yes.
kindly appreciate this. The entire proceedings are without any jurisdiction and without any authority of
No problem, sir.
without any authority.
No problem. Anything else, sir? 32, 33 order correct agide. Illi revision order correct agide. Yeah, Bandari box. What is Bandari box?
The revision petition is not
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, 6th time you're saying. First time register ಆಯ್ತು. Yes, sir.
31(2) is assuming that, my lord, worst scenario, the magistrate, this case can be transferred to magistrate for trial. Says as far as possible, magistrate try the offence. So there's nothing prohibition for trying by the sessions judge.
No, sir. If you can't take care of your mother.
I'm taking care of my mother.
Oh.
Once allegations made against me, and
The very fact of Swamiji being inside, gone.
under the DV Act, except the petition number 2 and petition number 3 cannot be made as a party.
Why, sir?
And look, the order, you will not kindly appreciate this order. The order is restraining the petition number 1 from withdrawing the capital gains from the demat account. That's the order. Now, the local section judge has directed the office to register the case. And for non-violence of the order, for breach of any order, only the magistrate has got power.
We'll answer that.
Only magistrate has got power.
We will answer.
So therefore, my submission before your lordship is kindly appreciate this. The entire proceedings are without any jurisdiction and without any authority of law.
Yes.
That's only my submission.
Yes.
All submissions made against the
Yes.
His contentions, my lord, as initially said, that state public special PP.
So that 31 and 32, no problem.
It is not PP. It's a suo motu cognizance taken by the
yes,
court for
absolutely. The
violation.
court has power to do that. It has done. Yes.
So therefore, he can't take a shelter and saying that PP has filed it. Obviously, like suo motu cases has to be represented by PP, and it is being represented by the state. Otherwise, then nothing held. And it is not his contention that he fulfilled the interim orders passed by the.
You have breached the interim order.
Therefore,
every interim order is breached. ಅದಕ್ಕೆ 31, 32 order ಮಾಡಿ.
We are not reached any interim order. And petition number 2 and 3, they are not into domestic relationship with the respondent. Therefore, initiating the proceeding against the petition number 2 and 3 also not meet. And entire proceeding is without.
If you stop interfering in the affairs of the family, third petitioner ಏನು ತೊಂದರೆ ಇಲ್ಲ. As long as you are interfering.
He is not at all interfering with the family between the parties. The allegation is that the petition one has transferred certain amount to the account of the Swamiji. That's only the allegation. Nothing else. Only 1 lakh rupees.
At the beginning.
The revision petition, third respondent is not part of this thing. Very fact that my learned friend is advocating for third respondent,
that is
itself
it.
speaks volumes.
That is exactly. If he is out of the family, everything will be fine. Allah? Dismissed. ನಿಮ್ದೇನು?
Same.
Dismissed ಅಷ್ಟೇನಾ? ಸರಿ.
I filed ವಕಾಲತಿ in office.
ಕೊಡಿ ಸರ್. We'll consider that. ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಬಿಡಿ ಸರ್ ನೋಡು.
Last page number 7, it is specific order passed by the concerned court answering application filed under section 18, 19, 20 or 22 of the Act or any other interlocutory order would not be entertainable before this court. Jurisdiction under section 482 of the CRC. By an order has to be for an appeal under section 29 of that as it is an alternative and statutory remedy. The impute order passed under section 23 of the DBI. Therefore, division is not at all maintained in the case on hand.
Yes. Both ಎರಡು ಇದೆಯಲ್ಲ?
ಇನ್ನೊಂದರಲ್ಲಿ
ಹಾ.
directing the office to register the special case.
ಕರೆಕ್ಟ್, ಅದು ಏನು ತೊಂದರೆ ಇಲ್ಲ.
The party complainant is a dispute between the private individuals.
That is the order of the magistrate.
Correct, that is the order.
Not public prosecutor, sir. So moto case ಅಲ್ಲಿ it is done in his name. No unheard of. No. You will hear it in the order. That unheard will go off. Yes.
All the in
Dismissed,
this court,
yes.
all the contempt cases have been prosecuted by the office of the state public prosecutor. It is not that we have.
He has not heard, sir. Yes. Dismissed both. ಯಾವುದು? List 2, 1. ಹೌದು ಮೇಡಮ್ ಇದು
23 also.
ಅಲ್ಲ ಆ ಡಾಗ್ದು ಯಾವುದು ಡಾಗ್ದು ಯಾವುದು ಇಲ್ಲ ಇದು ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್. ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. Which is your serial number?
My lords, 12, my lords. List 2, serial number 12.
Wait. Petitioners, people for ethical treatment. Petitioner not there? You are there? Yes, sir. Wait, madam. Dictation will pass over. Yes. Any gesture, madam? Next year? Next year? I think you are correct. Pass over. I'll take it at 3:45. Ask him to be here. Yes. 23 ತಗೊಳ್ಳಿ. Jagdish sir. Now, dying declaration without any corroboration, how can you take him into custody?
But it's still an investigation.
Correct.
But there is a dying declaration. Specific overtact against the petitioners. No, that's he may have entitled for bail, my lord, but
no, but on a dying declaration straight away, somebody says something without anything more, you can straight away take someone into custody.
That also is given before judicial magistrate.
That's a little corroboration. Any evidence definitely permissible.
Lordship may have it on Monday, Tuesday, my lord. I'll get
He's
the
in custody.
Investigation. One not the murder.
I'm on that. I'm not on that. I'm on legality of it. That's all. What application did you file before the magistrate? Nothing. Well, how did you take him into custody?
Because the murder. Initially, FIR was registered for the 109. Subsequently,
converted. 302 dying declaration. How did you take him into custody?
Because of the
where are the nuances of arrest?
No, I'll secure
nothing.
I'll secure all this.
Nothing. This can't be done. No problem. Dying declaration ಆಯ್ತು ಸರ್ ಅವ್ರು ಹೇಳಿದ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿ ಒಳಗೆ.
No, that's a matter of evidence.
No, whatever it is, but without following any nuances of arrest on a dying declaration, you can't straight away take someone into custody. Maybe 302, whatever it is.
Your lordship have it tomorrow.
Tomorrow, yes, list tomorrow. Prima facie,
I'll secure
it cannot be. Naale bitpurna. You are not there tomorrow. PhD examination.
In Tuesday.
6 months of PhD ಕೊಡ್ತಾರಾ? Or dissertation ಅಲ್ಲ. Oh, thesis submission. If you come here ಅಲ್ಲಿ antithesis ಆಗುತ್ತಾ? ಇಲ್ವಾ?
Then Tuesday.
He is in custody, sir. ಪರವಾಗಿಲ್ಲ. ಸರಿ.
Tuesday.
Yes. Our thesis. Sir, yes, sir.
Ruben mentioned that PPE kit. ಅವರು ಒಂದು ರಿಟನ್ ಸಬ್ಮಿಷನ್
ಹಾಕಿದ್ದಾರೆ.
ನಮ್ದು ಒಂದು ಹಾಕ್ಬಿಡ್ತೀನಿ.
ನಾ ಫ್ಯಾಕ್ಟ್ಸ್ ಒಂದು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಅಂತಂದೆ ಅಷ್ಟೇ. ಅದು ಕೊಟ್ಟಿರಿ ಸರ್.
ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ. ನಮ್ದು ರಿಟನ್ ಸಬ್ಮಿಷನ್.
ಅವ್ರದ್ದು ನಿಮ್ಮ ಹತ್ರ ಕೊಟ್ಟಿದಾರಲ್ಲ?
ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರಿ. PhD ಗೆ ಅಪಾಲಜಿ ಯಾಕೆ ಸರ್? ಎಸ್. ಇನ್ಯಾವುದಿದೆ? ಯಾವುದು? ಜಾಧವ್ ಸರ್ ನಡಿ. ನಿಮ್ದು ಯಾವುದು? ವೇಟ್, ಲಿಸ್ಟ್ 1 ಪಾಸ್ ಓವರ್ ಯಾಕಾಗಿದೆ? ವೇಟ್, 1 ನಿಮಿಷ ಸರ್. ಲಿಸ್ಟ್ 1 ಪಾಸ್ ಓವರ್. ಸೀರಿಯಲ್ ನಂಬರ್? ಸ್ಪ್ಲಿಟ್ ಅದೇ ನಾವಾಗಲೇ ಮುಗಿಸ್ಬಿಡ್ತಾ ಇದ್ದಲ್ಲ. Yes. Who is acquitted? A2 is acquitted. Your offense? De- Theft, extortion, theft, robbery.
Initially, it was registered, the FIR was registered for extortion. Later, it was into robbery.
We'll close this. The petitioner, accused number 1, is before CC dates held by custody and pages. The petitioner, accused number 1, is before the court, calling in question continuance of the CC so and so against him, notwithstanding the fact that the accused number 2 has been acquitted of the same offense after a full-blown trial, by drawing a split charge against the petitioner. The petitioner accused Ibrena robbery. Ibre robbery na. Oh, either dacoity. Yes. Yes. The petitioner gets embroiled in a crime number so and so for offense punishable under section 384 initially, which 384. The police conduct investigation and file a charge sheet not for 384 but for the offense under section 397, 390,
And trespass.
447, 447, sir. 447 and 457. One ನಿಮಿಷ ಸರ್. IPC ಕೊಡಿ. Highlight. 457 ಅಂದ್ರಲ್ಲ. ಒಂದು ನಿಮಿಷ. That is house trespass. Not criminal trespass. All right. Yes. For the offense under 457 and 397 of the IPC. The petitioner at the relevant point in time was not available for trial. The accused number 2, who was available for trial, was tried and after a full-blown trial gets acquitted of the offense on the score that the prosecution has miserably failed to prove the guilt beyond all reasonable doubt. The petitioner, a split charge is drawn on the ground of absence of the petitioner in the trial and is now sought to be tried on the said split charge. The offense being the one punishable under section 457 and 397 is an act that is done by both accused number 1 and 2. The reason so rendered by the concerned court for acquitting the accused number 2 would undoubtedly become applicable to the accused number 1. Therefore, for an eventual acquittal, the acquittal being an eventuality, even if the trial is permitted to continue, it would be an exercise in futility and wastage of precious judicial time for this court to permit the accused number 1 to be tried in the teeth of the acquittal of the accused number 2. It is needless to observe that in the event the state would prefer an appeal and in the appeal the acquittal of accused number 2 gets upturned, the proceedings against the accused number 1, the present petitioner, would automatically get revived. The aforesaid observations, the petition allowed quashed. Yes. Next, madam. Jadhav sir,
fact of the case is that
you are not the president.
My lord,
ಯಾರು ಕಾಂಪನ್ಸೇಷನ್ ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ ಹೋಗ್ಲಿ.
please, my lord, that's my humble submission.
ಅಷ್ಟೇ, that's all I am going to say.
Before that, let me clarify certain things, my lord. I was the de facto complainant who filed a complaint saying that some misappropriations take place in the Samiti, by virtue of which FIR was registered. Subsequently, investigation was concluded and charge sheet was filed against 3 persons. It was registered as CC number 7026/2021. Now, what is the modus of operandi of the accused number 1 has to be looked into, my lord. My Royal Lordship, page 57.
This is accused number 3.
No, he is not an accused. He is not also even the member of my committee, but he claims the money. 57, my lord. For a moment.
No, the amount will go to the Samiti.
Correct, my lord, but not to the petitioner.
Who is saying to the petitioner? It will go to the Samiti. That's all.
If it that's the order, my lord. That's the order passed by the trial court and the revision court.
First, it will go to the Samiti.
That's,
Then,
no issues, my lord. That's the order. But the only
he will not claim.
how I can claim, my lord, when I'm not occupying.
He will
the
not get a
post.
rupee. Don't worry about it.
When I'm
Yes,
not
it
an
will go to the
implement.
Samiti.
Please, my lord.
That's all. Yes. It will go to the Samiti. In law, in accordance with law, whoever wants to claim should show that he is in charge of the Samiti and take it. That's all.
Correct.
That's all. Ashte. Then we'll quash this crime and observe that.
My lord, with regard to that crime, my lord, there are other 2 accused who are not before this court.
Only in so far as this petitioner is concerned.
He is dead, my lord.
Petitioner is dead. But ಯಾರು prosecute ಮಾಡ್ತಾ ಇದ್ದಾರೆ? Accused number 1 is dead. You are accused number 3 or what?
In 37.1.
Sir, whichever is abated, we will close it. Which is that abated?
37.1 and 2 are abated.
1 and 2 both are abated?
Please.
Serial number in, sir. 37.2. The sole petitioner, the learned senior counsel C.H. Jadhav submits that the sole petitioner is no more. Therefore, the proceedings stand abated. The petition is disposed as having abated. Fine. Innondu yavdu? Innondu yavdu abated andralla yavdu?
37.1.
Who is the petitioner in that?
Accused number 1 is dead.
Allah, who is the petitioner in that? Then criminal case and legal LR. No.
There is an order of the ROCS, my lord.
Company Allah adu. It's individual.
No, my lord. No, my lord.
Accused number 1 individual is not the company. Company adre yes, it will survive. Director Sattaksha company and hogbidalla.
In page 27, my lord, of my memo.
Accused number 1 is individual, correct?
Correct.
So it abates. Allah, if your son is taken over as president there, that. Sir, you are accused number 1. Samiti is not the accused. You are accused number 1 on an individual capacity of individual acts. Correct? You are dead.
Page 27, my lord.
Let him take over. ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನು ಸಂಬಂಧ? ಇದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಸರ್. ಇದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ತಾನೆ?
Please, madam. In page 27 of the memo, my lord. For a moment, my lord. ಸರ್ಕಾರ ನೌಕರರ ಸಂಘ ಮಂಡ್ಯ ಜಿಲ್ಲೆಯ ಸಂಘದ ಅಧೀನದಲ್ಲಿ ನೌಕರರ ಗೃಹ ನಿರ್ಮಾಣ ಸಮಿತಿಯ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಜಿಲ್ಲಾ ಸಂಘದ ಅಧ್ಯಕ್ಷರೇ ಗೃಹ ನಿರ್ಮಾಣ ಸಮಿತಿಯ ಅಧ್ಯಕ್ಷರಾಗಿರುತ್ತಾರೆ. ರಾಜ್ಯ ನೌಕರರ ಬೈಲಾ ಸಂಖ್ಯೆ 14.
ಆಯ್ತು ಬಿಡಿ, ಅದೊಂದಿಲ್ಲ, ಅದು ಆನ್ಸರ್ ಮಾಡೋಣ ಬೇಕಾದ್ರೆ ಆಮೇಲೆ. ಎಸ್, I'll be passing an order on a dead person. That I will not do. For what?
There is a
That not in a criminal case, sir. Not in a criminal case. Your son was an accused.
No.
ನಿಮ್ ಲಾಜಿಕ್ ಅಪ್ಲೈ ಮಾಡ್ಬಿಟ್ರೆ ಫಾದರ್ ಹೋದ್ರೆ ಸನ್ ವಿಲ್ ಕಮ್ ಆಸ್ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಆಗತ್ತೆ. ಎಲ್ಲಾರಲ್ಲ, ಯಾವಾರಾದ್ರೂ ಸರಿ, if father dies, son will come as an accused. You take over, sir, money will go to the Samiti, whatever it is, yes. These proceedings, both the proceedings stand abated, error petition, one the allowed cost. Money will straight away go only to the Samiti.
The Samiti as claimed in the original 457 application.
ಈ 457 ಅಪ್ಲಿಕೇಶನ್ ಮಾತ್ರ ಇರೋದಿಲ್ಲ ಎರಡರಲ್ಲೂ. ಅದಕ್ಕೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಒಂದರಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ, 38 ಲಕ್ಷ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. ಅದೇ 38 ಲಕ್ಷ ಎಷ್ಟು?
38 lakhs.
38 lakhs ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. ಆ 457 ಅಪ್ಲಿಕೇಶನ್ ಏನಿತ್ತು ಅದು
Samiti.
ಅಷ್ಟೇ, that's all.
One more clarification, madam. In the trial court, originally no 457 application was filed by the accused number 1, who is in 37.1. He comes only in the revision petition.
But anyway, he's no more now.
Please, madam.
Leave it. Wherever he comes, he has gone now.
Yes, ma'am.
Yes. No, sir, that I will not. Yeah, no. No.
My lord, it's
Accused number 1 dies, his son should become accused number 1. Is one nimsha, sir. One nimsha. Is the criminal petition the forum to decide that he has succeeded to the throne of accused number 1? What observe that? Nothing. Yes, well, I'll pass the word.
Please, madam. There was an
The
adjudication.
money will not go to anybody but to the Samiti. That's all. Yes. And RTF, disposed cost. ಎರಡು 37 point ಯಾವ್ಯಾವುದು ಹರಿಪ್ರಸಾದ್?
37.1 and 37.2
37.1 and 37.2 ಸೇಮ್ ಅದ ಬರದ್ನಲ್ಲ ಆರ್ಡರ್ ಬೇಟಿಂಗ್ ಅದು 37 ವಿಲ್ ಆನ್ಸರ್ ಅಲೋಡ್ ಕಾಸ್ಟ್. ಆಯ್ತು ಒಳ್ಳೆ ಅಂಗದ್ ಕ್ಲಾರಿಫಿಕೇಶನ್. ಸಂದೇಶ್ ಸರ್.
Just a clarification, 37. Their prayer is to release that amount in their favor.
I am only ordering to the
Allowed
Samiti.
and cost.
ಅಲ್ಲ ಅದು ಬರ್ಕೊಂತ
Please, please.
ಅಲೋಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿ. ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಇದ್ದಾರಾ? ಇಲ್ಲ ಇದು it was reserved, some further hearing he wanted.
After my learned senior friend, I'll just take 5 minutes to just sum.
Our understanding is, from the perspective of the investigating officer and the accused, what we have understood is the order of freezing, the letter written to the bank is one under the BNSS.
Yes.
If that notice is seen, the notice which is issued by the investigating officer of the bank is under section 94 and 106.
Yes.
And we file an application on that basis, and ultimately we succeed and order of freezing has taken.
That's all right.
So that actually we're on a safe footing, because now we might as well file the report. If the report is now noticed,
Orders are passed under section 15(3) of the Buds Act as well. Application is filed under Buds Act also.
Their application was under 15.
Yes, yes.
Let's see the document itself.
No problem, you tell me, sir. Yes.
Document is at page 206.
Hmm.
Along with the memo, we filed a statement of objections. We gave a memo with documents. Please notice this memo dated 19/4/2026.
Yes, sir. ಇರ್ಲಿ ಹೇಳಿ, ನೀವು ಹೇಳಿ. ಕೊಡಿ. So ಮತ್ತೆ it should not be rehearing of the matter. Yes.
So that actually we are on the same page. 206 notices. This is what the IO writes to the bank. On the basis of it, the debit fees that takes place. Can you notice the sections there? Under section
94 and 106.
So it is under the BNSS. Now, my lords, even the petition which they filed before this honorable court, they clearly say that it is only under 94 and 106. At present, the amicus note may be noticed. What the amicus would say, amicus takes it under the Buds Act.
No, that's
it is not a debit freeze under the Buds Act.
No, go to the order passed by the court. The application that you filed for, what does that say?
Under IA 1, we get a
Under what provision of law you have?
15(3)
Ah.
and 497 and 503 of BNS.
Correct. See, direction to freeze 94 and 106, no doubt. Your application is under 15.3, read with 497, 503. What's the qualm there?
Please now notice the
Hmm.
written submission of the amendment.
Oh, tell me.
In the written submission,
Hmm.
let's say page 4
Heli.
concludes with that the amicus would say on the facts of the present case, the accounts were secured under section 31(2) of the Buds Act, which is not even the case of the investigating officer or anyway, please notice this, my lords, 32, which by section 34 has overriding effect. The question under section 106 and 107 of BNSS does not strictly arise. The respondent's application under section 15(3) were not maintainable. This is what the amicus report.
But why are you worried about that?
No, because
Why
now,
would I follow that completely?
my lords, if it is going to be 31, now for a minute, my lords, kindly notice Buds Act section 31. There are three prerequisites before you do freezing.
No, I think you're enlarging the scope of the challenge itself. Just because the amicus has said 31, 32, I will not.
I will clarify what I said. I will clarify what I said. But in any case,
let's take it that amicus felt it is under the Buds Act. Please have 31.
Buds Act.
Have 31. Now, under the Buds Act, my lords, even before there's an order of freezing, there are three essential requirements. If my lords have noticed 31, the first important requisite is reasons to believe by the investigating officer, my lord. First one. Second is he should have a written authorization of an officer not below the
31 is not even applicable here.
SP.
Yes.
Third, my lords, recording in writing.
No, 31 is not even applicable. Take it from me. Yes.
And under the proviso may be noticed, my lord.
Yes.
Proviso under 31(2) they say even if it is going to be a freezing done, it is only for 30 days.
Main section ne applicable agala. Proviso enga agala. Yes.
My lord, freezing can happen only for 30 days unless you get an order.
You forget 31, sir. Why are you getting into 31 at all? It's plain 106, 107, interplay between 106 and 107. Yes.
The other aspect which they pointed out as interplay between 106 and 107, what the learned amicus would say is there can be an amalgamation of both. You can have 106, you can have 107, you can even have an amalgamation of both, which means the investigating officer can choose to do a debit freeze either under 106 or under 107. That, my lords, in my respectful submission, is never permissible because if you do under 106, 107 does not mandate an order to be passed by the court.
Sir, whether what I interpret is a different thing, but 106 and 107 operate in different silos. that is his submission also.
Even if it is going to be special enactments, my lords, when it comes to debit freeze, there are inbuilt safeguards, whether we have it under the Buds Act, whether we have it under KPID Act, whether under PML Act, inbuilt safeguards of supervision by the courts. But when it comes to 106 and 107, my lords, if you go under 106, you would not have supervision.
Sir, those are seizures and attachments. This is debit freezement, whether it is seizure and attachment, I will answer. Yes, that's all.
My respectful submission is debit freeze on the basis of all the judgments.
Correct. It is according to you, on the basis of the judgments that are rendered, debit freezement is a seizure and attachment which will come only under 107 and not 106. That is all the submission.
Come under attachment, not seizure. That's my submission.
Attachment, seizure, ಎರಡು ಅದರಲ್ಲೇ ಇರೋದು 107. Seizure, attachment, forfeiture, confiscation, ಎಲ್ಲ 107 ಇರೋದು.
Seizure comes under 106. Attachment, forfeiture, and restoration comes
under 107.
So seizure is separate because as a point, seizure is material object.
So now your submission was that debit freezement is attachment. So attachment comes under 107. Procedure under 107 according to all the 18, 19 judgments. Yes.
I will only request your lordship. No, I just require 5 minutes not to respond to what my learned senior friend is. One, Lord, insofar as the assertion that I had said that the freezing is under 31(2), I had said generally under the Buds Act, if there is an offence registered on the Buds Act, you don't have to turn to the
107.
CRPC or the BNSS to exercise freezing powers because the Buds Act itself provides you with the power. Now, in this case, whether it was exercised under the Buds Act or under the BNSS, the state will have to answer. But if it is under the Buds Act, the special will override the general. There was no requirement to look to the 106 and
That
107
is,
at all.
no, that's again besides the point in enlarging it, not necessary. 106, 107 will answer.
Now, since the larger issue had come up and assistance was sought on that note, my submission, now that my learned senior friend has once again pointed out that debit freezing is an act of attachment, I'll only have to say this. Not in your lordship, for your lordships to see how Head Start has fallen into error, your lordship will only have to see 106, 107 from a broad perspective. My submission to your lordships is there can be situations where 106 is engaged and 107 is not engaged at all. There may be cases where 107 only is engaged, and there may be cases where both are engaged. Now, when it comes to 106, just take an instance where there is a trap. Let us say a bureaucrat has been trapped and cash has been seized. Now, when the seizure happens in a live trap, that happens under 106. According to my learned senior friend, if the seized cash, the cash which he receives on account of illegal gratification is put into a bank account, then it cannot be seized at all. It has to be only done through attachment.
No, this is plain debit freezement, Angad.
No, I'm on that. No, please see this. Whether it is cash in the physical form, whether it is money in a bank account, or whether it is the bank account itself, all of it constitutes property. And the power to seize property is traceable to 106. Now, the debit freezing is a mode of seizure. When it comes to tangibles like physical cash, you will go and impound, seize it. When it comes to money in a bank account, you cannot physically seize it because it's intangible. So you'll have to give a prohibitory instruction to the bank. And that's where Tapas Neoji says prohibitory instruction comes within the meaning of seizure. So to say debit freezing is only attachment is to confuse mode of seizure with the power of seizure. The power of seizure will apply equally to bank account, money in a bank account, and money physical form. The mode of seizure is debit freezing, which in Tapas Neoji that has been recognized. And therefore, Lord, your lordship will have to see 106. The question is, what is the connection to the crime? If there is any connection, either evidentiary, instrumentally, or from an objective point of view, or proceeds, not 106 gateway opens. The 106 question, 107 question answers whether the property is also proceeds of crime. So therefore, Lord, your lordship will have to see where Head Start goes wrong is in saying it can only be proceeds of crime, but not any of the three evidentiary, instrumental, or objective.
No, whether 106 is engaged or 107 and 7 is engaged, I am completely engaged.
One sentence, Lord. The account in this case is the weapon to commit crime. The argument of learned senior counsel, if I take it and give an example, my lord, someone is shooting an AK-47. First, you go to police station, register an FIR, go to magistrate and seek for an attachment, come back and take the AK-47. Account is the AK-47. People continue to deposit the amount. When the deposits are happening, we can't adopt 107. It's a evidence.
No, I asked a simple illustration. A call comes to the cyber command center by a victim who has lost 50 lakhs. She knows where he or she knows where the amount has gone, who has defrauded that person. So call comes and debit freezement will have to happen immediately. If crime has to be registered and it has to go before the learned magistrate, seek permission. ಬೆಳಗಿನ ಸಾಯಂಕಾಲದವ್ರು ಕೂತ್ಬಿಟ್ಟು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟ ಮೇಲೆ ಇಲ್ಲಿ ಹೋಗಿ ಅದನ್ನ ಡೆಬಿಟ್ ಫ್ರೀಸ್ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ 50 lakhs ಮಾಯ.
And your lordship has seen, your lordship has seen amounts.
And in cybercrime, as I mentioned it, my lords, the 48 bench is looking into the SOP so far as cybercrime is concerned. Now, we are not dealing with cybercrime.
No, it's before me only. ಗೊತ್ತು ಸೂರಜ್ ಅವ್ರದಲ್ಲ, ಹೌದು, ಒಂದು ನನ್ನ ಹತ್ರನೂ ಇದೆ.
That's on a different point as to whether outside state.
1191.
No, outside state when they debit freeze here, what should be the solution?
Anyway, that's a different thing. No, that's a typical illustration where the victim's amount can vanish due to delay.
Since cybercrime, my lords, lead is going to be marked. Now, my lords, please notice this. Now, the interpretation is going to be under 106, you can do
On 107, you can't do it, definitely. Obviously, you can't do it.
107 is not required, you don't need supervision at all.
No,
Why
no.
do we require 107 if
107 does not speak of supervision because it is by the magistrate. Where is the question of supervision there?
106 the IO debit freezes, he does not have to, they have to go under 107.
He has to go into the custody disposal chapter.
No, no.
In all the other enactments, kindly notice all the
See,
special enactments.
107 subsection 3 mandates that the IO who does directs debit freezement of a particular account report it to the magistrate without delay.
106.
106 alle, 106.3 I'm saying, yes.
That is the supervision.
Just explain the difference in this. In the special enactments, where the power to seize is given to the IO, my lord, it is with a rider that your power to seize is only going to be for 30 days. In that 30 days, the designated court will have to pass an order, failing which bank will not continue with the debit freeze. Any of these special provisions is that. Now in BNSS, we don't have that. Now if that is the case, my lord, says you will see the Banks Act also. In any provision, 30 days, within 30 days, there should be an order by the designated court. Now, if under BNSS, if 106 and 107 is seen, if the IO says, I am debit freezing under 106, I have informed the magistrate. I don't need any orders for having this debit freeze beyond 30 days. No. Then 107, in my respect to submission, introduction of 107 is absolutely rendered effective.
Correct. If 107 is kept as it is, as the submission is said of judgments, prima facie 106 becomes redundant.
106 is seizure, 107 is attachment. Bank debit freeze
Is that I will consider whether it is attachment or seizure. Correct. There everything considers it to be attachment. Head star. There are only Justice Suraj has deferred and Division Bench Allahabad has deferred. Division Bench Allahabad considers all the judgments.
That was a case of seizure of gold. It was not debit freeze.
Which is why I was giving the example of physical cash.
Wait.
So, in my respectful submission, the only differing judgment is that of
Allahabad.
Other than that, the consistent view has always been, if it is debit freeze, it amounts to an attachment. If it is attachment, you get the permission of the magistrate. This is a consistent view of all the judgments that we write on.
We'll answer it. Don't. Yes.
Because otherwise, 106 IO seizes it, you can see quite after that.
He can't sit quite after that. He has to inform the magistrate, it becomes the property of the court.
And in this case,
after that, where is this order passed by the magistrate to extend that attachment?
He has to pass.
No, Lord, in this case, it is said that under. Sir, just one.
Magistrate does not have to pass an order. You report to the magistrate, it stops there. So what happens to 107?
If once you seize under 106, nothing can be done. Nothing can be done. How did they go under 451, 457?
That is the magistrate, sir.
They have gone there and they got it defrozen.
We'll see. We'll fill in that lacunae if possible.
70, if you are considering it, Buds Act 17.
No, I am not considering Buds Act at all. Yes. Plain 106, 107, because prima facie you say that I am bound by 19 judgments. Mine will be the 20th. We'll see. No, coordinate bench. No. Sachin Magdum.
He has held that it is an attachment.
On that judgment,
that is head star.
But 106 no discussion in that.
But on that judgment,
106 no discussion.
I thought I've seen.
This is one thing, Lord, on that judgment.
Probably this note given by us on
No, don't. It's all right. Nope.
On that,
don't get worried with the note.
Yes. On that judgment, Lord, their legislative intent has been drawn from Head Start's judgment and the submission of my learned senior friend.
You had appeared in that.
He had appeared.
Oh, ನೀವೇ appear ಆಗಿದ್ದು. Sachin Magdum or orderly.
So my learned senior friend had argued that the legislative intent is that the BNS brings a change in regime. Now that on the basis of my learned senior's submission has been drawn to be the legislative intent. Legislative
that
intent
is why
can't be drawn from submissions, but has to be drawn from the historical
all right,
debate. In this case, unfortunately, there is none.
Notice all the judgments
No, I have to, sir. I have to. Whether I follow or not, I have to notice all 19.
Why, Manoj, I pointed out each of the judgments thereafter, there has been an improvement to its
Correct. One paragraph is added. No, of importance, just like that, Allah. Importance. Yes, yes. Yes.
Lordship must distinguish head start on facts and law.
We'll see. Yes. All right. Sak.
Andhra Pradesh, how they have gone.
I-
It's all
Part of the compilation, all you will find all 19 judgments considered. Yes. In the 20th judgment, I write. Yes.
Yes, grateful.
Grateful.
Dog. Very reserved. The matter was heard and reserved. The learned senior counsel had made a mention that he would wish to argue further in the teeth of the note submitted by the submission note of the amicus. Therefore, the matter is posted for further hearing today. The matter is reheard, re-reserved. Yes.
Grateful.
A dog. Seal number 12. You are there? Yes. What is this judgment?
This court that say that when there's an FIR filed on the basis of cruelty towards animals, the dogs should not ordinarily be given back to the accused pending trial.
The petitioner, People for Ethical Treatment of Animals India, PETA for short, are at the doors of this court calling in question an order passed by the concerned court dated, what's that? Where is your prayer, sir?
What's page 33, dated 25th April 2026.
Where do I get it? Just a moment. Dated 25th, dated April the 25th, 2026, by which the application filed by the second respondent under section 497 and 503 of the BNSS is allowed, and 9 dogs that were taken custody of by the PETA is directed to be returned to its said owner. Facts in brief, also, and so facts in brief, Germain, are as follows. The petitioner is said to be in receipt of a detailed complaint. Oh, no. Yes. Who complained to you first, sir? Yeah, you go on saying neither here.
The name is not mentioned, but the neighbor of the accused.
Where is that complaint?
It's an oral information.
Oral information.
Along with the videos that they have supplied to us.
Yes. The petitioner, PETA, is said to have received information, within bracket orally, that the dogs that were in the possession of the second respondent, totally 9 in number, are being indiscriminately beaten or treated indiscriminately beaten, heinous assault, as also sexual abuse. On the said complaint, on 15th February 2026, the petitioner registers a complaint before the jurisdictional police against the second respondent for subjecting the said dogs, i.e. 6 golden retrievers, 3 Shih Tzu, to repeated assault and sexual abuse and gross neglect and illegal breeding at his residence. Based upon the said crime, said complaint by PETA, a crime comes to be registered in crime number 89 of 2026 for offences punishable under section 11(1) of the Act and section 325 and 62 of the BNSS. The investigation commences on 18th February 2026, and the investigating officer is said to have written to several animal organizations for requesting the custody and rehabilitation of the dogs rescued from the hands of the second respondent. Madam. Dogs rescued from the second respondent. During the investigation process, the second respondent files an application under section 597 and 497 and 503 of the BNSS, seeking release of the dogs rescued by the petitioner to his interim custody pending disposal of the case and during the investigation. The concerned court is said to have allowed the application in terms of the impugned order dated 25th April 2026 by releasing the dogs in favor of the second respondent. It is this order that is called in question by the petitioner, petitioner PETA before this court. The learned counsel appearing for the petitioner would vehemently contend that it is the first of the case where the concerned court, despite the grave allegations against the said owner of the dogs of beating, assault, sexual abuse, has directed the release of the dogs in favor of the perpetrator of the said allegations. The council would submit that if the dogs are being ill-treated by the owner of the owner, it is it should be in the care and in the care of the Cupan another.
Animal welfare organizations in terms of
other organizations which take care and rehabilitate those dogs. They rehabilitate the rescued dogs from the hands of the petitioner in the normal circumstance. The learned counsel appearing for the respondent would, however, seek to refute the submission that he is, you are alone. The petitioner lives alone. Therefore, he has reared 9 dogs, 6 golden retriever and 3 Shih Tzu. And he is taking care of the dogs very well, and there is no warrant of interference with the order passed by the concerned court, as the dogs are hale and healthy with him, and all the other allegations are a figment of imagination of PETA, as there is no written complaint by any person to PETA. The learned counsel submits that the order would not warrant any interference. I have the learned HCGP would toe the lines of the petitioner in contending that the dogs must be in a place where they are rehabilitated appropriately. Allo dog idea. Yes.
That's 2 points. One is that it was also filed on the basis of the videos that were.
But I'm coming. No reason, Kotila. Wait. I have given my anxious considerations also. The afore narrated facts lie in a narrow compass at this juncture, as what has driven the PETA to this court is the order passed by the concerned court, which directs the dogs to be given back to the owner. Why the dogs were taken custody by PETA is a little history that has to be noticed. The petitioner, the second respondent, claims to be the owner of 9 dogs, 6 golden retriever and 3 Shih Tzu. The dogs were being ill-treated by assault or by sexual abuse is the allegation is said to be the oral complaint registered by the neighbor to the organization PETA. Based upon this, the complaint comes to be registered before the jurisdictional police by one of the representative of the petitioner of alleging blatant unethical treatment to the dogs that were in possession of the second respondent. The complaint reads as follows, page 47 to 49. The investigation was underway And in the course of the investigation, the PETA, prior to the commencement of investigation, the PETA is said to have taken custody of the dogs and also secured a relinquishment from the hands of the owner of owner of the dogs. The relinquishment is appended to the petition. The second respondent would file an application before the concerned court under 497 and 503 of the BNS. The concerned court, by the following order, has directed that 3 golden retriever, wait, 3 plus 3, 6 golden retriever and 3 Shih Tzu dogs that is seized by Pina police on the direction of request of PETA be returned to its owner for interim custody till the disposal of the case. Order page 40, 38 to 42. A perusal at the order shocks the conscience of the court. The learned magistrate appears to have lost sight of the fact that ethical treatment to the animals is imperative. What the photographs depict or a screenshot depicts in the case at hand, video of which is also seen, video of which was also shown to the court, that the owner of the dog has repeatedly beaten every dog and has treated those dogs like chattels that he can deal with it as and how he wants. In the teeth of this video or the photograph, it is ununderstandable as to how the concerned court could pass an order directing the dogs to be returned to the perpetrator of the crime. The investigation is still underway with regard to the owner, the second respondent, sexually abusing the dogs as well, as that is also one of the allegations. In such circumstance, the order of the concerned court directing the return of the dogs is, to say the least, preposterous. Therefore, the order of the concerned court which directs return of the dogs cannot sustain even for a minute. It should meet its obliteration. Before I say omega to this order, it would not be inept to refer that animals, though bereft of human speech, are not bereft of sentience, suffering, or the capacity to experience pain. The law, in its civilizational wisdom, has long ceased to view animals as mere chattels existing solely for human utility. They are not. The law now recognizes the animals also to be living beings entitled to dignity, compassion, protection from cruelty. The measure of a civilized society is often reflected not merely as to how it treats its fellow humans, but as to how it extends mercy and justice to the voiceless creatures that inhabit in its shared world. Therefore, every act of cruelty against an animal is not merely an injury to a sentient being, but a blemish upon the collective human conscience. Protection of animal life, therefore, is not an act of charity. It is an affirmation of constitutional morality and recognition that the arc of justice must extend even to those who cannot knock at the doors of this court by themselves. For the aforesaid reasons, the following order. Allowed, the order stands quashed. The dogs which are in the care and concern of CUPA or whatever it is, they shall continue there, subject to the result of the investigation.
Please.
Yes.
Grateful, my lords.
230 mood matters. Fresh matter still number 1, Shri Vinod Kumar M.
Vinod Kumar. What's that?
Parties are present, madam.
Offense.
Offense 420 and 409 and 420.
Then casual, yeah, 420.
Well, the allegation is
Yes.
only that salary is not paid in the.
All right, yes.
Both are present. Much of them.
Wakalat.
Respondent files.
Parties are present?
Yes, ma'am. Wakalat is filed
I-
along with the joint memo and affidavit.
Order sheet signatures. Number 2, Sundaraman MV.
Petitioner.
Settlement.
ಇಲ್ಲ ಅಲ್ಲ ಸುಂದರ
ನೀವೇ ಹೇಳಿ.
In December of 2019, there was a protest going on all over the country about this CAA. So on 19th of December, some protest was called for in near the town hall, and they had obtained requisite permissions, etc. On 18th evening, the Director General cancelled the permission, and then
ಇದು ಬೇರೆಯವ್ರದೆಲ್ಲ ಕಾಶ್ ಆಗಿರ್ಬೇಕಲ್ಲ.
ಹೌದು ಕಾಶ್ ಆಗಿದೆ.
How are you left out?
I was also one of the
No, because if I have seen everybody else's is cost, where are those orders, Kudi? So even before this order, they have accused, how many accused? I think the learned judge follows
no, there's no
division
reference.
bench's order.
Yes, division bench quashed the order of the Director General.
Exactly. That Soumya Reddy's case.
Yes.
Will quash it. Enilla. Others are quashed.
Please.
Division bench had quashed the order itself of the police. Yes, allowed quashed. But the petitioner is before this court. Petitioner accused number 4 stands at the doors of this court calling in question CC 5618 of 2020 registered for offences punishable under so and so. Heard the learned senior counsel Arun Kumar appearing for the petitioner. The issue in the list relates to a particular promulgation in the year 2020 in the teeth of COVID-19. It was COVID, right?
2019.
2009, not COVID. But it's a 2020 order. In the teeth of, an order of the year 2019. This had become the subject matter of the division bench proceedings before the division bench in writ petition 52731 of 2019 and connected cases. The division bench, in terms of its order dated 13th February 2020, recognizing the right to protest, had obliterated the order passed by the then Director General. Several of the accused took advantage in the teeth of the quashment of the very order itself. The crimes so registered against every other accused stood quashed by judgment of the coordinate bench in writ petition 23579 of 2021. The order reads as follows. Who remained in the fray is the present petitioner, accused number 4. The accused number 4 is also entitled to the same benefit that is granted to the other accused by the coordinate bench for the very reasons allowed quashed. Yes.
Number 3 is Sudhadi.
Well, I'm appearing for the petition. Malas, FIR has been registered against the petitioner, Malas. The respondent number 2 is the advocate, Malas. After filing of some civil cases, Malas, he will send the notice to the
In the
petitioner,
meantime,
Malas.
yes, next. State.
Please, Malas.
Orders. Bill number 4, Srimati Arati.
Withdrawal, Your Lordship.
For withdrawal. Charge sheet.
Charge sheet file ಆಗಿದೆ.
Charge
Fresh
sheet
petition.
memo ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲ ಬರೀ
ಇಲ್ಲ memo
charge sheet format.
Right.
Bill number 5, Shri Vishruti.
Yes, Vishruth.
Offences are 110 clause 4 and 5, Your Honor. 310 clause 4 and 5, Your Honor.
I'm sorry, I'm not able to get what you say.
Offences are punishable under section 310 clause 4 and 5, akin to
Of what?
of VNS,
Oh, yes.
akin to 399 and 402 of IPC.
Oh.
Annexure A is the FIR, Your Honor.
All right.
It is at the preparation stage. I'm not
Preparation stage?
No, 399 402. I am a jeweler. I was served with a notice at annexure.
What were you preparing?
Not me.
Oh, they. Yes.
Accused persons. Notices were served on me on 21/6/2025.
All right.
B and C are the notices.
All right.
In the notice, it says that I have to appear before forthwith.
Appear?
No, here, as soon as the notice was served, I was taken into custody.
You are in custody now?
I'm in custody now.
Okay.
Here, Your Honor, this petitioner has nothing to do with this case, and there is no theft, there is no robbery. I'm a jeweler.
But problem is 411.
Yes, Your Honor. In
Buying articles that are thieved.
Absolutely. In this case, there is no such allegation either. There is no such act that has happened. The allegation against me is that in some other case that I have received the stolen material, for which also none of the material is placed. I was not informed of which case or what it is. I want to take the court's attention to the very annexure, the notices itself, Your Honor. Your Honor, here it only says 310 clause 4 and 5. No FIR is given to me. No statement is given to me. There is an SOP that is already in place.
Who has issued?
The Director General of Police.
Oh.
This is at annexure D, where it clearly says, in case if at all, if there is any such act that has to happen, if at all, if there is any recovery that has to happen, 1, 2, 3, the SOP has to be followed.
ಸ್ವಲ್ಪ ಇರ್ತೀರಾ ಒಂದ್ ನಿಮಿಷ? ಎಸ್ ಸರ್. ಅವ್ರು ಕನ್ನಡ ಬರುತ್ತೆ. ರಿಸೀವರ್ ಆಫ್ ಸ್ಟೋಲನ್ ಗೋಲ್ಡ್ ಕಸ್ಟಡಿ ಯಾಕೆ?
ರಿಕವರಿ ಮಾಡಕ್ಕೆ
35(3) ನೋಟಿಸ್ ಎಲ್ಲಿ?
35(3) ನೋಟಿಸ್
ಅರೆಸ್ಟ್ಗೆ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಎಲ್ಲಿ?
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಏನು ಇಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಹಾಕಿಲ್ಲ ಅಷ್ಟೇ.
ಎಲ್ಲಿದೆ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್? ಕೊಟ್ಟಿಲ್ವಾ?
Nothing is given. 5 o'clock ನನಗೆ ಕೊಡ್ತಾರೆ, ಹಾಗೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಕೂಡ ನನ್ನ.
ನೋಡಿ, ಹಂಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ, ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ?
ಅದೇ ಅಲ್ಲಿ
ಎಲ್ಲಿದೆ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್?
ಅದೆಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್
ನಾಳೆ ರಿಲೀಸ್ ಹಿಮ್ ಫ್ರಮ್ ಕಸ್ಟಡಿ ಇಫ್ ನಥಿಂಗ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಟುಮಾರೋ.
ಎಸ್. ಏನು ಕೊಟ್ಟಿಲ್ವಾ?
Nothing is. I can even produce the video
of what?
CCTV
of what?
From my shop.
ಶಾಪಿಗೆ ಬಂದು ಕರ್ಕೊಂಡು ಹೋದ್ರು.
ಶಾಪಿಗೆ ಬಂದ್ರು, ನೋಟಿಸ್ ಕೊಟ್ರು, ಹಾಗೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಕೂಡ. So I in fact actually told that if at all if there is anything, I'll appear before the investigation officer tomorrow itself.
ನಾಳೆಗೆ ಸೆಕ್ಯೂರ್ ರೆಕಾರ್ಡ್.
We'll take it tomorrow itself. Yes. Tomorrow in the fresh matters list. ಜಗದೀಶ್ ಸರ್, ಇದೊಂದು, ಆಮೇಲೆ ಇನ್ನೊಂದು ಎರಡೂನು ಬೋತ್ ಕಸ್ಟಡಿಲಿ ಇದ್ದಾರೆ ಇಬ್ರು.
Yes.
And that husband custody ಇತ್ತಲ್ಲ ಯಾವುದು?
That is not listed today.
ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಎಸ್.
Admission, seal number 6 and 7 withdrawn. Number 8 also. Seal number 8, Nishant SK.
Waiting for petition, my lord. Withdrawal, my lord.
Thank you, sir.
Yes. There was a stay, my lord. Charge sheet has been filed.
ಸ್ಟೇ ಇದ್ದಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹೆಂಗ್ ಹಾಕಿದ್ರು?
ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಮುಂಚೆ ಸ್ಟೇ ಆಮೇಲೆ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಸ್ಟೇ ಆದ್ಮೇಲೆ ಹಾಕಿರಲ್ಲ, ಮುಂಚೆ ನಿಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಅಷ್ಟೇ. ಅಥವಾ in quick succession ಆಗಿರುತ್ತೆ. Anyway, you challenge it immediately.
I seek liberty, my lord.
That's all.
Voting settlement. Number 9, Shri Abhishek Malipati.
My lords, I appear, my lords. Sir, reporting settlement, my lords.
Offense?
118, my lords, grievous hurt.
What's the wound certificate?
My apology.
Wound certificate?
Yes.
ಏನಿದೆ?
Full injury, my lords.
Then fine. ಕೊಡಿ. This complainant ಯಾರು?
Complainant is, yes.
Who's the complainant?
He's the complainant.
Accused?
Yes.
ಇದಾರಾ?
Yes.
All right, yes.
One is grievous.
307 ಅಲ್ವಾ? 307 ಅಲ್ಲೇ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳ್ತಾರೆ.
Great.
ಲಿಟಿಗೇಷನ್ ಕಮ್ಮಿ ಆಗ್ಲಿ, ಸುಮ್ಮನೆ ಇರಿ ಮೇಡಮ್. ಎಸ್, ಹೀನಿಯಸ್ ಒಫೆನ್ಸ್ ಆದ್ರೆ 10 years and yes.
Odd sheet signatures.
Next.
Till number 10, Mark KG.
Lord settlement. Lords, seal number 123 and 124 also same lots. 490 ATM.
123, 124 of the second list plus
And my lords.
10
Now this
10, 498.
498 and other.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Lord family court we have settled the matter.
ಆಯ್ತು
Lord,
ಸರ್.
now
ಎಸ್, ಕೊಡಿ ಅದು.
parties are present. There are 3 cases.
ಆಮೇಲೆ ಮಾಡ್ಕೊಂತೀವಿ ಮೇಡಮ್.
Number 11, Srimati Shailashri.
And to the petitioner, Your Lordship.
ಸೆಟಲ್ಮೆಂಟ್?
Yes, yes.
ಒಫೆನ್ಸ್ ಏನ್ ಮೇಡಮ್?
417, 418 and 420.
ಎಸ್, ಕೊಡಿ.
And
ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ.
Yes.
Affidavit along with wakalat.
ಹತ್ತೊಳ್ಳಿ ಮೇಡಮ್. ಅಫಿಡವಿಟ್ 417, 420.
Affidavit and wakalat.
Parties?
Parties are present.
All right. Yes. Complainant?
Complainant.
Complainant, accused ಎಲ್ಲ ಇದ್ದಾರಾ?
Both present, madam.
Yes, next. ಆಯ್ತು.
Odd sheet signatures. Till number 12, Puneet C.
So, married,
Odd sheet
marriage
signature.
certificate.
Offense.
My lord,
Sorry.
Section.
Sorry.
Please.
At the time of incident, what was the age?
My lord, they say that please, my lord, she was minor.
Of course, minor, sir.
Allah, my lord, she is not minor is what my contention. In fact, please, my lord, the complaint is by through social worker, not by the wife or their family members.
ಮದುವೆ ಆಗಿದೆ. ಮಕ್ಕಳಿದ್ದಾರಾ?
ಮಕ್ಕಳಿದ್ದಾರೆ.
ಮಕ್ಕಳು ಅವರು ಮಗು.
ಮಗು. Absolutely no dispute. In
Filing a wakalat also.
That's the child, is it? Huh?
That's
ಬರಲ್ಲ. ಇಲ್ಲಿ ಸಫೋಕೇಟ್ ಆಗೋದು ಬೇಡ, ಆಚೆ ಇರಕ್ಕೆ. ಆಮೇಲಿಂದ ಸೈನ್ ಮಾಡಿ. ಯು ಗಾಟ್ ಹರ್ ಮತ್ತೆ ಸಿ. ಎಸ್, ಆಲ್ ರೈಟ್.
ಪ್ಲೀಸ್.
ರಿಜಿಸ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಪ್ರೊಡ್ಯೂಸ್ಡ್ 46 and 376.
ಸರಿ.
Odd sheet signatures.
ಮ್ಯಾರೇಜ್.
13, Karthik Kumar.
Petitioner in this case.
Offense.
304A, 106 class.
304A. 304A.
106.
He said on merit, 304A, my lord.
ಬರೋ ದುಡ್ಡು ಬರಲ್ಲ. ರ್ಯಾಶ್ ನೆಗ್ಲಿಜೆಂಟ್ ಆಕ್ಟೇ ಇರಲ್ಲ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
They are giving TD, madam, 2 lakhs.
2 lakhs.
2 lakhs.
ಮಗು ಸ್ವಾಮಿ 2 ವರ್ಷದ.
ಅದಕ್ಕೆ? That is too less. I will not. 2 ಲಕ್ಷ ಯಾರು ಒಪ್ಕೊಂಡಿದ್ದು 2 ಲಕ್ಷಕ್ಕೆ? ಏನ್ what are you? ಕಾಂಟ್ರಾಕ್ಟರಾ?
3 ಜನದ ಮೇಲೆ ಆಗಿದೆ. ಓನರು, ಕಾಂಟ್ರಾಕ್ಟರು ಪ್ಲಸ್ ಮತ್ತೆ ಇವ್ರ ಮೇಲೆ ಎಲ್ಲಾರು 3 ಜನದ ಮೇಲೆ ಆಗಿದೆ ಸರ್.
ಓನರು, ಕಾಂಟ್ರಾಕ್ಟರು
ಮತ್ತೆ ಮೇಸ್ತ್ರಿ 3 ಜನದ ಮೇಲೆ.
ಮಗು ಎಲ್ಲಿ ಸತ್ತಿದ್ದು?
ಅವರು ನಮ್ಮಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರಲ್ಲ ಸ್ವಾಮಿ, ಬೇರೆ ಪಕ್ಕದ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದವರು ಬಂದು ನಮ್ಮಲ್ಲಿ ಎಕ್ಸ್ಪೈರ್ ಇದ್ ಮಾಡ್ತಾರೆ. ಮಗು ಬಿದ್ದು ನೀರಿನ ಗುಂಡಿಗೆ ಬಿದ್ದು ಸಾಯುತ್ತೆ.
ನಿಮ್ಮ ಸೈಟ್ ಅಲ್ಲಿರೋ ನೀರ್ ಗುಂಡಿಗ? ಆಬ್ವಿಯಸ್ಲಿ ಅಲ್ಲೇ ಎಲ್ಲ ಕೆಲಸ ಮಾಡ್ಲಿ. 2 ಲಕ್ಷ is too less. Nothing doing for a child. Don't treat human life so cheap. Nothing doing. Just how much you increase it and come, I will settle it. ಅವ್ರೇನೋ ಬಡವ್ರು ಏನೋ 2 ಲಕ್ಷ ಸಿಕ್ಕರೆ ಸಾಕು ಅಂತಾರೆ. No. That can't be. ಅದು ಏನು 3 ಜನ ಸೇರಿ 2 ಲಕ್ಷ? ಓನರು, ಕಾಂಟ್ರಾಕ್ಟ್ರು, ಆಮೇಲೆ
ಇದು ಮೇಸ್ತ್ರಿ ಸ್ವಾಮಿ.
ಆ ಮೇಸ್ತ್ರಿ ಬಿಡಿ, ಓನರ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಸೇರಿ ಕೊಡಕ್ಕೆ ಹೇಳಿ ಫಸ್ಟ್.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ವಾಟ್ ಈಸ್ ಆಲ್ ದಿಸ್? 2 lakhs. ಯಾರು, ಹೂ ಆರ್ ದಿ ವಿಕ್ಟಿಮ್ಸ್ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ?
ಈಸ್ ದ ಫಾದರ್.
Yeah, who is the father? 2 lakhs I will not accept. I will permit trial now. Come up with a better thing. Not.
Okay.
2 ವರ್ಷದ ಮಗುಗೆ ಅಷ್ಟು ಚೀಪ ಲೈಫ್? ಎಷ್ಟು ವರ್ಷ ಮಗು?
2.5 years.
2.5 years.
2 years under.
That's so cheap, is it? Life is not that cheap, sir. Come up with something else. ಏನು ಬಡವರು ಅಂತ ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಅವ್ರು ತಗೊಂತಾರೆ, ಅವ್ರಿಗೇನು ದುಡ್ಡು ಬರುತ್ತೆ ಅಂತ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. That's not the way to look at it. You can't throw pittance and get away with the crime. I will not permit it. Come up with a better offer. Better offer ಅಂತ 25 ಸಾವಿರ ಜಾಸ್ತಿ ಮಾಡೋದಲ್ಲ, ಗೊತ್ತಾಯ್ತಲ್ಲ? Go and see and come. I'll take it tomorrow if you want.
Okay.
Tomorrow ಇಲ್ಲ Monday, Tuesday ಯಾವಾಗ ಬೇಕಾದ್ರೆ ತಗೊಂತೀನಿ. But 2 lakhs I am not going to settle it. I will permit trial in this case.
Okay.
Yes.
Next time.
Don't misuse the innocence of poor people. Yes. Next. Tuesday ಹಾಕ್ಬಿಡಿ. ಮಂಗಳವಾರ. ಅಷ್ಟರಲ್ಲಿ ಇಬ್ರು 3 times that ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಎಲ್ಲರೂ ಸೆಟಲ್ ಮಾಡಲ್ಲ ನಾನು. Yes.
14 also.
69 BN.
69. ಮದುವೆ ಆಗ್ತಾ ಇದ್ದಾರಾ? Fulfilling the promise to marry. Very good. Yes. ಅದು ಕ್ಲೋಸ್ ಮಾಡಿ.
He is in JC, my lord. He is in JC.
ಅದಕ್ಕೆ now you are in JC ಅಲ್ವಾ? Come up with a better offer. Ilder you will remain in JC. ಮಗುಗೆ 2 ಲಕ್ಷ ಎಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
ಇದು ಬೇರೆ ಸ್ವಾಮಿ. ಸೇಮ್
ಇರಲ್ಲ ಅಲ್ವಾ? ಯಾವ್ದು JC ಇದ್ದೀರಾ? ಇದು ನೀವೇನಾ?
ಅದು ನಾವೇ.
ಓ ಕರೆಕ್ಟ್. ಕಾರ್ತಿಕ್ ಕುಮಾರ್. ಎಸ್, ವಿಲ್ ಸೆಟ್ಲ್ ಇಟ್. ಮದುವೆ ಆಗ್ತಿದ್ದೀರಾ? I'll give you interim bail.
ಸ್ವಾಮಿ ಆಗ್ಬೋದು.
I'll give you interim bail.
ಆಗ್ಲಿ ಸರ್.
ಯಾಕಂದ್ರೆ ಆಚೆ ಬಂದ್ಮೇಲೆ 69 ಬಿಟ್ಬಿಡ್ತೀರಾ ನೀವು.
Respondent.
ಆಯ್ತು.
Direct today itself, my lord.
Today itself, you marrying today itself?
Within 15 days I will marry the.
Yes.
ಅದಕ್ಕೆ direct JC to release today.
The petitioner is before the court. Petitioner now in judicial custody has knocked the doors of the court, calling in question the offence under section 69 of the BNS. The reason for moving the matter is that the petitioner who is in custody is now wanting to fulfill the promise of marriage, to demonstrate that he has not had the relationship with the complainant on deceit. Therefore, I deem it appropriate to permit the petitioner release the petitioner on grant of interim bail for a period of 3 weeks from today, for the purpose of getting married to the complainant. The petitioner, as undertaken, shall marry the complainant and produce the certificate of marriage within the next 3 weeks. The registry is directed to communicate this order to the jail authorities to enable release of the accused number 1. Accused number 1, sole accused.
Accused number 1, my lord.
Sole accused.
No, my lord.
Accused number 1, who is now in prison for the purpose of marriage with the complainant. With the complainant, yes. List them 3 weeks between date code. List the matter on 29th July at 2:30 PM for further hearing. Yes. Certificate should be produced next time. And Amele, if you leave the lady in the lurch, 69 will spring back. All right, yes.
Reporting settlement, list number 2, serial number 119.
Serial number 119 and 121 are pertaining to same parties, my lord. Both the parties are present.
ಆಯ್ತು ಕೊಡಿ. offense ಏನು?
Offense 490 and 3 and 4 of dowry prohibition.
ಆಯ್ತು.
I am filing joint memos, my lord. To settle.
And I may be permitted to amend the prayer, my lord. CC number has been now changed to SC number.
ಓ ಕಮಿಟ್ ಆಗಿದೆಯಾ? ಒಫೆನ್ಸ್ ಯಾಕೆ ಕಮಿಟ್ ಆಯ್ತು?
ಅದು ಅಬಾರ್ಷನ್ ಇತ್ತು, ಅದಕ್ಕೆ ಕಮಿಟ್ ಆಯ್ತು. ಪಿಟಿಷನರ್ ನಂಬರ್ 1 ಇರಲಿಲ್ಲ.
ನಾಟ್ 304B ಅಲ್ಲ ತಾನೆ?
ಇಲ್ಲ ಇಲ್ಲ. ಇಸ್ ಜೀವಂತ ಇದೆ.
313 ಇರಬೇಕು.
ರೆಸ್ಪಾಂಡ್ ಇದೆ, ಇದಾಳೆ. ರೆಸ್ಪಾಂಡ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್.
304B.
ಅಲ್ಲ ನೀವು 304B ಅಂದ್ರೆ ಐ ಆಮ್ ಹ್ಯಾಂಡಿಂಗ್ ಓವರ್ ದಿ ಡಿಡಿ.
ಗೊತ್ತಾಯ್ತು. ಆಫ್ ಅಮೌಂಟ್
3.5 lakhs. Earlier I have paid 4 lakhs.
ಆಯ್ತು ಸರಿ. So and so hands over a demand draft of rupees 3.5 lakhs and has earlier paid about 4 lakhs, which is acknowledged by the counsel for the complainant and the complainant who is present before the court. All right.
I may be permitted to amend the prayer.
ಅಲ್ಲಿ ಮೇಡಮ್ FIR ಅಲ್ಲ, SC ನಂಬರ್ ತಗೊಳ್ಳಿ. ನಂಬರ್ ಕೊಡಿ. SC
725 of 2026.
SC ನಂಬರ್ 725 of 2026.
275.
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, ಯಾವ್ದೋ SC ಕೋಶ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ.
ಇಲ್ಲ 275.
ಬರ್ಕೊಡ ನೋಡ್ಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಕಾಸ್ಟ್.
Order sheet signatures.
Please. 21 is arising out of Domestic Violence Act.
120, Tejas N.
But 109.
ಇಂಜುರಿ
Simple in nature.
ಎಲ್ಲಿದೆ wound certificate?
30 and 31, my lord.
Just
Type
state
copy.
wound certificate.
30 and 31 is type copy.
Respondent
This is state.
State ಗೆ ನಿಮಗೆ ಕೇಳ್ತಿರೋದು, where is the wound certificate?
Page number 28, your lordship.
What does it say?
It's a simple injury. It says.
ಸಿಂಪಲ್ ಇಂಜುರಿ ಅಂತಿದೆಯಾ? ಎಸ್ ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್ ಜಡ್ಮೆಂಟ್ ಕೋಟ್ ಮಾಡಬೇಕು. ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಮಾಡಬೇಡಿ, ಚೇಂಬರ್ ಬಂದು ಒಂದು ವಾರ ಸುಮ್ಮನೆ ಇರಿ.
Please, please.
ಎಸ್
Grateful.
Order sheet signatures. 122. Mahesha, Maheshwari.
498.
498 ಅಷ್ಟೇನಾ?
498.
ಎ ಇಲ್ವಾ?
498A.
ಎಸ್ ತಗೊಳ್ಳಿ. ಎಸ್
Handing over the 5 lakhs check to the.
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ದ್ಬಿಡಿ ಮೇಡಮ್, 5 lakhs. ಎಸ್ ಚೆಕ್ಕ.
Sorry, DD ಮೇಲೆ.
DD. ಎಸ್
DD has given.
ಎಸ್ ನೆಕ್ಸ್ಟ್.
Order sheet signatures. 123. Page J. ಆಯ್ತಲ್ಲ? Correct. Yes. ಆಯ್ತಲ್ಲ? 125 ಅದು 7th ಇರ್ಬೇಕು. Past over settlement 40. List 140.
In this case, my lord.
Offense.
Offense 498A, my lord. Filing joint affidavit. Both the parties are.
ವಕಾಲತ್ ಕೊಡಿ.
File ಮಾಡಿದ್ವಿ ಕೌಂಟರ್.
ಕೌಂಟರ್ ನೇಮ್ ಕೊಡಿ. ನೇಮ್ ಬರ್ಕೊಡಿ.
ಯಾವ್ದು 498 ತಾನೆ ಸೆಟ್ಲ್? ಅದೇನು
Order sheet signatures.
ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ. ಎಸ್ ಪಿ ಪಿ ಅವರ ಯಾವುದಿಲ್ಲ ತಗೊಳ್ಳಿ. ವಿಡ್ರಾಲ್ ಮಾಡಿಬಿಡಿ. ಲೆಟ್ಸ್ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಎಲ್ಲಿಗೆ ಬಂದ್ವಿ ನಾವು? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
Past over matters, list number 2, seal number 2.
The petitioners, my lord.
ಪಾಸ್ ಅವ್ರು ಯಾಕಾಯ್ತು?
For the second respondent.
You should come from this side. ಅಲ್ಲಿ ಅಷ್ಟೊಂದು ರಶ್ ಇದೆಯಲ್ಲ.
Let's, on the last occasion,
It's in
senior made a mention, my lord, that
About what?
against him, if there is no material, my lord,
We'll quash it. ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ ಅಂತ ತಾನೆ?
ಅಂತ ಅವ್ರು
ಅಲಯನ್ಸ್ ಅಲ್ವಾ?
yes, my lord.
ಆಯ್ತು.
but the
ನಾಳೆ.
observations made, my lord, in the petition should not be, my lord.
Sorry?
The observations, my lord.
Of course,
should
it will not be made applicable to any other accused,
Yeah,
madam. ಅದು ಹೊಸದಾಗಿ ಹೇಳ್ತಾರೆ. Yes. We'll do that and, but ನಾಳೆ ಮಾಡ್ತೀನಿ. Time ಆಗೋತಿ. Yes.
Interim orders.
Hmm?
Interim orders fixed.
Overnight extension. Yes. ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಇನ್ಯಾವ್ದು ಇರುತ್ತೆ ಕರೀರಿ.
I think he has to make the bank and other people are, because
But
they
this
need
is
to
the
also
deep
be-
freeze.
tomorrow they should not come up and say, my lord, that we have not been heard. He's asking for deep freeze. 457 application.
ಬ್ಯಾಂಕ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಬ್ಯಾಂಕ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ಬಿಡಿ.
The reason is, my lord, there is no claimants.
There are no rival claimants?
No claimants. The only observation made by the trial court is that there are no sufficient materials placed to show that I am the owner of
The
the
reason
money.
for rejection
ಅಲ್ಲ,
is that the
ಈಗ-
amount is not recovered from his possession.
ಮತ್ತೆ?
Amount is recovered from somebody else. That is the trial court order.
My lord, I'll come to that. You know what has happened, my lord? My 3 crore 70 lakhs, my lord. The amount, my lord, is the the accused, my lord, he's transferred it to several accounts. That is the betting apps. He's a habitual guy, my lord. He's a habitual. So many FIRs have been registered. My lord, with that being the case, my lord, there is direct nexus. I've placed documents to show from my account to his account to his account to the said bank accounts. Direct cases, my lord.
Then ಎಷ್ಟು ಬ್ಯಾಂಕ್ ಹಾಕಿದೆ? ಎಷ್ಟು ಬ್ಯಾಂಕ್
16
ಪಾರ್ಟಿ
ಬ್ಯಾಂಕ್ಗಳಿದೆ
ಮಾಡಬೇಕಾಗುತ್ತೆ?
ಸ್ವಾಮಿ.
Tomorrow bank should not come and say
ಇಲ್ಲ,
we don't have
ಎಷ್ಟು
that.
ಬ್ಯಾಂಕ್ ನ ಪಾರ್ಟಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ? Are the banks party there? ಇಲ್ಲಲ್ಲ.
ಇಲ್ಲ.
No, you're actually in Axis Bank, each time they come up before.
I
this
know,
court.
clarification ಕೇಳ್ಕೊಂಡ್ ಬರ್ತಾರೆ ಮಾಡ್ಬೇಕಾ ಇಲ್ವಾ? But how many banks, ಎಷ್ಟು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆ ಈಗ?
16 ಬ್ಯಾಂಕ್ ಇದೆ.
ಮತ್ತೆ 16 ಬ್ಯಾಂಕ್ ಪಾರ್ಟಿ.
Betting apps, sir.
And he is the victim.
I'm the victim, my lord.
There are no rival claimants.
The only reason
ಎಷ್ಟು, what is the total amount?
That was sought for release is 22 lakhs. The amount which has been in the crime, my lord, 3 crores 78 lakhs, sorry, 68 lakhs.
ನಿಮ್ದೇನ ಎಲ್ಲ?
ನಂದೇ ಸ್ವಾಮಿ.
3.5 ಕೋಟಿ ಬೆಟ್ಟಿಂಗ್ ಅಲ್ಲಿ ಕಳ್ಕೊಂಡಿದ್ದೀರಾ?
ನನ್ನ ಅಕೌಂಟ್ ಇಂದ I am the de facto complaint. ನನ್ನ ಅಕೌಂಟ್ ಇಂದ the accused, my lord, he transfers it to various banks account. He also lends it out for interest. In that, my lord, they have seized only, my lord, 22 lakhs. On the face, the
No, I
prosecution.
think it should be given. ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕೋಣ. ನಾಳೆ will do it.
Please, yes.
ಜಗದೀಶ್ ಸರ್ ನೋಡ್ಕೊಳ್ಳಿ ಅದು. ನಾಳೆ will do it. Yes.
Fresh matter.
First fresh. Yes.
List 2, settlement seal number 7.
Very good petitioner. Section 74 and 70.
Huh?
Plain in presence of
Offense ಏನ್ ಸರ್?
74 and 75 of BNS.
Morning I mentioned charge sheet ಆಗಿದೆ ಅಂತ.
ಆಗಿದೆಯಾ?
Posed on that lines, your lordship, settlement ಇದೆ ಅಂತ.
Oh, correct.
They have
Give it, sir.
Respondent is present before the honorable court.
ಆಯ್ತಾಯ್ತು.
Present ಇದ್ದಾರೆ sir. Present.
Yes.
Right. Grateful.
Order sheets in which? Let's continue. Number 228.
For petition, my lord. Time for 1 week time, my lords.
Vacating stay ಅಲ್ಲ?
Please, my lords.
Yes.
retirement memo is filed by R2, your lordship.
ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರೆ ಕೊಡ್ಲಿಲ್ಲ ನಾನು ಏನಿದೆ.
Retirement memo is filed by
By
R2.
whom?
R2 has filed retirement memo. Both
ಅಲ್ಲ,
state
ಬೇರೆ
and-
ಯಾರು ಹಾಕಿಲ್ವಲ್ಲ ವಕಾಲತ್? ವೇಟ್.
ಹಾಕಿಲ್ಲ.
ಎಸ್. ಯಾವತ್ತು ಕಮ್ಮಿ ಇದೆ ಮೇಡಮ್? Perfect. 14th,
Please.
same stage. 39.
For petition.
Hmm.
39.
Application for the vacating they have filed.
Hmm. Yes, what's the matter?
The 498 and Dowry Prohibition Act.
Hmm.
So it is they have taken two grounds, but ultimately there is no material in the FIR itself.
Husband is the accused?
Yes, ma'am.
Stay is in favor of the husband also?
Yes, ma'am.
Hmm. Hmm.
Only he admitted to the hospital, they have taken a stand, suppressed and got the marriage. They demanded the gift, balance gift in the marriage. The complaint is clear, my lord. There is no prima facie case for the complainant. So, and also your lordship's judgments also is covered.
Husband kodala sir.
They also filed after this, my lord. They filed the divorce petition.
After this?
After
That's okay.
complaint. After complaint.
All right.
Two complaints they made. For first complaint, they kept quiet. Engagement date is the
Anyway, respondent is not there, you're saved for the day. Yes, 14th, same stage, entry orders would continue. Next.
40.
What your lordship's notes not that certain documents they have fabricated here.
ಗೊತ್ತಾಯ್ತು.
And I'm not, their affidavit is delightfully vague about what your lordship wanted to point out. And we have obtained a fresh certified copy of what has been filed before the ROC. They don't match at all. It's the case where I would humbly submit not serious cognizance would have to be taken.
Certain events that have taken place, which are placing on record. My lords may recollect, my lords, two orders passed by my lords asking us to file our affidavits. Affidavits were filed. The events that have transpired thereafter before the register of companies is what we're placing on record, my lords. That may be noticed. We have still not been able to get to the merits of the matter because this had to be sorted out before we started on the merits.
No, if this is sorted out, you have no merits at all.
That's the reason, my lords, we had to. So, my lords, probably on the basis of this, if it's going to be even in Tuesday, Wednesday, any day, my lords, we will.
Tuesday.
Any day, my lords, we will.
Tuesday under the same caption.
You've given a copy to them? Yes, but we have also given a copy of this developments that have taken place.
All right. Otherwise, you have filed your synopsis or something?
ಇಲ್ಲ main matter start ಮಾಡಿಲ್ಲ my lords. We are on the aspect of saying these documents which
So you mean to say the periphery has taken such long?
Yes, my lords, it has, because when I was to comments on the main matter, it was pointed out.
What is an allegation of fabrication there is one aspect. Fabrication here is something too serious.
Okay,
Not
we
which your
will-
lordship took
Two affidavits that have been filed plus this events that have taken place, we'll explain it out. my
Events
lords.
are
And if the
irrelevant,
court,
it's a
if the
question of
court is
comparison
going to
of
be
documents.
convinced, we can go on to the main matter, we will go on with
There
it.
is nothing, Lord, it's just a comparison of two documents.
Now,
What
it's
they have filed
ultimately,
before
my
ROC,
lords,
what is filed before the
somehow
court.
prevention of us arguing the main matter by saying what you produced here appears to be fabricated.
Absolutely it is
It is
fabricated.
only on that point we are still stuck at. Anyway, affidavits are before the court.
Not affidavit does not say a
Court
single
may
word.
consider
Your
it.
lordship may have a look at the affidavit.
Tuesdays.
Please,
Yes. Tuesday and the same caption.
please.
That will continue. Yes.
41.
For the petitioner.
Number 2 in this case.
My lords, the offense is related to 115 and 118, my lords.
Hmm.
Their allegation is that we have hit them with rods, but nowhere they have told that in the NCR report.
No, that's all right. Wound certificate?
Yes, my
One
lord.
certificate just says simple hand pain. He's complaining of hand pain.
What is the motive?
My lords,
I have produced the entire CCTV footage along
my
with
lords, in the CCTV
objection.
camera footage, there is no hitting, beating, no any sort
Then
of
what?
violence.
Then what is there?
My lords, the offense is only this, my lords, the alleged incident that we have parked the car in front of their shop, and their father, the victim himself has not given the complaint. His son has given the complaint after the lapse of 77
Of
days.
course, if you hit the father, son will complain. No problem. Yes.
My lords, there is no injuries as such, even invisible in the CCTV camera footage, my lords.
I have produced
There
the
is
entire
just
CCTV footage,
altercation, my lords.
Even I have produced the photographs out of that CCTV.
My lords,
footage.
in their NCR.
They blocked the way. Then they came. They hit me. They took my mobile. ಕಾರಲ್ಲಿ ಕೂಡ್ಸ್ಕೊತಾರೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ದೆನ್
ಎಲ್ಲಿಗೆ?
ಕರ್ಕೊಂಡು
ಹೋಗ್ತಾರೆ ದಟ್ ಫುಟೇಜ್ ನೋಡ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಅಲ್ಲ ಎಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋದ್ರು?
ಜಸ್ಟ್ ದೇ ಮೂಡ್ ನನ್ನ ಮೊಬೈಲ್ ಕಿತ್ಕೊಂಡು ಓಡಿಸ್ತಾರೆ ಬಟ್ ಇನ್ನೊಬ್ರು ನನ್ನ ಅಂಕಲ್ ಬಂದು he stops that vehicle and we secured his presence.
My lords, if you see kindly.
That is
see the
offense also
CCTV.
registered. My lord, another submission is that there is a delay. On very next day we complained. The police will not register a FIR because our 3 members ಅಲ್ಲಿ ಒಬ್ರು police relative.
My lords, no such
That was
allegations,
the
my
defense.
lords.
Photographs also, my lord.
Could
That
he-
CCTV
My lords,
footage is with
kindly-
the
It's pen drive, who has given this pen drive?
Respondent.
myself I had given.
My lords,
Respondent
in
number
their
two.
respondent pen drive also, my
Madam,
lords, he was in the car only for 10 seconds, my lords. They have not moved the car at all.
That's my.
My lords,
It's-
kindly see the
is it my
NCR
interim order?
statement. Yes, ma'am.
No, my lords.
I have granted the interim order.
My lords, kindly see the NCR report, my lords. He says, they themselves have says that Eka
Yaar
Eki
this
nama
white car?
tande.
ಅವ್ರದ್ದೇ. ಎಂಟೈರ್ CCTV footage ಅಲ್ಲಿಂದ
ಅಲ್ಲಿ ಯಾವ ರೋಡ್ ಅಲ್ಲಿ ಹೊಡೆದ್ರು ನಿಮ್ಗೆ?
ಅಲ್ಲ ಕಾರಲ್ಲಿ ಕುತ್ಕೊಂಡು ಮಾಮೂಲಿ ರಾಡ್ ಅಲ್ಲ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮೇಲೆ ಮೊಬೈಲ್ ಕಿತ್ಕೊಂಡು ಕಾರ್ ಹೋಗ್ತಾರೆ, ಕಾರಲ್ಲಿ ಕುಡಿಸ್ಕೋತಾರೆ.
My lords, this
The entire video
improvisation.
footage clearly shows, my lords. It's nothing but an abduction.
Sir,
Please, ma'am.
my lords, there's improvisation in the NCR as well, my lords. In the NCR, all he says is that Eka Eki ನಮ್ಮ ತಂದೆ ಮತ್ತು ಆ 4 ಜನ ಅಪರಿಚಿತರು, 3 ಜನ ಗಂಡಸರು, ಒಬ್ಬರು ಹೆಣ್ಣು ಮಗಳು ಮಧ್ಯೆ ಕೆಟ್ಟ ಕೆಟ್ಟ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. Now, in the FIR, my lords, he says that have threatened him for life. Only I have scolded him. And everything, and also, my lords,
ಈ ಕಾರ್ ಯಾಕೆ ಅಡ್ಡ ನಿಲ್ಸಿದ್ರಿ?
my lords, the
Reason
shop
for
was
that?
not open. We had gone somewhere out. As we would be returning, we had just parked it there and we have gone, my lords. By the time we came, their father told remove the car and we have removed it immediately. And he was
Own
the one
certificate ಕೊಡಿ.
who.
Madam, get the investigation papers.
My lords, and in FIR, they said that there was rod inside. We have hit in
Rod
the
inside?
inside the car.
Hmm.
In NCR, there is no such mention at all.
Whose car is that? You carry rods inside the car.
No, my lords.
Then?
In his NCR report, which he has given immediately after 2 days,
Hmm.
there is no mention of rod. There is no mention of scolding. There is no mention of threat of life.
Yes, get the investigation
It
papers.
can be seen in the NCR, my lords. I have produced
Well,
page number R3.
Use-
Page number, my lords.
Madam, Wednesday,
9.
under the same caption, the investigation papers till the date of grant of the interim order by the coordinate bench, i.e. 4/7/2025 shall be placed before the court on the next date, Wednesday. Yes, next.
42.
Second respondent. Lord, I appear for the petitioner. Lord.
Hmm.
Lord, the allegation in the complaint is that I trespassed, Lord, and demolished a Goshala, Lord.
Goshala?
Goshala. It's a shed, Lord.
Hmm.
Lord, the history behind this case is this, Lord, that in KGF Taluk. KGF Taluk.
1, 2, 3. Huh?
No, I don't know which one.
Yes. Hmm.
Lord, there is a temple called Lord Kotilingeshwara temple.
Hmm.
The person, Lord, who constructed the temple was one Shamba Shiva Murthy, who is the father of the complainant, the respondent. Lord, he enters into a family settlement in the year 2000, March 2000, settles all the properties of to the sons and other family members. Thereafter, my lord, he goes away to Lord Kolar. There, my lord, he has developed the temple. Now, my lord, in 2004, he executes a will in favor of the petitioner, my lord. And the will is not in respect of the property. The will only says that you will be the Uttaradhikari of the temple trust, my lord. Lord, thereafter, he died in 2018. Lord, in 2019, there is a suit which is filed by me, my lord, for a declaration that, my lord, I am the Uttaradhikari who is entitled to manage the properties, my lord. Kindly have that at page 65.
B report kotra?
B report. Now, after that, my lord, there was a protest petition. Now, cognizance is taken, my lord. Lord, I have to mention one thing, my lord. We had earlier filed a petition, my lord, before this honorable court. But we were, Lord, some communication gap was there. We were not aware that the B report had already been, Lord, set aside and cognizance had been taken. For that reason, we said, please direct the magistrate, Lord, to Lord, dispose the B report.
That's okay. Yes,
So,
tell me.
it was not decided on merits. What I wanted to point out is page 71 at the prayers in this suit.
Offense is 447, is it?
Yes.
447, 427.
Yes.
Hmm.
Now please see at page 73, what are the suit schedule?
Yes, sir.
This suit, what is being referred is for an entirely different subject
No.
matter.
Hmm.
What is sought in the suit is for declaration for managing the temples as such.
Correct.
My lord, there is no suit on the ownership of the properties.
Hmm.
What is alleged here, my lord, is mischief coupled with trespass.
Correct.
I have produced photographs, my lord, which show that certain structures were demolished. Initially, my lord, B report said it fell on account of natural causes. Gali ಬಂದ್ ಬಿದ್ದೋಯ್ತು ಅಂತ.
Hmm.
Then I have got photographs and videos of it, the sheds being dismantled.
Where is it?
I have produced. I'll place it. It is
Wednesday,
marked-
same stage, Wednesday, the learned HCGP or the complainant to produce material to demonstrate that the petitioners have indulged in criminal trespass and demolition of property of.
As part is, my lord, there is orders of this honorable court.
We'll see.
Which say that, my lord, I am in possession and I should be in possession.
Don't worry.
He has filed 25 suits after that.
We'll see. Yes. Wednesday, same stage. Yes, next.
Lord, interim order.
That will continues. Heard the learned senior counsel, Mahale, and the yes.
43.
Apologies, sir.
Serial number 38, my lord, interim order may be.
Ayyo, apologies rejected. Yes. Interim order extended. Yes, next. That extend agutte bidi, sir. Yes, next.
Appear for the petitioner, my lord.
Hmm.
Appeal for the
Page
respondent number.
16 is the impugned order. Kindly see, my lords.
Who has filed vacating stay?
Respondent number 2 has filed a vacating stay, your lordship.
41 either.
43.
43. What's the offense?
My lords, offense under section 329(3), 3144, 3184, 60B, 352, 351.
Crime stage alla stay agidya?
Crime stage yakandre.
Your
This is the
lordship.
case, my lords, wherein the case of the complainant is that her car, my lords, was given for servicing.
Ella parvayilla 175(3) violation, will send it back.
That's the
That may be done.
See, yes.
fact. That is the
See, yes, madam.
That-
ಅಷ್ಟೇ ಅಲ್ವಾ?
175. There is one more thing.
Hmm.
Like earlier 156(3). Here there has to be a specific application for reference. There is no application.
Whatever procedure is contemplated under 175(3) will be followed.
Please.
The petitioners accused 1 to 4 are before the court calling in question the reference by the concerned court to the jurisdictional police for conduct of investigation, which has then become a crime in crime number 260 of 2025 for the said offences, Madam. The coordinate bench of this court grants an interim order of stay on 6/8/2025. The order reads as follows. The interim order is granted primarily on the reason that there is violation of the order passed by, the violation of the mandate of the statute as obtaining under section 175(3) of the BNSS. The learned counsel for the respondent complainant would also submit that the court has erred in not following the mandate of the statute. The issue need not detain this court for long or delve deep into the matter. The apex court in the case of Om Prakash so and so 2025 SSC online SC page 238 has held as follows. In the light of the mandate of the law that that procedure under 175(3) must be followed prior to issuance of directions for the purpose of investigation as obtaining under 175(3), the petition deserves to succeed, albeit in part, with the order of reference to be obliterated. For the aforesaid reasons, the following order. A petition is allowed in part so and so. Allowed quashed, matter is remitted back to the hands of the concerned court to pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order with an outer limit of 8 weeks from the date of receipt of the copy of the order. Yes.
Consequently, the crime has to be quashed. FIR has to be quashed. Consequently.
FIR quash ಮಾಡಿದ್ದು.
Order passed.
FIR reference order, FIR ಎಲ್ಲ quash ಮಾಡಬೇಕು. Complaint will remain.
Please.
Yes. Next.
44.
Appearing for respondent.
Petitioner matters.
Hmm.
In this case, they filed vacating stay mandates, whereas I appear for petitioner's mandates.
Yes, I know. Yes. Hmm.
So therefore, they contend that there be several allegations such as ಕೊಲೆ ಮಾಡ್ತಿದೀವಿ ಅದು ಇದು choke ಮಾಡ್ತಿದೀವಿ and things like
Choke
that.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
That's what they contend so. But it has all happened in Chandigarh is what the allegations is. They never file a complaint or whatsoever there. Here they directly come because there's a stay order. There's a case pending before the Naba court, and there's a stay order on the property. Their expectation is that almost ನಾನು ಎಲ್ಲ gift deed ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ because she is my wife. 30 years ನಾವು ಒಟ್ಟಿಗೆ ಇದ್ದೀವಿ. Thereafter, ಈಗೇನು ಅವ್ರದ್ದು is that one more flat ಇದೆ, get that to my name, register it to my name, where we deny doing it, then they come registering this case. That's what my lords also noted in the order sheet while granting the stay order.
ನಿಮ್ ಫ್ಲಾಟ್ ಬೇಕಾ?
ಬೇಡ ಮಿಲೋಡ್.
ಫ್ಲಾಟ್ ಬೇಡವಾ?
We have never demanded that, Milord, whatever they are saying. Secondly, I have two lands. I have one land.
Two legs.
Two lands.
Lands.
Sites I have, which my father-in-law transferred in my husband's name. And during 2016, 14 acre once he transferred in my name. Secondly, 4 acres in my younger son's name. He is also major now. Their main contention is hit by section 27 because as per section 27 of the DB Act, I can file the case here. Your Lordship may kindly see the documents I have produced along with my objections, please. I was, so as per section 27.
I will hear it on Wednesday.
My lords.
14th.
14th.
Same stage.
17, my lords.
No.
Please, my lords.
Come on, come on
Direction
14th.
matter, my lords.
Come on 14th. We'll grant time on that day. Yes.
Grateful.
45.
Nisha madam, the moment I finish this interlocutory, I'll take it. Yes. Intermodal will get extended. Thank you. Yes.
Your Lordship, state has sought for extension of time, Your Lordship.
Status sort.
ಅದಲ್ಲ.
Why?
D.
Oh, Lamborghini. Department inquiry ಮಾಡಿಲ್ವಾ?
3 months extension ಕೇಳಿ.
What steps have you taken?
Enquiry officer is appointed, Your Lordship.
Charge sheet is issued?
No.
Charge sheet is issued, inquiry officer appointed. What's the next date of inquiry?
July 1st week.
Then date ilva. Inquiry officer yavat notice ಕೊಟ್ಟಿದ್ದಾರೆ ಬರಕ್ಕೆ ಕೇಳಿ.
Please, Your Lordship. My colleague was handling the matter, Your Lordship.
ಕೊಲ್ಲಿಗ್ ಅಂದ್ರ?
ತೇಜೇಶ್ ಅವರು.
ವೈದ ಇಲ್ಲೇ ಇದ್ದಾರೆ?
ಅಲ್ಲ, ತೇಜೇಶ್ ಅವರು.
ಅದಕ್ಕೋಸ್ಕರ ಬಂದಿದ್ದ?
He had that file, Your Lordship.
ಕೇಳಿ ಯಾವತ್ತು ಅಂತ. ಎಸ್. ನೆನ್ನೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ ಯಾವತ್ತು ಡೇಟ್ ಕೇಳಿ ತೇಜಸ್ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. Yes.
46.
See, this honorable court passed an order.
ಏನು?
To take steps to
Relaxation.
withdraw the case.
ಏನ್ relaxation?
SOP, my lordship, the below 10 years, my lordship is.
ಓ ಅದರ ಪ್ರಕಾರ.
Yes, my lordship.
ಎಲ್ಲಿ ಶಾಂತಿ ಭೂಷಣ್ ಅವರೆಲ್ಲಿ?
Yes. My lordship already 5 to 6 orders, my lordship passed.
All right, get ಶಾಂತಿ ಭೂಷಣ್.
Inform my lordship, maybe.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗಲ್ಲ. ನಾಳೆ ತಗೊಂತೀನಿ ಕರ್ಕೊಂಬನ್ನಿ.
Public.
Yes.
47.
Vacating stay.
On behalf of respondent number 2, council members.
Who has filed vacating stay?
Respondent number 2.
ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳಿದ್ ನೀವೇನ? ಬೆಳಗ್ಗೆ ಕೇಳಿದಕ್ಕೆ ಸಾಯಂಕಾಲ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಪರವಾಗಿಲ್ಲ. ಯಾವತ್ತು ಬೇಕು?
Any date in the
14th.
Please.
Same stage. IO extends. Yes.
48.
RP. ಏನ್ RP? ಮನ್ನಾಪುರಮ್ಮ ಮುತ್ತೂಟ. ಮನ್ನಾಪುರಂ. Yes.
I prefer a date in this matter because the matter can be heard.
14th. Yes. 14th. Next.
59.
Sheshgiri Rao. Sunil.
If my lordship remember that RP minutes, that limitation and
ಗೊತ್ತು.
execution.
ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿಲ್ವಾ ನಾನು?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಡೇಟ್ಸ್ ಏನೋ ಕೊಡ್ತೀನಿ. ಏನು ಡಿಸ್ಪೋಸ್? ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಲೌಡ್ ಆಕ್ಚುಲಿ. ಅಲೋ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪ್ರಕಾರ ಕವರ್ ಆಗಲ್ಲ ಇದು. ದಟ್ಸ್ ವಾಟ್ ಐ ಹ್ಯಾವ್ ರೆಂಡರ್ಡ್ ರೈಟ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪ್ರಕಾರ ಕವರ್ ಆಗುತ್ತೆ.
ಕವರ್ ಆಗುತ್ತೆ ಅಂತ.
ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಆಗಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು. ಆಗಲ್ಲ ಅಂತ ನಾನು ಒಪ್ಕೊಂತ ಇದ್ದೀನಿ ಅಷ್ಟೇ. ಎಸ್. ವಿಲ್ ರೆಸ್ಟೋರ್ ದಿ ಮ್ಯಾಟರ್ ಟು ದಿ ಫೈಲ್. ಬಟ್ ನಾಳೆ ಮಾಡ್ತೀನಿ ಸುನಿಲ್. We'll post it tomorrow.
Very good.
Yes.
Let it come.
lordship, this is a matter and under insecticides and fertilizers, sir.
Huh?
Short accommodation. 51.
Insecticides Act.
Oh, fertilizers, sir.
Huh?
Insecticides Act ಅಲ್ಲಿ.
Right. 14th. Yes. Next. 52.
Lords, appearing on behalf of the second respondent complainant, Lords.
Ah. Yes, sir.
Fought for vacating of the interim order.
Yes.
Lordship, the issue is this.
Hmm.
Offence under 316(4) and 318(4).
Hmm.
I am the
ಜೋರಾಗಿ ಹೇಳಿ, ಯಾಕೆ?
33% shareholder in the company. Lordship, I am the 33% shareholder in the company. 67% is held by the complainant in a representative capacity of Saving Systems India Private Limited. The allegations, my lords, is that there are some related party transactions which have routed the goods through my entities, where I, the petitioner, is one of the partner in one of the firms and my wife is one of the partner in another firm. The allegation seems to be that there is an interim report which has been given by a chartered accountant. Based on the interim report, there have been some findings where there have transactions where there have been purchased by such firms at a lesser price, and thereon there has been a sale at a higher price, lower price and higher price. So the allegation is that I have usurped some of the money and also misused my office. That's my only submission in this regard. Is I am the 33% owner of the company. 316, I'm only on that point. My lords are aware of the Companies Act and the aspect of section 206, 210 and all. Now, this is a per se operation mismanagement matter. The only thing what they wanted is they wanted to take me out of the company because now they have initiated action for removal of director as to me, and they wanted to go before NCLT. This is a hoodwinking petition complaint which they filed before the police. They go before the police. Instantly, they get the complaint registered. Next day, they come to my home, they harass, and then they go to the office and they take my laptop, they block my emails, they block the GST, and they block my accounts. Therefore, my lords, this is only a strategy to use criminal force in order to avoid the Companies Act procedures. My lords, my only submission is they are telling they have invoked section 316(4) and 318(4). My lords, 316(4), my lords, I'm not a servant. I'm not an employee, my lords. I'm a co-owner of the company. How can I cheat myself? How can I cheat? My lords, they told there is a, the 316(4) has been invoked, where my lords, I am the 33% owner of the company, my lords. Absolutely, the allegations are frivolous. My lords, contrary to that, my lords, I go with a complaint to the police, and my lords, when I go with the complaint, I get a notice saying that your complaint is not entertainable. And my lords, what they do, after giving the complaint, lordship, after filing the FIR, they go to the media, they publish my name and the photo and say that don't, this person is with criminal antecedents, etc., etc. Don't deal with this person. This is all done in order to take back the shares of 33%. Whatever I have is the main allegation, my lords. My lords, other things, my lords, of 206, 210, my lords, I don't have to. It becomes so rudimentary for this court to be here. My only submission is, my lords, if their complaint is entertained, as well my complaint has to be entertained. If my complaint has to be quashed, if their complaint has to be quashed, then my complaint also has to be quashed.
I will hear this in the council. Yes, sir.
Lords, page 27, para 7 of the complaint. Lords, what this person does, he is holding 33%, and therefore he will be entitled to 33%. So probably he was not satisfied with his 33%. He does two things. He sets up a firm along with his wife called as Eon Tex Industries. He sets another firm called as Sri Sai Sharda Textiles, where his wife is the partner. Now what he does, because he was in charge, he was the executive of the company. What he does is, he starts procuring raw materials from these two entities by over invoicing. If it is 10 rupees, 15 rupees, invoicing is done. Money is siphoned off into his firms, where he is going to get the money. That's why I said that he is not happy with this 33%. Next, what he does, he invoices our company relating, what we are doing is we are the manufacturers of the apparel accessories. Whatever gets into a coat, we do everything, including the pads and all, which is the major sale. Now what he does is, he purchases the goods from us in the name of these two firms and sells to our own customers. These are all the customers who are our customers, Aditya Birla. Now he discontinues with this supply. He supplies this Aditya Birla the goods which we have, which has been invoiced by us. So now there is one whistleblower who said that these are all the things which are happening. You are not looking. We appointed, will not say forensic audit. We then got to know that other than these two things, what he has done is two more things. One, the stocks which is reflected as having been there in our stocks is actually not there, but records are there to show that there are delivery notes which are sent where these stocks are lying with them. This is number one. Secondly, the employees of his firms are being paid through the accounts of the company. These are the four allegations. Now what happens after this is done? What my learned friend said, the police registers the complaint. They will have to proceed to the place for the purpose of drawing up of the matter. Then he is tipped off. Somebody tips off saying that no, this police complaint is registered. Then what he does? He grabs all the files, the computers. There are CCTV footages to this effect. Then he goes out. By the time the police comes, he is already not there in the scene of the place where the merger is to be conducted. Not after this is done, because we were part of this, we were called for signing the mergers, etc. Now they have actually recorded the statements, and whatever statements now I am making, milords, these materials are seized from the premises where the search and seizure has been conducted. Substantial investigation has already been conducted. Milords, offences are there on the face of it. He has misappropriated, he has misused his position and then cheated the company. Whatever representations he held out saying that these are all the entities with which he is dealing are not his entities, milords, ultimately turns out to be false, and he is unjustly enriching himself. That's essentially the end of the complaint. So therefore, milords, I am respectfully submitting that this is a matter which requires investigation. If he wants to keep,
In the least.
please, that's the least, milords, to the least.
I second his opinion. If my complaint is also taken and a joint investigation.
What is your complaint?
Same complaint. How I have set up my entities on
ಅವರು ಸೆಟಪ್ ಮಾಡಿದಾರಾ?
ಅವರು ಮಾಡಿದ್ದಾರೆ.
In his wife's name.
His name. I have got a signed CA report there. I got a better report than them.
Better report.
That is what, because
That's a better company.
No, because theirs is only a draft report. Mine is a signed report. They can challenge it. No, milords, my only submission is this, milords. These are all matters, milords, has to be decided in operation mismanagement, not to initiate a criminal action.
Operation
Not a criminal action. Then I'll have to go, milords, 360.
ಇಲ್ಲ ಇದು ಆಪರೇಷನ್ ಮಿಸ್ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಆಗಲ್ಲ, ಇದು ಸಪ್ರೆಷನ್ ಆಗಿದೆ.
Yes. My only submission is.
ಆ ಕಂಪ್ಲೇಂಟ್ ಯಾವ್ದು ನಿಮ್ದು? ಅದು ಮಾಡ್ಲಿ ಬಿಡಿ.
I have absolutely no difficulty, milords. Let them investigate into the complaint. What I am submitting is,
I'll show that.
ಆಯ್ತು, ಅದನ್ನು ಡೈರೆಕ್ಟ್ ಮಾಡಿ.
what they have done. If there is a complaint, milords, which was not accepted by them, he had his remedies insofar as that complaint is concerned, which he does not take recourse to.
It's all right.
The reason why I am submitting
if there
this
is a complaint, let them investigate.
Let them, if it is a complaint worthy of being investigated,
Correct. If
let
your
it be
complaint is
investigated.
worthy of being investigated into, let it be.
Very
Let
well.
them
I have no
invest-
difficulty.
How can you
Last
fight shy of
occasion
we will permit investigation in both the complaint.
Very well. I have no
Which
difficulty.
is that complaint? Learned HCGP heard the learned counsel Madhu and Rao appearing for the petitioner and the learned senior counsel Dr. Ravishankar representing the respondent. The issue is complaint versus a complaint.
No, because I just want to say this. After every incident takes place, after the stay is granted, then he goes and gives a complaint.
Oh, what is the date of the complaint, sir?
That's what your lordships
The
will
date of the complaint is post the FIR.
Post FIR, post
No
stay.
problem. Leave it.
Cannot
Yes.
seek for that.
In spite of
Post
that,
stay.
ಅದನ್ನ ನೀವು ಕೊಟ್ಟ ಮೇಲೆ ಅವ್ರು ಮಾಡಿದ್ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿ ನಾನೇ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
Allala, hagalla. I go to the police station. They won't take my complaint. I send an email.
When did you go?
No. The moment the FIR gets registered. at that
Against
point-
you?
Yes. That point of time, they don't even take my complaint. They say I won't take it.
If
Then
you
there
had
afterwards-
gone in an earlier point in time,
They, within no time, the FIR.
ಆಯ್ತು, FIR ರಿಜಿಸ್ಟರ್ ಆದ್ಮೇಲೆ ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಹೋದ್ರಿ?
I went
After
within
the
no
stay.
time.
ಸ್ಟೇ ಆದ್ಮೇಲ?
After the stay.
Milords,
Date, sir.
Milords, I sent an email because they did 16/4.
9-4 is the stay.
That's okay.
That's
Nim
not-
complaint
Not
ಯಾವ್ದು?
of any relevance.
Pardon me, lords.
Yeah, complaint ನಿಮ್ದು?
Lords, our complaint is on 22/3/2026.
Because they take, because obvious reasons. My complaint is not
Lords,
taken.
after the stay is obtained on 9-4, they
complaint
go
is not
before the
taken.
police and say they want
My
a complaint to be
laptop is,
registered.
my laptop is taken,
Oh,
my
nothing is
GST
taken.
credentials are seized, my accounts are seized, everything.
And
is
I thought simultaneously both of you gave given against each other.
The moment I was
Yes.
called, my lords, they were also
Will
the
decide.
same place of.
Wednesday will dictate.
Lords, grateful.
My only
ಅಷ್ಟೇ
sub-
ಇದ್ರಲ್ಲಿ.
My only submission, my lords, is, because they have invoked section 316(4) and 318(4). Let's kindly have a look at 316(4).
See, whatever they have invoked now, it is only an FIR. How is it that the charge sheet will be filed, if at all, is to be filed on those offences only?
My submission is, my lords, fair enough. Let there be an investigation. Let my complaint also be taken, my lords. How is it of any relevance, even if I come after this day?
No,
Complaint is
that's all
correct.
right. See, that is a counter blast to what the complaint is
Offenses are
registered.
right. My lords, there is an offense.
Well, see,
for
but why you
regress
did not take the complaint?
They did not take. Lords,
Anyway, then you will permit investigation in this.
No, my lords, in such a case, my complaint also should be taken, my
I
lords.
will
But
direct.
so, Lords, now that is the reason why I said.
No, because this court,
If he had,
this court on last
I
date of occasion,
really,
this court
Lords,
on
if
last
he
date
had
of
any
occasion,
grievance that there is any forgery, anything of the kind.
it is there.
Lords, now we wanted to say that we gave a complaint against him. I pointed out these are all the things. Offences are disclosed in the complaint. The FIR is registered. They take this matter for investigation. After an investigation is completed, he approaches this honorable court and this honorable court has stayed the matter. After almost about a week's time, then he goes to the police station and say,
it is
now
only
I want
after
to
the
give a
direction
police
given by
complaint.
this court.
Lords, it's
It-
an
it is-
afterthought.
No, you
It's a
could.
statement to be given before the police to get himself off the hook.
1 minute. You could have.
That's the statement. he
You
has
could
to-
have registered a private complaint as well.
Yes.
Look, this court was seized of the matter. At that
So
point of
private
time,
complaint ಹಾಕ್ಬಾರ್ದು
that point
ಅಂತಿದ್ಯಾ?
of time, my lord, that point of time, I brought this issue before this honorable court. This honorable court told the SPP, let this complaint be registered, my lords. Because that was not registered even after that.
We'll see. Wednesday will dictate.
Please, my lords, great.
But ಆದ್ರೂ complaint in investigation, you should not fight shy.
Lords, now I'm not shying away from it, but the kind of thought process for behind this complaint, after obtaining the stay from this honorable court, going and giving a complaint, my lords, is definitely a mischievous effort on their part. That's the statement which he has to give before the police in my investigation to see whether he can get it on.
The thought process of after the
Wednesday.
Wednesday.
last month, the thought process of giving advertisement saying that you are a criminal after the getting of registered. as a- that-
Adjournment ಆದ್ಮೇಲೆ argument ಯಾಕೆ?
Great.
ಅಲ್ಲ ವಿಡ್ರಾವಲ್ ತಗೊಂಡ್ಬೋಣ. 3-4 ವಿಡ್ರಾವಲ್ ಇದೆ. ಆರ್ಡರ್ಸ್ ಎಷ್ಟು ಜಾಸ್ತಿ ಏನಿಲ್ಲ ಅಲ್ಲ. Withdrawal in terms of memo, 54 in terms of memo. Dilli Rajan is retiring, no? Huh?
ಅದರಲ್ಲಿ all the events are pre-BNS.
Pre-BNS.
BNS.
Huh.
And the offense charged is in BNS.
Where is my judgment? Pudi.
Yes, covered.
It has to go back to redraw the offences.
Yes. But 69 was not in existence then.
69 ಇದೆ ಇದರಲ್ಲಿ. ಅದು ತೊಂದರೆ ಇಲ್ಲ. 69 10 ವರ್ಷದಿಂದ ಇದು ಹಾಕ್ತಾ ಇದ್ದಾರೆ. That's not the issue. Now
Ex post facto law ಆಗ್ಬಿಡುತ್ತೆ.
that will see 69, 89, 351 stay ಕೊಟ್ಟಿದೀವಲ್ಲ. What's the matter?
ಅದೇ all the offences.
That's okay. That argument, leave it. Next argument.
Consensual. ಎಲ್ಲ. It's the thing. But they, from 2022, the complaint says that they met at Bangalore, went to Chennai, Maldives, Mahabalipuram, Goa, Andaman, Pune, Sri Lanka.
Oh, India and beyond.
India and beyond. She accepts that they had gone around all these places. And then
But why have you signed everywhere as her husband?
ಬಂದು ಸೈನ್ ಮಾಡು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Why have you signed as her husband every place that you have gone?
ಅದೇ
ಇಲ್ಲ ಜಾಗ ಕೊಡಲ್ಲ ಅಂತ.
The last such offense she says is 17/3/24.
ಎಲ್ಲಿ?
BNS is June 24.
ಅದು ಪರವಾಗಿಲ್ಲ. ಇದು ಮಾಲ್ಡೀವ್ಸಾ?
ಇಲ್ಲ, Mahabalipuram.
Mahabalipuram. So from Maldives to Mahabalipuram. All right. Anyway, respondent is not the vacating stay ಹಾಕಿರೋದು ಯಾರು? Stay 69 ಗೆ ನಿಮ್ಗೆ ಏನ್ ಮೇಡಮ್?
Pending matters, instructions.
ನೀವ್ ಯಾರಿಗೆ? ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಅವ್ರಿದ್ರೆ ಕ್ವಾಶ್ ಕಂಪ್ಲೇಂಟ್ ಸರ್ವ್ಡ್ ಇಲ್ಲ ಸಂಬಡಿ ಇಸ್ ದೇರ್?
Complaint is served.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋನ?
ಹೌದಾ?
ಓ ಬೇರೆ ಯಾರು ಬಂದಿಲ್ವಲ್ಲ?
ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಹಾಕಿದ್ರು next week.
ಮುಗಿಸ್ಬೇಡ. ಅವ್ರದಂತೂ ಡೆಫಿನೆಟ್, ಬಟ್ ನೀವು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1.
DNS ಮೇಲೆ ಹೋಗ್ಬೇಕು.
ಆ ತರದ್ದು ಹೋಗೋದೇ ಇಲ್ಲ. ಎಸ್ ವಿಲ್ ಸಿ. ಎಷ್ಟು ವರ್ಷ?
ಅದು 22 to 24 ಕನ್ಸೆನ್ಷನ್.
ಅದ್ರ ಮೇಲೆ ಹೋಗುತ್ತೆ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಲೆಟ್ ಅಸ್ ನಾಟ್ ಸೆಂಡ್ ಇಟ್ ಬ್ಯಾಕ್ ಫಾರ್ ಸಮಥಿಂಗ್ ಎಲ್ಸ್. ಅವ್ರು ಬರ್ಲಿ, ಇವ್ರದ್ದು ಕ್ವಾಶ್ ಮಾಡಿ ಈಗಲ್ಲ. ಬಟ್
Last 2 dates they have not come, Lord. Last 2 dates they have not come.
ಸ್ಟೂಡೆಂಟ್ಸ್
Last 2 dates.
ಲಾಸ್ಟ್ 2 ಡೇಟ್ಸ್.
Next time ಹಾಕಿ.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner in one of the cases, and Sunil S. Rao appearing for the petitioners in the companion petition. There is no representation on behalf of the complainant. In fact, there has been no representation for the complainant throughout in these proceedings. In that light, as a last chance, list this matter on 14th. In the event the complainant would not be present, orders would be passed on hearing the learned senior counsel and the counsel for the petitioner. Interim order subsisting would continue till the next date of hearings. Yes.
Fresh matters.
Bad, worth. A post in under the caption interlocutory applications. Yes.
Obliged.
56.
Appear for the respondent number 2 in this case, madam.
ಇದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ
Vacating stay ಹಾಕಿದೀವಿ madam.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ನಾವು madam.
Post on 14th under the caption interlocutory applications for vacating stay.
Tuesday.
Huh?
Kindly on Tuesday.
This Tuesday?
This.
Okay. You want the stay to be vacated?
No.
And then?
Both state and the respondent have filed.
And then why are you in a hurry to get it vacated? Wait.
Madam, we can have it this Tuesday.
No. 14th, yes. Next.
Date for
57.
Memo for retirement filed by so and so. 2 weeks, yes. Withdrawal in terms of memo.
59.
I appear for the petitioner in this matter, ma'am.
59 post immediately after service of notice upon the respondent. Interim order ಇದೆಯಾ?
Interim order is there.
Continue. ಪ್ರಕಾಶ್ ಯಾರಿಗೆ ನೀವು?
Respondent.
ಯಾವ್ದ್ರಲ್ಲಿ?
16 that is.
60.
Yes, my lord.
For the
They have
appellant.
filed the vacating stay. in this
Vacating
case.
stay.
For the appellant.
This is the case wherein, my lord, they have collected the rent from the subtenants and they are the tenants under me and they have not paid the amount, my lord. The rent is due to an extent of more than 3 crores. Cheated, my lord.
When do you give it, sir?
My lord, this is
And
filed
they have-
during the pendency of an OS, which is in the city civil.
There's a
code. I'm being
direction in the OS that you should collect the rent.
My lords, I'm being led by a senior counsel. There's some difficulty.
So he will come and tell that, is it?
No, my lords.
My
the
lord, I have
direction-
placed the document, my lord, complete. At
Yes,
page
for-
number 10, my lord.
14th finally. Interim order would stand extended to the next date under the same caption.
They themselves have, subtenants said, my lord, we have paid the amount to them.
Yes.
Obliged.
If that is the case, gone 406 straight away. Yes.
61.
My lord, we have filed an IA for directions. to
End
renew the
direction, madam.
To renew the passport.
Passport renewal.
Please, my lords. A short date may be given, my lords. maybe
Sir, please.
Because I appear in
Sir,
61.
don't appear from the park.
No, I'm on the way, my lord. They're outside High Court only. I was in the.
High Court Park, other it is park. You're in Kapan Park.
That's outside the High Court, my lord. Downstairs, my
No,
lord.
no, sir. Your colleague is there. Don't worry.
Yes, my lord.
And you video off ಮಾಡ್ಕೊಂಬಿಡಿ. Yes. Yes, madam.
My lords, despite the interim order passed by this honorable court, the passport authority is not renewing the passport of the petitioners, my lord.
What is the allegation?
It's under Customs Act, 135 of Customs Act, my lord.
Where do you want to go?
Dubai, my lords. I'm a businessman. I'm doing import and export business, so I should be traveling around the world for my business purpose. So the passport authority.
I appear in 61.1. Plus the arguing counsel is.
That's okay.
Please, my lord.
Will permit issuance of a short validity passport.
My lord,
ಅದು
I'll have
ಮಾಡುವ.
to-
Get,
I'll have instructions.
You do one thing. Get the DSGI tomorrow. Will direct issuance of a short validity passport for the purpose of travel. All right? Tomorrow. Yes.
62.
Lordship, I am appearing for the petitioner. So this writ is on a question of a law.
Question of law.
Question of a law in
Every writ is that only, sir.
question of a law in section 340 CRPC.
Ah.
Whether the respondent being the would-be accused, they are seeking the.
What?
They are the would-be accused in the trial court.
Would be accused.
Would be.
Oh, there is something called would be accused also, is it? Oh.
So they are a proposed.
How do you know?
accused.
Definitely they are going to be accused.
They are a proposed accused because they committed a fraud before the court. So under the section 340. So it's a well settled principle of a law in state of Punjab versus Jasbir Singh in a 2022 SEC online 1240. Where the
You're
question has
competing
been,
with me. Yes.
Your Lordship, question has been asked and clarification is given in the para number 9 stating that there is no doubt the proposed accused can get a hearing. That is in aligned with British versus state of Maharashtra.
Citation?
British versus state of Maharashtra. 2022 judgment. On SEC 253 in a volume 1.
Yes.
In aligned with constitutional bench order in Iqbal Singh Marwa and Meenakshi Marwa, where it clearly stated that the proposed accused cannot get a hearing because they have a remedy in before the magistrate when the complaint has been made.
Now, what is that you have challenged?
I have challenged because they are seeking for the audience before the trial court, and it's
Audience is granted now, is it?
granted by the learned judge 7 times.
7 times.
7 times. So I have invoked a writ of prohibition as well as a writ of
Writ of
assurance.
prohibition.
Yes, Your Lordship. And the stay order has been given.
482, sir.
226 and 227 read with 482 because as a 340 has been.
Oh, 1 ನಿಮಿಷ. Would be accused. Really?
Blood. Earlier, 340 application got dismissed by the commercial court. He came on appeal before this honorable court. This honorable court remanded the matter back to the commercial court with the direction complainant was 14% and the respondents to appear there. Initially, now appear. We appeared. Millards may take page number.
Story helped.
Initially, his counsel said, I don't have any objection for them to appear. That has been recorded in the order sheet.
In which order sheet?
In the commercial court's remanded matter.
All right.
It was then he raised the right of audience question. We were making our submissions. Court was not making. Court has not done any passed any order. Before court concludes the argument the matter, he files an application for reference. That to send the matter to High Court to decide whether in this case the respondent has to be given audience or not before even the court decides that. When that was pending, he approached this honorable court and got his own case stayed, saying that he got an interim order of stay, saying that the proceeding itself is not maintainable. He himself says that that has been recorded.
It is not about the proceeding, Your Lordship. There is a procedural flaw that has been committed by the learned judge because they have triggered it.
Now, the coordinate bench said both of you should be heard.
You
not
go
here,
appear.
only appearance, Your Lordship.
Go appear. That's what the coordinate.
Order ಏನಿದೆ?
The order is, Milord, at Milord, the party in person and respondents are directed to appear before the trial court and so and so without expecting any notice.
Without a notice. Without a notice because.
Wait.
That is the order.
Because as per the procedure, notice cannot be issued. Appearance is only to.
You don't interpret the order of the coordinate. Which court has passed that order?
Sandesh.
ಅಲ್ಲೇ ಹೋಗ್ಲಿ. Clarification ಅಲ್ಲೇ ತಗೊಳ್ಳಿ.
ಅಲ್ಲದೆ.
You go and appear ಅಂತಂದ್ರೆ it has to, not for going and standing there to be heard. Yes.
And there is
if that order has become final.
Yes, my lord.
That order has become final. Anything else, sir? Would be has to be heard. Anything else? ಅದನ್ನ challenge ಮಾಡಿದ್ದೀರಾ? You have challenged that, is it? Now that proceeding that took place after the order of the coordinate bench.
Coordinate bench has asked to appear. And
no, you are acting against your own case.
Because they are coming and facts and
So
averments,
what if they are heard?
that is not a problem, but
Then-
facts and averments, your lordship can see.
They will project whatever facts and governments they want to project.
May I
How
make a
can you
submission,
come in the way?
Your lordship has to see the page number 63 of my rate.
Post it on Wednesday.
Lord, may I make one submission, Lord, in this? Lord, my lords may remember I made a submission saying that we got a notice. Both the councils have got a notice from the party in person that are saying that he is intimidating us from appearing for the party's hearing.
Idralena.
Idralene.
And
We have filed
after-
our counter affidavit.
After we issue a reply to his notice, he comes before this honorable court and also files an affidavit saying that we should not be appearing. He is going to take action against us. in the
No, your
parliament.
lordship.
Intention is to
Your
curtail
lordship,
them.
they are
I'll tell you.
Your lordship.
No problem.
filed
I will see.
Lordship,
I will see what is the reality. But if you have indulged in all this,
If I
you
have
will
done
not get audience before this court.
Yes, your lordship. There is a wakalat, without filing a wakalat, there are 7 cases they have appeared and
We'll
it
see.
prejudiced to me.
List on Wednesday at 2:30 PM. Come at 2:30 on Wednesday.
Yes, your lordship.
Grateful.
63.
My lord, matter can be had on second, my lord. Some inconvenience for me, personal inconvenience. on
Second.
Second.
2:30 minutes.
Second 2:30.
Please.
Interim order will continue. Yes.
63.
Vacating stay again. Second.
Lordships, we have,
ಆಯ್ತಾ.
Lordship, the petitioner.
Vacating stay ಯಾರು ಹಾಕಿರೋದು?
Millards, I filed for vacating.
What's the offense?
Millards, the offense is with respect to the petition that in which it is granted.
14th,
Your Lordship.
same stage.
Millards,
There's another matter which has been filed by us, your lordship.
Tag along with so and so. Yes, next.
it's already
Same parties,
connected, Millards.
same parties.
Yes,
Same
your
parties,
lordship.
it's already
Same parties,
connected.
your lordship. No, your lordship, there's another matter, 17471,
Birth
2026.
birth kodi. Fast, yes.
Millards, my lords had not.
14th. Interim order will continue. Yes, next.
64.
Copy has been served on the advocate appearing in the trial court. And with regard to office objection, may I make one submission?
Overruled. Next.
This interim order.
Interim order will continue. 65.
55.
Yes, Sunil.
Application of the section 4 of the probation of.
First immediately after service of notice upon the second respondent.
66.
Interim order
There
ಇದೆಯಾ?
not be any precipitative measure.
ಯಾಕೆ? ಅದು ಕೊಟ್ಟಿದ್ದೀನಾ?
ಇಲ್ಲ ಇಲ್ಲ. 3 months imprisonment ಆಗಿತ್ತು.
ಹಾ.
4 months. So it was a offense relating back to 90s. Now he's around 58, 59 years. I want to seek probation if it is
List
permitted.
on Tuesday in the fresh matters list. Yes. Golf club.
66.
The petitioner in this case, my lordship.
Post immediately after service of notice upon the respondent. Interim
Interim
order will
order has to be extended.
continue. Has to be. It won't be, sir. Yes.
So we continue it, my lord.
Yes. Interim order extended. Next. Yes, Nisha Tiwari, madam.
Vacating order.
I'll get back to admission. Wait. Yes.
Milord 26.
In
Milord, one
5 or 10 minutes finish. Yes.
3 to 4 minutes.
Yes.
Milord, first clarification that I am not hiding behind any technicality or hyper technicality
Who
of
told that?
absence. Milord, for the reason that
All
every
right.
single time I approach the dais in this matter, equities operate against me because there is an order against me.
That's the whole problem.
That's
Yes.
my lord,
Hmm.
I have realized that.
And I also realize that ಇವ್ರಿಗೆ ಏನು ಗೊತ್ತಿಲ್ದೇನೆ ಕನ್ವಿಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
I will be in a position to convince your
Hmm.
lordship.
All right,
I
Kannada I
just
should
had
not
10 minutes
speak.
to probably your lordship.
Now finish. Yes,
Milord,
start, madam.
first clarification is that I am not hiding behind this hyper technicality of absence of a particular word of conviction.
Hmm.
My submission in substance before the recall court as well as before the magistrate court as well as before this court is that there is no finding of guilt against me and therefore there is no conviction recorded against me. It is not just the absence of a particular use of word convict. Because there is no finding of guilt, there is no satisfaction recorded with the essential ingredients of 141. That is the reason the court has cautiously not used the word convict against me. And it has cautiously used the word convict against the company only. This is one submission, my lord. Secondly, my lord, the contention that there can be a deemed conviction. My lord, I have not come across any such decision wherein there can be a deemed conviction. It's a judicial act which
That's
cannot be
the-
drawn
yes. Hmm.
as which cannot be drawn by way of inference. It's a judicial act and it involves the section 141 uses phrase deemed guilt, not the deemed conviction. And if we were to equate this deemed guilt to deemed conviction, my lord, then the entire journey of trial is vitiated. Then there is no necessity for prosecuting these accused separately. Going by the logic of section 34 of the IPC, my lord, that also talks about joint liability and all that. Every single accused is prosecuted, sentenced, tried, and then punished separately, my lord. Same logic applies here, and everywhere wherever the offenses against the company is defined, only those persons who are found to be in charge of and irresponsible for the affairs of the company at the relevant point in time, that is at the time of commission of the offense, are held guilty, convicted, and then only they are sentenced, my lord. In this case, admittedly, from the order itself, it is clear that there is no finding of guilt against me. There is no recording of conviction against me. There is no reversal of acquittal order against me. The conviction has been recorded only with the company, and I have been sentenced categorically for the offense committed by the company. The liability is admittedly of the company, and this cannot be stretched by way of imagination that this meets without specific government, without specific finding, with the satisfaction of section 141 elements, my lord. The doctrine of alter ego, that my guilt will amount to findings with the company's guilt, that applies, my lord. There is no dispute about it. Sunil Bharti Mittal judgment in
Yes.
2015, my lord, has held the doctrine of alter ego applies. If I would have been the convict, then the guilt of the company could have been presumed. But even then, there has to be, in my respectful submission, specific requirement of recording a conviction against the company as well. Having said so, my lord, it is categorically dealt with in that judgment that the doctrine of alter ego does not apply vice versa. So the conviction of the company cannot be read against me to say that I am also a convict. And my lord, my difficulty, why I came to this court, my lord, my specific contention that I have resigned from the company was not taken into account because my communication to ROC was doubted for want of a seal. I just wanted to get from this honorable court as to what happened to my communication. That alternative prayer, my lord, unfortunately was not considered by this court, not even discussed, not even mentioned, my lord.
Which
That,
by, in my order,
My
that
lord.
was not projected at all.
my lord, that was part of the writ petition, my lord. There is,
In 2023.
please, my lord, that I must fairly submit that could be a lapse on the part of my lawyer, my lord.
Hmm.
That could be a lapse.
Hmm.
But however, my intentions are very bona fide, my lord. I just wanted to know as to what the ROC did with my communication, because there was a seal. And my lord, I was fortunate, God was graceful to me that in 2026, I got a communication dating back to 2009 from the ROC on the same complaint, wherein he...
Where is that?
My lord, that is part of my correction
Now,
application.
now.
Now, my
All
lord,
right. Hmm.
to show my bona fides that this is the document which I was seeking from this honorable court's indulgence. And that document I got from another director who was at that point in time executive director of the company, my lord. He gave me this document which dates back to 2009, which says that on my communication about resignation with the board resolution, wherein my resignation has been accepted by the board, the ROC has initiated prosecution against the company for non-filing Form 32, which was agreed upon in the board resolution that will be submitted by the company, presided over in a meeting wherein the complainant himself has presided as a director. Well, here my main defense was that the company was taken over in discharge of the liability. The court came to a conclusion on the basis of a document which I claim to be a forged document, that the company takeover was reversed. My lord, even if the company takeover is reversed, it is not proved that I was responsible for the affairs of the company
Anyway,
when the
this
check was present.
the words conviction will remove,
My
and whatever is to be done, will do it. Yes, sir.
I just require 10 minutes of my lords. Just 10 minutes.
Yes.
Madam,
Copy.
good.
Hmm.
Madam, altogether, there are 14 litigations between us.
Hmm.
Dates I have given, madam.
Hmm.
The last one is one filed after your lordship passed an order 2 days back. That's on 22nd. Very notice has not yet come. So in the rest of the 13 minutes, except the first one, in all the other 12, I have succeeded both before this honorable court as well as before the honorable Supreme Court twice. Again and again, the same thing is being said, Millard. Now, I'm just passing on the judgments, Millard, on the point, Millard.
On the point.
That filing this repeated application amounts to criminal contempt. Just, my lord could kindly see the, and not all the, I had prepared for some other matter, Millard.
Allah, copy.
Last time.
You got the copy, madam?
And just give it again also.
Filing repeated applications.
File, that yellow color ಹಾಕಿದಾನೆ sir. Side ನಲ್ಲಿ plastic ಇದೆ. Rashid Khan's case. Repeated applications amount to cannot be filed to overcome the procedure. Then in I have marked it also for your motions. Then other thing is sorry, IS cannot be filed to overcome the procedure. Rashid Khan. Then came Modi Miller, that is a green color flag hakidane. That is repeated pleadings amounts to criminal contempt.
You want it, madam?
But I'm fine.
ಕೊಟ್ಟಿದ್ದಾನೆ last.
You have it.
Please. But I remember his submissions, the locus. That's the question.
Yes.
No, some of them are her own judgments. She had given me. I had
All right.
Then the last one, there's a blue color one, Sunil Batra's case. That is the scope of 141. My Lord could kindly permit me to read that news. The last one. This also again my Lord friend. She had given me news.
Sunil Bharti Mittal.
Yes.
That's
Page-
what she made a submission.
Yes, page
Madam made a
27
submission
onwards,
now
madam.
saying alter ego is applicable as said there.
So here again, I am when the company is involved, it is a legal person. Any person who runs the management, he is the person against whom an order is deemed to have
So
passed.
you accept the fact that there is no independent order of conviction against this petitioner. Your submission is it is deemed conviction.
The learned judge himself has said, not
Correct.
me. Yes, ma'am.
That's all right. That
Yes.
that is pending in recall. That's a different thing.
No, no. Of course. That order has become final. That's what Miller.
That's SLP is dismissed, sir.
No, Miller, not that. That's what Miller has said. She filed an application.
Milord, probably my lord.
Let him finish.
No, but-
Miller, first, she filed an application in the.
Who?
I filed an appeal, Miller, that has been allowed on 4/2/2015.
No, who she?
No, I just.
Petitioner is a lady.
No, no,
Then?
my land friend himself.
My lord, he filed it.
Yes.
I filed an appeal, Miller, in 2009. The second, still number 2, Miller. That has been allowed, Miller, and order of acquittal is set aside. Order of conviction is passed. Then, Miller, that is against the company, I agreements. Then, Miller, they filed an application, Miller, for suspension of the order. That has been allowed on 14/10/2022, 4 years back, with a condition that they must deposit 10 lakhs. Even to this day, they have not complied with this order. Still, Miller, this honorable court has been entertaining their applications. Then, Miller, they filed an application. They went to Honorable Supreme Court. That is rejected. They filed a review petition there. That is rejected. Then they came before this honorable court, filed IA 1/23. There, the honorable Judge Miller, who had passed the order of conviction, he said, in the light of section 141, that is deemed to have been passed. So whatever order that is passed is in consonance with 141. That has not been challenged. That has become final. No recall application. Of course, tomorrow they will file again. That I am aware of that. The moment we make some submission here, next day we get an application. Miller, I had these dates, that's why I have given. Then Miller, they filed a writ petition before your lordship, that is rejected. Then they filed a review petition before the Honorable Supreme Court, that is rejected. Then they filed a fresh writ petition before this Honorable Court, that is rejected. Then filed a CRRP. My lord was pleased to hold it is not maintainable. Then Miller, they filed IA for suspension of the order in writ appeal, it's a criminal appeal, that is not yet disposed of. Office objections are
But
not
this
yet-
factor of resignation is not taken in note anywhere.
Which?
Resignation from the company,
I-
even before the check was issued.
No, it has been rejected. That contention is taken and rejected. By this
All right.
honorable court.
Okay, yes.
And then Miller, they filed an IA for all these IAs. Office objection is not yet removed in all the office IAs, but still orders are being passed,
ಈಗ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ ಹೇಳ
including the advocate signature is doubted. Your lordship may see the cost title. ಈಗ ಏನಾಗುತ್ತೆ ನಾವು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರ್ತಾ ಇಲ್ಲ ಹಾಗಾಗಿ ನಾವು ನೋಡಕ್ ಹೋಗೋದಿಲ್ಲ.
Your lordship would recollect, Mr. Gautam had made a submission that his name may be deleted. It
Deleted,
is his
correct.
signature which is not matching on my
Now
NOC.
you have signed the wakalat.
I have signed my wakalat. It is on NOC, my lord. The NOC signature do not tally with the previous record. That
And
counsel
then
himself has made submission.
They made a submission before the honorable judge that they never made an appearance. The learned judge has specifically rejected holding that they did appear. Now, this amounts to criminal contempt, Miller. How they can make such submission? Miller, all these are supported with decisions. Of course, it is in the book, Miller. Today I am not citing all those things for want of time. But the fact
Well,
remains.
well, now this is only for correction of my order.
Your
Whether
Lordship,
it should be corrected
Miller,
or
whether
not, we'll
that
do it.
application after application, that also my lord could kindly give a finding on that.
Yes,
Again and again
Nisha
filing
madam.
applications.
My lord, two things. My bona fides as a litigant is being questioned because I am filing multiple applications, my lord. I respectfully submit that, my lord, the recall application wherein in detail I argued before the coordinate bench, my lord. After hearing me at length, my lord, my application was not dismissed despite so many dismissals. Because, my lord, for the simple reason that there was some merit.
What has happened to that now pending?
That has not got listed yet, my lord.
No,
We'll-
that
we'll
office
move that.
objection is still there. That is
My
not,
lord, the-
it was
It is not listed still ante.
No, Miller, it was heard for several days before the honorable judge, Justice Basavaraju Miller, Honorable Justice Basavaraju. He passed an order that this matter cannot be finished because they are taking time, and again 3 days it was argued. He has said so in the order, Miller.
My lord, no.
Then he said, since I am
My-
going to Dharwad,
No,
I
the
cannot pass.
You
this.
appeared?
My lord, I appeared. The
And
judge
especially
at
it
the
was
end of the
listed on
hearing
Saturday.
said that I would like to release the matter and you please move it with some other judge.
Fine.
My roster
Then it
is
came
ending,
before
my
the
lord,
registrar.
It is the workload
on
on the
office
court. My
objection.
lord, court can decide either not to
You,
continue, my lord.
you have produced that ROC document
Please, my lord.
in the correction.
Please, my lord.
We'll see. Yes.
Which is at page number
I
57 of my correction application.
heard reserved will pass out.
My lord, may I request for open court dictation? my lord?
For?
Open court dictation on any day,
Oh,
my
madam,
lord.
where is the time you tell me?
On any day, my lord.
Now
Whenever
then,
is convenient
all
for
right,
your
when
lordship.
will you come next? Next week I'll put it.
Very well.
Yes.
No.
Better, I also dictate in the open.
No,
But you
it's
should
an-
not disturb.
My lord, I will not.
Yes. We'll take it on 15th. All right, 15th at 4 p.m.
4 p.m.
Yes.
Please.
Can it be before 13th? my lord?
Before 13th.
Before 13th.
All right, 10th.
Obliged.
Yes.
So great.
10th at 4 p.m.
Please.
My lord, I am also placing reliance on your lordship's judgment in Krishna Swami Sridhar.
Ade yavdu?
That
Which is that?
deals- My lord, wherein your lordship has dealt with 3056 CRPC, separate representation of the company.
Ah, yes.
My lord,
Anybody cannot be dragged into that and say you represent the company.
no, that has already been supplied to respondents and my lord's judgment. If
That's,
your
I think,
lordship
so SLP is dismissed against that, I guess.
want-
Against that order,
Please,
yes.
that holds field, man. That holds. Obliged.
Hmm. Carry ಎಲ್ಲ wait ಮಾಡಿ.
Finish.
Hmm.
Finish
Sir?
the board.
Huh?
Finish the board and then.
I'll finish the board and get up. Yes. Not yet. Yes.
Admission?
Till there, all of them will finish me.
No, let's no.
Yes.
Admission 67?
ಚೌಟ ಸರ್ ಕಾಯ್ತಾ ಇದ್ದಾರೆ ಯಾವ್ದಕ್ಕೆ ಅಂತ. ಓ ಇವರು ಇದೆ ಸಾರಿ ನೋಡ್ಲಿಲ್ಲ. ಎಸ್ ವಿಖ್ಯಾತ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ 2 weeks ಐವೋ ಬಟ್ 23 ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫಸ್ಟ್ ವೀಕ್ ಜುಲೈ ಇಂದ ಲಿಸ್ಟ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ because when all these matters get cleared.
494 and 498A, my lord. The petitioners are the
Same,
in-laws.
2 weeks ಐವೋ ಎಸ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ 2 weeks ಐವೋ ಸಾರಿ
Third time it is coming. for-
ಇನ್ನೊಂದ್ 2 ಸರಿ ಬರ್ಲಿ ಬಿಡಿ ಸೊ ವಾಟ್ ಎಸ್ 2 weeks ಐವೋ ನೆಕ್ಸ್ಟ್
Abroad ಆಗ್ತಾರೆ.
ಇವಾಗ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ ಆಗುತ್ತಾ ಮೇಡಮ್ ಬರುತ್ತೆ ಎಲ್ಲ ಜುಲೈ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ
Date on the.
Let them serve a copy.
ನಾನು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೇನೆ ಕಾಪಿನೇ ಕೊಡಿಲ್ವಾ
Connected matter ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕಾಪಿ ಕೊಡಿ ಸರ್ ಯಾಕೆ
70, 69. ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ?
70 my lord appearing for the
ಐವೋ
petitioner.
ಎಸ್ ನೆಕ್ಸ್ಟ್
Entry matter is there, my lord. 447.
ಒಂದು ಜುಲೈ ಫಸ್ಟ್ ವೀಕ್ ಅವ್ರಿಗೆ ಟೈಮ್ ಕೊಡಿ ಎಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೇನೆ
Entry model may kindly.
ಎಂಟ್ರಿ ಮಾಡಲ್ ಕಂಟಿನ್ಯೂ
My lord, any date maybe?
71 ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಇಸ್ ದಟ್ ವಿಸಿಲ್ ಬ್ಲೋಯಿಂಗ್ ಆಫೀಸರ್ ಆಲ್ ರೈಟ್ ಎಸ್ ಲೆಸ್ಟ್ ನೆಕ್ಸ್ಟ್ 2 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ ವಿಲ್ ಸಿ ಎಸ್
Much obliged.
ರಾಘವೇಂದ್ರ
Let's appear for the respondent in this matter.
ಓ ದಿಸ್
CV Nagesh sir appeared, my lord.
He's not well, my lord. They have informed me in well.
ಸಮ್ ಗ್ರೀನ್ ಸಮಥಿಂಗ್ ಏನದು
E Parisara matter, my lord. The
ಈ ಪರಿಸರ ಕರೆಕ್ಟ್ ಈ ಪರಿಸರ ಅಲ್ಲ ಅಲ್ಲ ಈಗ ಪರಿಸರ ಸರಿ ಇಲ್ಲ, ಇನ್ನೊಂದ್ ದಿನ ತಗೊಳ್ಳೋಣ.
At least, sir, we don't want to spoil the parisara.
ಎಸ್ ಆಯ್ತು. 14th
Interim orders.
ಎಲ್ಲ ಬರುತ್ತೆ ಅವತ್ತು. ಎಸ್.
Just
Interim
one
orders will
submission,
continue,
Manoj.
please don't mention.
Just one submission, 72 and 72.1, a detagging application is already, an order is passed by your lordship.
ಆಯ್ತು. 72.1 D tag, but place it in seriatim.
Much obliged.
74 ವರೆಗೂ ಅದೇನೆ.
Please.
Why, Sivanagesh sir is not well, is it?
He's not well. Yes, Manoj.
ಹೌದಾ?
They informed me well in advance.
He appeared in Kotal number 7 Millers.
ಇವತ್ತಾ?
Some emergency matter.
Yes.
Much obliged.
73, sorry, 75,
Same 2 weeks.
76 ಆಗಿದೆ.
ಆಗಿದೆ, ಅಡ್ಜನ್ ಆಗಿದೆ. ಸೇಮ್. ರಜತ್ ಎಂಟ್ರಿ ಮಾಡಿದೆಯಲ್ಲ? ಎಸ್. ಇನ್ನೊಂದ್ ದಿನ ತಗೊಂತೀನಿ.
79, entry model.
ಎಸ್, ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಇದೆ. List the matter under the caption.
Parties are ready to settle the matter.
Settled. Matter ಏನು?
Last time.
Offense ಏನು ಸರ್?
Unlawful assembly.
ಆಯ್ತು. List on 14th. Yes, next.
Next.
Settlement ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಮಾಡಕ್ಕೆ ready.
ಆಯ್ತು, ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಅವತ್ತೇ ತೊಂದರೆ ಇಲ್ಲ. 80 ರಜತ್
80 my lords.
for withdrawal.
Only 80 my lords, I am withdrawing. 80.6 my lords is the petition, and 80.8.
80 in terms of the memo withdrawn. ಇನ್ಯಾವುದು?
80.8 my lords is the fresh petition. 80 my lords was for FIR. 80.8 is charge sheet.
ಎಲ್ಲಾದ್ರಲ್ಲಿ entry order ಎಲ್ಲಾದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ, in all my lords there is.
In the light of the interim order subsisting in all the petitions, there shall be an interim order in 80.8 as well.
Obliged.
One HCGP to emergent notice.
And your lordship in 80.1 to 80.5, copy was not been served.
Huh?
Copy was not been served.
80.6 and
Copy, sir.
80.7.
Co-accused my lords.
ಯಾರ್ದಿದು? ಹನುಮಂತರ CH.
I'll inform the colleagues.
ಯಾರು ಇಲ್ಲ ಅಲ್ಲಿ. Copy serve. The petitioner shall serve requisite set of papers upon the counsel for the respondent if not already served. Yes.
80.8 Mr. Murugesh Sarati may be.
Learned 80.8 ಅಲ್ಲಿ. Counsel Murugesh Charati is directed to accept notice for the complainant second respondent.
Obliged.
80.6 and 80.7, entry mod extended.
ಅದು ಮಾತ್ರ ಮಾಡಲ್ಲ. ಎಸ್, ಎಲ್ಲದರಲ್ಲ ಆಗತ್ತೆ ಹೋಗಿ. ಆಗ ಇಂಟರ್ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ಲ. ಎಸ್, ಇಂಟರ್ ಮಾಡಿದ್ಯಾ? ನೋಟಿಸ್, ಎಸ್, ಲಿಸ್ಟ್ ಆಫ್ 2 weeks next.
82,
My lord, in this case, there were two accused.
2 weeks IO next.
Against
ಮಾಡಿದ್ಯಲ್ಲ?
ಅಲ್ಲ, against accused number 1, it has been quashed, short date. I'm in the same footing, my lord. Way back in August 25, it has been quashed against.
7th July. 7th July, yes. Fire.
Servant lordship, co-accused also quashed lordship. Lordship is given
Number.
direction.
Order ಕೊಡಿ.
Issue was that lordship, in respect of this accused person, charge sheet was not filed.
7th
Lordship.
fresh matters.
Obliged.
Yes, next.
84,
It's 84 IPF for the petitioner, my lords.
ಏನ್ ಮೇಡಮ್ ಇದು?
It's the basis of a confession.
Notice, yes, yes. And it list after 2 weeks next.
It's 84 my lords.
84 no entry ಮಾಡ್ರಿ ಸರ್, ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದು.
No, my lords. My lords are directed the state, my lords, to furnish any materials apart from confessional statements if there is anything to indicate that we have committed a crime.
84 ಅಲ್ಲ.
84 only, my lords. On 3/6/2026.
ಆಯ್ತು, 8 July next.
In the fresh matters list, my lords, because
Yes sir, fresh matter, fresh matter. Yes.
Great.
Praveen.
Petitioner, your lordship.
Praveen is not well ಅಲ್ಲ, surgery. Yes. 14th ಆಗ್ತಾನೆ. List on 14th. 86.
My lord, 86.2.
86.2,
my lord. It's a legal service committee's referred matter, my lord. My name is not mentioned.
86 stay file ಮಾಡಿದ್ವಿ.
86
86 main case. So
ಮೇನ್ ಕೇಸ್ ಅಲ್ಲಿ ನೀವು ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
vacating stay file ಮಾಡಿ.
ಇದೆಲ್ಲ ಜೊತೆಗೆ ಬಂದಿರೋ ಕೇಸ್ ಯಾವುದು?
ಅದು ನಂದು, ಅದಲ್ಲ ನಾನು petitioner. So ಇದಲ್ಲ
ಇಷ್ಟೊಂದು ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಹಸ್ಬೆಂಡ್ ವೈಫಾ?
ಹಾ.
ಎಸ್. ಹಂಗಾರೆ ಕಡಿಮೆ ಆಯ್ತು.
ಫೈಲ್ ಮಾಡಿದ್ದು. ಸೊ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಮತ್ತೆ ಸೈಟೇಷನ್ಸ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ವಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೈಟೇಷನ್ ಸಪೋರ್ಟಿಂಗ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದೀವಿ. ಸೊ ಏನಂದ್ರೆ ಈಗ 4
ತಾನೇ ವೈಫ್ ನಿಮಗೆ ತುಂಬಾ ಹೊಡೆದ್ಬಿಟ್ರು ಅಂತ ಹೇಳಿದ್ದು?
ಇಲ್ಲ, ಸ್ಟೇರ್ ಕೇಸ್ ಇಂದ ತಳಿ
ಸ್ಟೇರ್ ಕೇಸ್ ಇಂದ ವೈಫ್ ತಳ್ಬಿಟ್ರು ನಿಮ್ನ.
ಸಾಕು. ಸೊ ಈಗ 480/12 ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಪೆಟಿಷನ್ ನ. ಸೊ ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ವೆಂಕಟರಮಣ ರೆಡ್ಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ So High Court may refuse to exercise the discretion if the party has not approached it with the clean hands. ಈಗ ಪೆಟಿಷನ್ ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿದ್ರೆ 131 ಪೇಜಸ್ ಇದೆ. ಅವ್ರು ಕೋರ್ಟಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಬರೀ 26 ಪೇಜಸ್. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದಾರೆ, ಇಂಟ್ರಿಮ್ ಮತ್ತೆ ಫೈನಲ್ ರಿಲೀಫ್ ನ ಕೇಳ್ತಾ ಇದಾರೆ. ಸೊ ಅವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಈ ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಏನೇ ನಿಜ ಇದೆ ಎಲ್ಲ ಕೋರ್ಟ್ ಹತ್ರ ಹೈಡ್ ಮಾಡ್ಬಿಟ್ಟು ಸುಳ್ಳಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ಸೊ ಐ ಆರ್ಡರ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
ಯಾರು ಸುಳ್ಳಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡಿರೋದು?
ಪೆಟಿಷನರ್
ಯಾರು? ಅಶ್ವಿನ್.
I appear for the
ಅವ್ರು ಆಬ್ಸೆಂಟ್ ಮೈಲರ್ ಸ್ಟೇ ಹಿಯರಿಂಗ್ ದಿನ ಬಂದಿದ್ರು,
ಆಮೇಲೆ ಬಂದೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಫುಲ್ ಆಬ್ಸೆಂಟ್. 3 ಹಿಯರಿಂಗ್ ಆಯ್ತು, 3 ಹಿಯರಿಂಗ್ ಆಬ್ಸೆಂಟ್ ಇದ್ದಾರೆ.
ಎಸ್.
ಸೊ ಈ ತರ ಮಲ್ಟಿಪಲ್ ಸೈಟೇಷನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ವಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ,
ರಾಮಕೃಷ್ಣ ಯಾರು?
ನನ್ನ ತಂದೆ.
ಅವರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಒಂದು ಯಾವ್ದು?
ಅವರು ಈಗ ಅಡ್ವೊಕೇಟ್ ಬಂದಿದ್ದಾರೆ, ಆನ್ಲೈನ್
ಬಂದಿದ್ದಾರೆ. ಇಲ್ಲ ಫ್ಯಾಮಿಲಿ ಪೂರ್ತಿ ಪಾರ್ಟಿ.
86.2 my lord. That's the against in-laws.
What would be the situation? Wife party in person, husband party in person, father-in-law party in person.
and I appear for the father-in-law and all the in-laws.
Thank God. Yes.
ಮೈಲಾಡಿ ಕೇಸ್ ಬಂದ್ಬಿಟ್ಟು ಅವರು ಕಂಪ್ಲೀಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತರದಂಗೆ ಕೋರ್ಟ್ ಸುಳ್ಳು ಹೇಳಿ ಸ್ಟೇ ತಗೊಂಡಿರೋದ್ರಿಂದ ಸ್ಟೇ ವೆಕೇಟ್ ಮಾಡ್ಬೇಕಂತ ಕೇಳ್ಕೊಂತೀನಿ. ಯಾಕಂದ್ರೆ ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಈ ತರ ಬಂದ್ರೇನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು, ನೋಡ್ಲೇಬಾರ್ದು ಅಂತಾರೆ.
ಆಯ್ತು, ನಿಮ್ಮ ಕಳಕಳಿಯ ಮನವಿಯನ್ನು ಮುಂದಿನ ದಿನ ತೀರ್ಮಾನ ಮಾಡುವ.
ಶಾರ್ಟ್ ಡೇಟ್
ಎಸ್. ಲಿಸ್ಟ್ ಆನ್ 8ನೇ ತಾರೀಕು ಹಾಕಿ. 9.
My lord one submission. 86.2 ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅಂತ ಇದೆ, ಬಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ರೆಫರ್ಡ್ ಮಾಡಿದ ಮ್ಯಾಟರ್ ಇದು. we filed ವಿದ್ಯಾ. ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಸರಿ ಹಾಕಿ ಮೇಡಮ್.
ದಟ್ ಟು ಬಿ ಶೋನ್.
230 ಮೈ ಲಾರ್ಡ್.
230 ಬನ್ನಿ ತಗೊಳ್ಳುವ, ಬನ್ನಿ. Monday, fresh matters. Yes. 6th. Next.
88.
Next 2 weeks. Next. 89, Samir.
89, your lordships, by virtue of your lordships order dated 25/4/2026, had stated that if they don't make a clarification, your lordships will be constrained to pass an interim order. Now the wife has filed 3 separate proceedings, 1 in Tirur and 2 in Mysore, asking for the same relief. I'll just produce this. Now it is with regard to this that your lordship had stated that they have to clarify.
Just a moment. 7th in the fresh matters list. Yes.
90.
2 weeks. Yes.
91.
Remote idea. 6th fresh matters.
92. Fresh law.
6th fresh matters.
Order
ಇಲ್ಲ, ಅದಕ್ಕೆ ಹಾಕ್ತಾ ಇದ್ದೀನಿ. 6th fresh matters. Next.
93.
Appearing for the petition in this matter, your lordship.
Oh, the Supreme Court has directed.
Yes, my lord. Yes, my lord.
When do we take it?
Any date convenient to your lordship.
Monday, my lord, if it suits my lord.
Monday, the 300. Monday difficult, sir.
Wednesday, my lord.
Can I post it on 6th so that matters are less on 6th? I can take
6th,
this.
please, my lord. 6th.
6th will take it up, post it at 3:30 antane haki. 6th at 3:30. Please file synopsis in each of the case. Last time I told you, have you done it?
Ready, your lordship.
Then file it.
We'll file it.
Oh, you should not disclose your arguments anta.
No,
Then
we'll get it filed.
file it, give a copy to them. ಇದ್ರಲ್ಲಿ ಏನು ಹಾಕಿಲ್ಲ ತಾನೆ? Prosecution complaint ಆಗೋಗಿದ್ಯಾ?
We have not received any copy that
See,
they have filed, your lordship.
Without giving a copy, how did you file a prosecution complaint?
My lords,
Huh?
fill the copy on the last hearing itself.
Yes, on.
Give him a hard copy.
Please give. Yes, we'll take it on 6th at 3:30. By then, even if fresh matters is mukste, we'll take it positively because of Supreme Court's direction. Yes.
May I only request, my lord, if it may be reflected in the order at 3:30, because sometimes, my lord,
it will be the heard so and so ella haki. List the matter on 6th at 3:30 p.m.
Yes, my lord.
Or same caption only. For admission.
Because
3:30 p.m. Sir. Yes.
Deeply obliged. Deeply obliged.
Yes.
94. Petitioner, your lordship.
Want to withdraw?
No.
Then what's that?
This is counterblast FIR case in which our
Counterblast FIR case.
ನಮ್ಮ FIR ಅಲ್ಲಿ ನಾವು ಹಾಕಿರೋದು FIR ಅಲ್ಲಿ ಅವರು ಅಕ್ಯೂಸ್ ಪ್ಲೀ ಗಿಲ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಲಾರ್ಡ್ಶಿಪ್.
ಈಗ ನಿಮ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ನಮ್ದು ಸ್ಟೇ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್. The petition can be allowed.
Allowed?
Yes, your lordship.
Why?
First ನಾವು FIR ಹಾಕಿರೋದ್ ಮೇಲೆ ಅವರು
ಕಂಪ್ಲೇಂಟ್ ಬರ್ಲಿ ಮೇಡಮ್. Yes. ಯಾವ್ದಿದು? Which serial number? 94. Joseph Anil Kumar,
Yes, Your Lordship.
you are his colleague.
Yes, Your Lordship.
Yes, we'll take it on,
I'm producing the audit sheet.
you file it in the registry, it will come. List on 8th. We'll close it on 8 because there is already a council. Yes.
95, one submission, Lords. We were not informed about the adjournment sought at 1:30.
Somebody
Yes.
sorted
Please,
Jan,
Lords.
1:30.
Date may kindly be given, my Lords, as an interim order.
You were in VCA?
No, the
Alla
other
avaru.
side, any date 2 week hence, 2
We'll
weeks. hence.
see. What's the matter?
498A, my Lords, was filed, FIR. Thereafter, the mother-in-law commits
Oh, yes,
suicide.
who sought time in this?
The respondent to it's a 95.1.
Mohan Kumar, list the matter on 8th.
Please.
List the matter on 8th under the cap, vacating stay ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಲ್ಲ?
We are due to
Would your
file today.
lordship have it anytime after 13th or 14th?
ನೀವು ಯಾರಿಗೆ ಸರ್?
I am for the petitioner in 95.1, Mohan Kumar's colleague.
Oh, you are Mohan Kumar's colleague.
Ali,
ಆಯ್ತು, when do you want?
Wakalat is filed after 12th or 13th.
List the matter on 14th. 14th for admission. Interim order subsisting would continue till the next date of hearing. Yes.
Your Lordship, short point, my Lords. The trial court has stayed its own proceedings in lieu of moratorium imposed against a personal guarantor, my Lords. The Supreme Court has held that moratorium is only applicable to the corporate debtor.
Correct.
And
That-
not the
Let's see,
guarantor.
this 96 then post it on 30th in the fresh matters list. Yes. First time ಬರ್ತಾ ಇರೋದಲ್ಲ?
ಇಲ್ಲ, my Lords, 4 ಸಲ ಬಂದಿದೆ.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
Notice ಆಗಿದೆ, but 3 days ಹೋಗಿದೆ.
ನನ್ ಮುಂದೆ ಬರ್ತಾ ಇರೋದು ಫಸ್ಟ್ ಟೈಮ್.
ಇಲ್ಲ, ನಿಮ್ಮ ಮುಂದೆನೂ 3 ಸಲ
ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ, my Lords. ನೀವು
ಆಯ್ತು,
fresh
ಸರಿ.
matter ಗೆ ಇಲ್ಲಿ ಹಾಕಕ್ಕೆ ಹೇಳ್ತಾ
We'll
ಇದ್ದೀರಾ?
see, we'll take it in the fresh matters list on 30th. 2 weeks.
For the response, already I filed a vacating stay application.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ sir, 19th.
Registry to list the matter on 14th under the caption interlocutory applications. Yes, next.
Mas-
2 weeks. Yes. 6th, yes. Bakery.
KP Act proceedings, my lord.
Again KP Act. ಮುಂದೆ ಬೇಕರಿ ಹಿಂದೆ ಮಟ್ಕ.
My lord,
Yes.
in 2 matters, my lord, the honorable magistrate has endorsed as permitted.
We'll see, sir. Yes. 14th, next.
In the fresh matters.
All 3, yes, all 3.
103.
Sunil Kumar.
The fresh matter, my Lords. Interim order.
6th. ಎಲ್ಲಿದೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್? ನೋಡಿ ಆಗ್ಲೇ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ, my lords, last date of hearing, my lords, your lordship is about to grant an interim order, my lords.
ಕೊಟ್ಟಿದ್ದೀನಾ?
No, my lord, Jagdish sir, opposite, we have to see the papers, investigation papers.
ಆಯ್ತು. 6th fresh matters, next.
104, fresh law.
6th, yes.
Appearing for petitioner, my lord.
6th fresh matters. Split up ಯಾವ್ದು ಮೇಡಮ್?
Split up ಇದೆ.
ಯಾವ್ದು, which matter?
106, 5,
106.
2011.
106 list on 7th.
105 also split up case, my lord.
105, 106.
Interim order is in.
ಒಂದು ನಿಮಿಷ. List on 7th, interim order will continue. ಅವತ್ತು ಮುಗಿಸ್ಕೊಂಡು.
105 ಅಲ್ಲಿ entry ಮಾಡಿಲ್ಲ. Split up case.
ಅವತ್ತು ಮುಗಿಸೋಣ.
Please.
Yes. 106 split.
104.
104 and 105 post it on 7th. 106 2 weeks, next. 2 weeks. 6th fresh matters.
107 split up case.
107 split. ಹಾಗಾದ್ರೆ 7th, next. Withdrawal, yes.
109 split up case.
Split up, 7th fresh matters. ಸಾಕು ಮೇಡಮ್. ಏನಿದೆ? Interim orders continue, yes. PP ಕಿಟ್ ಯಾವತ್ತೋ ಒಂದಿನ ಹಾಕಿ.
Under 138 of NI Act, 111 you're on.
100, I'm at 110, madam.
Sorry.
Wait, yes. Wait, yes.
111, fresh matter, my lord. Under
Then-
138 of NI Act, the recalling application was rejected for cross-examination of
Then list on 7th,
interim
fresh
order.
matters. Interim order ಇದೆಯಾ?
ಇಲ್ಲ, ಆಗ್ಬೇಕು ಅದು.
ಅವತ್ತು
Fresh matter
ಕೊಡುವ.
ಅಲ್ಲ, ಇವಾಗ
ಅವತ್
more further evidence of accused, their honor.
ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. We'll grant on that day.
Till next date, my lord, kindly. Till next.
311 application ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
311 application was filed on 10/6.
ಎಷ್ಟನೇ application?
It is third application. I do
Yes,
understand.
list
your
on
lordship, there
7th. Let the respondent come. Petitioner to serve on the council representing the respondent in the trial proceedings and file an acknowledgement 7th in the fresh matters list. Next. Anandram. 6th fresh matters.
This is a matter which should be covered by decision. PMLA matter without cognizance taken. I think it's
Parvinder
covered.
Singh.
Oh, Parvinder Singh and
Aitu
Kushal.
113, then we'll take it 7th.
Oh.
7th fresh matters.
Interim order, my lords, because we have served copies on them. It's covered by decision itself.
It may be taken up, my lords, for
Then we'll take it on Tuesday in the fresh matters list.
Tuesday, my lords.
Avadu kalisponna.
Although on merits also we have a good case, we will do it
Adamali,
there. I'll marty.
Come back.
Yes, my
Yes. Anyway, you will come back. Yes. 2 weeks. 6th fresh matters. Same.
That's 113 in fresh matters, my lords.
Fresh
on
matters.
Tuesday it's covered.
2 weeks.
ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ವಿ ಇದು
ಯಾವ್ದ್ರಲ್ಲಿ
117 ಅಲ್ಲಿ
ಏನಾಗಿದೆ ಸರ್?
ಜಪಾನ್ ಹೋಗ್ಬೇಕು ಪ್ರೋಗ್ರಾಮ್ ಇತ್ತು ಅಂತ
ಜಪಾನ್ಗೆ ಹೋಗ್ಬೇಕಾ?
ಸಿಂಗಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್
ಯಾಕೆ?
ಸಿಂಗರ್
ಸಿಂಗಲ್ಲ?
ಸಿಂಗರ್
ಸಿಂಗರ್? ಯಾವ ಕಾನ್ಸರ್ಟ್ ಇನ್ ಜಪಾನ್?
ಪ್ರೋಗ್ರಾಮ್
Program. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ ಮಿಲೋದ್
Melody, 117, Melody, I appear for the respondent.
You don't want him to sing? ಅವ್ರು ಹಾಡೋದ್ ಬೇಡವಾ?
Melody, it is WP number 23-233, Melody.
ಅಯ್ಯೋ ಹೌದು ಸರ್. Yes.
Melody, he is the grandfather, Melody. He is the grandfather against whom the complaint is filed, Melody.
One ನಿಮಿಷ. One ನಿಮಿಷ ಸರ್. Grandfather wants to sing. Grandfather wants to sing.
ಫಾದರ್ ಇನ್ ಲಾ.
Who is that audience is wanting to listen?
ಮಳವಳ್ಳಿ ಮಾದೇಸ್ವಾಮಿ ಅಂತ ಅವರು ಇದ್ರಲ್ಲಿ ಅವ್ರ ಫಾದರ್ ಇನ್ ಲಾ ಬೈಗಮಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ ಅವ್ರು ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದ್ರಲ್ಲಿ ಫಾದರ್ ಇನ್ ಲಾ ಪಾತ್ರ ಇಲ್ಲ.
Melody, it is 498A.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಜಪಾನ್ಗೆ ಯಾರು ಹೋಗ್ಬೇಕು? ಹಸ್ಬೆಂಡ್ ಫಾದರ್ ಇನ್ ಲಾನ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್?
ಫಾದರ್ ಇನ್ ಲಾಸ್.
ಫಾದರ್ ಇನ್ ಲಾಸ್.
ಫಾದರ್ ಇನ್ ಲಾ ಮೇಲೆ ಪಿಟಿಷನರ್.
ಎಷ್ಟು ವರ್ಷ ನಿಮ್ಗೆ?
ಇವಾಗ 70 ಮಿನಿಟ್ಸ್.
ಏನ್ ಹಾಡು ಹೇಳ್ತೀರಾ ಸರ್ ಈಗ?
ಇಲ್ಲ ಅದು
ಸಿಂಗರ್.
ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಹಾಕು.
ಇರ್ಲಿ ನೋಡೋಣ. ಎಸ್ ಲಿಸ್ಟ್.
ನಾಳೆ ಬೇಕು.
ನಾಳೆನೇ ಟಿಕೆಟ್ ಇದೆಯಾ?
ನಾಳೆ
ಯಾವತ್ತು ಇರೋದು ನಿಮ್ ಪ್ರೋಗ್ರಾಮ್?
ಡಿಸೈಡ್ ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಿ ಆಗ್ಬೇಕಾಗಿತ್ತು ಮತ್ತೆ.
ನೀವು ಹೇಳ್ದಾಗ ಪ್ರೋಗ್ರಾಮ್?
ಇಲ್ಲ ಮೀನ್ಸ್ ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು. ಅದಕ್ಕೆ
ಇನ್ವಿಟೇಷನ್ ಎಲ್ಲಿದೆ? ಜಪಾನ್
ಕೊಡ್ತೀನಿ.
ಎಲ್ಲ ಕೊಡಿ.
ಎಲ್ಲ ಕೊಡಿ.
ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕಿ. Will say, what do you sing?
Folk singer.
Folk.
Please.
118. Let's appear for petitioner. My lords, there is no stay. My lords, offense.
No stay. No stay.
My lords, offense is under section 12 of.
ನಾನೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು. ಎಸ್.
My lords.
2 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡೋಣ. ಎಸ್.
My lords, date may be fixed. My lord.
2 weeks.
My lords, in fresh matter. My lords.
15th ಸರ್.
Great.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಹಾಕಲ್ಲ. ನೋಟಿಸ್ ನಾನೇ ಮಾಡಿರೋದು. ಹಿಟ್ಸ್ ಮ್ಯೂಸಿಕ್.
Further hearing 128, 127 dictating orders.
Dictating orders. Yes, sir.
Apologies, Lord.
Missing file. ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬಿಡಿ ಇದರಲ್ಲಿ. ರಿಸರ್ವ್ ಮಾಡಿ ಆರ್ಡರ್.
ಪೇಪರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಇವರಲ್ಲ. ಮೈ ಲಾರ್ಡ್.
You file a synopsis at 9. We'll take it on 8th. Yes. By then you file.
I will file it tomorrow. Please.
Apologies, my lord. In serial number 116, I'm the counsel for the petitioner and I couldn't hear the serial number being called out. I'm just seeking a date for the next week, if possible.
Thank you. Yes.
Thank you.
128.
This is a hits music matter.
What to hits music? ಎಲ್ಲಿ ರೋಡ್ ಬಿಟ್ರಾ?
Whole contention is purely of a commercial dispute, suits pending between the
Where is he?
parties.
My lord said. My lord, on the last occasion.
ದಿನ ಬರ್ತಾ ಇದೆ, ನನಗೂ ಟೈಮ್ ಆಗ್ತಾ ಇಲ್ಲ ತೊಗೊಳಕ್ಕೆ. ಇಟ್ಸ್ ಫಾರ್ ದ ಹಿಯರಿಂಗ್. I'll reserve it and write, but ಇದು ಹಾಕಿದ್ದೀರಾ?
Yes, madam. I'll give a synopsis.
ನೀವು?
Also. I'll give it.
Let's we haven't filed a synopsis yet.
File, madam.
File a synopsis, even if it's going to be reserved, madam.
ಬೇಡ, ಇಟ್ಸ್ ಆಲ್ರೆಡಿ ಪೈಲ್ಡ್ ಅಪ್. ತುಂಬಾ ಆಗಿದೆ. ಇನ್ನು ಅಷ್ಟೊಂದೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡಿಕೊಟ್ರೆ ನಾವು ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? In every case, it's like this. What to do?
Some matters are interesting, my lord.
Everyone is interesting. I'm not saying they're not interesting. Everyone is complicated and interesting. So you can't just like that write it off. We'll see. Then Tuesday ಹಾಕಿರಿ ಅಷ್ಟರಲ್ಲಿ ಒಂದು ಸಿನಾಪ್ಸಿಸ್.
Yes, madam.
ಅವತ್ತು ನಾನು ಮಾಡ್ಬಿಟ್ಟು ಮಾಡಿ. ಇವಣ್ಣ ಏನಿದು?
129.
heard the learned senior counsel ಅಂತೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು list on Tuesday in same stage early,
Yes.
we'll take it.
The
Yes.
interim orders to-
That will continue, sir.
29 and 130, my lords.
ಏನದು?
Section 69 interlocutory
Ah,
application.
ಇದೆ, I was searching ಎಲ್ಲಿದೆ ಮ್ಯಾಟರ್ಗಳಿದು ಅಂತ.
And interestingly, my lords, the respondent number 2 has filed their objections to our application, but in support of our application to pass necessary guidelines.
ಅಲ್ಲ, this is necessary, this is really necessary.
Not filed objection on the merits of the matter.
I'll do it, yes, yes. 129, 130, madam ಇದನ್ನ 10th ಹಾಕಿರಿ. 10th in the release the matter from the status of being parted, post them in the fresh matters list. ಅವಾಗ I'll get hold of it.
131.
Interim orders.
Interim order ಇದೆಯಾ? Interim order will continue, sir. ನಿಮ್ದು interim order ಇದೆಯಾ?
Oblige.
ಏನಿದು?
Lord, sir. Malleshwaram, my lord, sir.
Huh?
Malleshwaram, my lord.
Oh, ಅದಾ? Police quarters, all right, yes.
I appear in 132. my lord.
We'll take it. 15th,
Please, please, please.
yes. 130,
132.
132 similar matter.
same. 133 ಆಯ್ತಲ್ಲ?
137.
This is a matter, my lords, pertaining to matter remanded by the Honorable Supreme Court.
CBI.
Please, my lords. CID to CBI, seeking investigation.
ಆಯ್ತು, ಯಾವ ತರ ಹಾಕೋಣ ನೋಡು.
Date may be fixed, my lords.
It will be fixed, sir. Madam, ಇದು 17th ಹಾಕಿರಿ. 17th at 3:30 PM.
Also, my lords, I had filed NOC wakalat, my name may be reflected, my lords.
What's your name?
Mithwan.
So and so submits that is entered appearance in place of Gaurav, is it?
Please, my
So
lords.
and so, registry to print the name of so and so is appearing for the petitioner.
Serial number 45, passed over.
Passed over. Where are you, sir?
Application is filed, my lord.
Hmm.
Taking time of 3 months, my lord, for completing the
Inquiry.
Please. Article of charges has been issued, my lord.
Hmm.
Now you have sought time to produce the documents.
45 ಅಲ್ಲಿ 45 ಅದು.
Please, my lord, 45.
The state has preferred this court, while disposing the petition, operative portion court ಮಾಡಿ, had directed certain actions to be taken by the state, qua the officer. The learned learned HCGP would submits that state has preferred an application seeking extension of time in the teeth of the fact that the inquiry could not be concluded within the time frame fixed by this court. The learned counsel would submit that the charge sheet, articles of charges are already served upon the officer, and the next date,
3/7/26.
the inquiry is fixed on 3/7/2026. ಎಷ್ಟು ದಿನ ಬೇಕು?
3 months, my lord.
Therefore, the time that is granted in terms of the order quoted supra stands extended by another 3 months from today. All other directions would remain intact.
My lord's permission, in serial number 137, my lords, may I request for a shorter date, my lords, kindly.
10th.
Investigate.
10th.
Great. Much of it.
Yes, Rajat, ಏನು?
That community service matter, my lords. Green Lamborghini.
ಇವತ್ತು ಬಂದಿಲ್ಲಲ್ಲ?
Please.
Oh, such.
Please.